a contractor who has been wrongly penalized for no fault of him, and there has been a derailment which is attributable to private respondent number 5. But entire punitive amount has been imposed upon me, and they have started deducting from my security deposit. My lordship has heard this matter, and I have served notice upon all. Everybody appeared except private respondent number 5. Lordship has specifically directed to effect service upon all the parties again, and I have done so. But still, my item is item 234, my lord. Any day my contract will be collapsing, my lord, because they have
234.
234 of the monthly combined list. my lord.
Monthly list.
It is appearing under heading urgent matters. And I have served notice upon everybody. My lord, my only prayer, let it be upgraded, my lord, the daily list, so that it can be heard, my lord. This is my only prayer, my lord.
That is the only prayer of the all advocates. All advocates are upgraded urgent
My lord,
hearing.
this has some urgency because it has already been demonstrated and lordship has appreciated that. Great.
Permitted, my lord, to seek
एक काम
Paragraph 6.
एक काम करो, आज कितना 17 है, कितना तारीख है? 8-10 तारीख है ना, 13 तारीख को रखो, 13 तारीख को रखो 10 मैटर में.
permitted, my lord, to seek for a leave, my lord, to move this matter, my lord, urgently.
But are unlisted?
Unlisted, my lord.
What is the
Unlisted, my lord, tomorrow, my lord, your lordship's, my lord, convenience.
what is the urgency?
Yes, my lord. The urgency is, my lord, the online record of the birth certificate of the petitioner, my lord, has been deleted. Now, my lord, the petitioner has obtained a government service. It's in the process of verification of documents, my lord. I've submitted my online, my lord, the birth certificate that I previously got. But, my lord, they are willing, my lord, to verify it, my lord, from the online portal, my lord, of the maintained, my lord, by the West Bengal government, my lord. Unless, my lord, the verification stage is already going on, my lord, I, my lord, secured my service.
What verification?
Verification of, my lord, the documents that I submit.
For what
Birth
purpose?
certificate. The birth certificate verification.
Birth certificate is okay. For what is the urgency? Birth certificate might be
No, my
after
lord,
2 months, after
my
3
lord,
months.
verification stage is going on, my lord. I've already secured, my lord,
For
government.
what verification, sir?
My lord, government
For
service.
what purpose?
My lord, I have already secured, my lord, government service, my lord, in the department of, my lord, my lord, my lord, I've already, my lord, I'll just indicate.
You don't know when you which department your client has got appointment. You are moving the urgent.
My lord, Department of Textiles, my lord, of the government of West Bengal.
When you got the appointment letter?
Appointment letter, my lord, I am yet to receive.
When you were selected?
Was selected, my lord, in the month of February, my lord.
Then,
my lord,
in the month of February selected, and now you are August, you are asking for the birth certificate.
My lord, verification is going on right now, my lord. My lord, my lord, I have, my lord, submitted my documents. It's in the stage of verification right now, my lord.
So you don't know, you don't have the birth certificate in February itself, and you August, the last moment you are coming, flag end of the verification, you are coming to the court. There is an urgency.
My lord, kindly consider, my lord. My lord,
no, consider the court has to see the conduct of the party.
My lord,
you got the appointment order or selected in February, and you slept over the matter, and now the verification is going. Now, last moment you are coming to the court. There is an urgency.
My lord, not the appointment letter, my lord. My lord, the list was published in February. My
That's why list was published. You could have been get all the document ready by this by the 6 months. Now you are coming in the last week of the.
My lord, it is not, my lord, available in the offline mode, my lord. Online mode, my lord. That was, my lord, that was, my lord, not known to, my lord, to any of the parties, my lord. My lord, kindly consider, my lord.
Whatever the mentioning list give, I will see to it. Unlisted, I will hear with regard to the mentioning for upgradation. Give the mentioning list to my court officer. I will see to that. I will not hear each and every. Whatever the you give, whatever the mention list, give to reason for mentioning, give in the your mentioning list, I will consider that. It is not possible in this court to hear all the persons one by one in the mentioning. You give the mentioning list, I will see to that.
For correction, my lord.
Give the correction, I will mention the correction, see to that. Give whatever the mention. I will not hear mentioning. Give the mentioning list. I will see to that.
No, first August, directed this matter.
Give mentioning list. I will see. I will not hear any persons with regard to the mentioning. Only I will take the mentioning of the unlisted motion. So why you are not mentioned? It is not in the list.
It is item number 103.
It is in the list. Come up at the time of rising of the court.
No,
I will not allow. Leave. What is a leave? Only leave I will hear. Otherwise, I will not hear.
Mention a leave here.
What is a leave?
Your Lordship, 13 is the NEET counseling process. You know
Yes.
very well. On 13th August is the NEET counseling process. You know very well. Such, such as domicile certificates and CA category and the certificate also.
So what the court will do?
Lordship, the council has issued.
It will do only I can pass an order directing the
Yes.
upset authority.
Yes,
I
Lordship.
cannot pass an order to give admission in the NEET.
No, your Lordship kindly matter and pass the orders so that the petitioner can go to.
कल का जो है ना SIR लिस्ट में रख दो कल SIR लिस्ट में कर दो
My lord, may I permit?
Yes, any unlisted?
My lord, may I permit to mention a leave, my lord? My lord, these are the similar matter.
I can't hear you.
My lord, this is the similar matter, my lord, about NEET counseling, my lord.
I'm mentioning only one thing, Lord.
Expiring today, item number 79, my lord.
Come at the time vector.
I'll at the time pricing, I'll come. I'm here to the party.
Give what mentioning give the list.
Lordship,
Give
under
the
the
unlisted. Where is the petition? Why there is no unlisted? Once the writ petition is filed, there is a non-listed.
Lordship, mentioning under complaint situation, Lordship.
Give whatever the mentioning list.
No, Lordship,
Give.
Kindly, my lord, may I have your lordship? My lord, serial number. My lord, have mentioned before your lordship, my lord, on the earlier 4 times before your lordship, my lord, the matter is not come, my lord.
Give the mentioning list, I will see urgency.
your Lordship,
If
first of order,
you able to mention the urgency, I satisfied, then I will
your Lordship,
give the mentioning.
Lordship mentioning under complaint situation, Lordship. Your Lordship have passed order dated 15 July. This matter is come within the 10 items, but it is till now last 3 days beyond the 10 items.
Okay.
Kindly fix the matter today, Lordship.
Mention an urgent tender matter.
What is emergency?
The urgency is, my lord, I have set up an infrastructure, a tender is being delayed for no reason, my lord. CIL has passed an order saying that tenders should be processed within a particular time frame. PCNS, the product is dust ionizer required for safety of the miners, my lord. The PCL is inordinately delaying the process. I just want a direction that the tender should be processed. That is it, my lord. I am not asking for anything else, my lord.
उसको परसों रखो.
Lordship, time the matter.
May I request for Thursday, because the Asansol, the authorities are in.
Lordship, kindly fix the matter to the Lordship.
My lord, I'm requesting. My lord, may I request for Thursday, because the authorities are in Asansol.
13 को कर.
Lordship,
13 within 10 matters.
Lordship, kindly. Lordship, kindly.
Give all the mentioning list. You are not understanding. Give the mentioning list. Yes, call the list.
Have your lordship kindly to mention that? My lord, for the,
Today, Lordship.
my lord, for the 4th time this matter, I am mentioning just for 30 seconds. Use of modification of your lordship, so just for 30 seconds, the petitioner has suffered. For the 4th time I am mentioning.
My lord, this is appearing at my instance for extension of interim order.
Where you are coming?
The interim order was granted till today, your lordship. Lordship will kindly
It is
extend.
not in the list.
My lord.
It is not in the list. If the interim order is still today, the interim matter is not in the list. So why you not mention Friday, Thursday, all the parties that see, all the mentioning, why you not mention
1 and 2, my lord.
today?
Yes, my lord.
So item number 1 is called.
Yes, that is I'm appearing.
So you are telling a mentioning.
No, my lord. Item number 1 and 2 was called, my lord.
For the petition, you are for the petition.
And for the petitioner, my lord. My lord, it is appearing at my instance. The interim order granted earlier is till 10th today, my lord. I'm praying for an extension, lordship. This is the hemoglobin meter matter, my lord. Lordship will recall. My lord,
Which order the interim order was
yes,
granted?
my lord. My lord will kindly take up order dated 10th of July 2026, lordship.
Yes.
Yes, my lord. My lord, it was extended till 10th of August. It is expiring today, lordship. I'm praying for extension, my lord.
The report is not submitted by the
Not
date.
yet, my lord. We have been in touch with AIMS New Delhi. As of now, lordship, they have not given us any update on it. We are not sure whether the report is ready or not. Possibly not, my lord.
The matrix list has to be mentioned for the extension of interim order. Counsel for the petition submit that the interim order is till today and paid for extension of interim order. Consider the submission made by the counsel for the petitioner. The interim order is extended till 11th of September 2026 or until further order which is decided.
I'm deeply obliged, my lord.
Yes.
Obliged, my lord.
Next.
Item number 3, Lordship, I am for the petitioner, Lordship.
Yes.
The application for extension, Lordship, on the last occasion, Lordship were pleased to direct the filing of the affidavit of opposition. No opposition has yet been filed. Tomorrow, the interim order is expiring, Lordship.
Who is for the other side? Have you issued notice?
I have served the university by hand service.
No, mentioning notice you have served. Where is the mentioning notice? Have you served the other side?
I have served, Lordship. The affidavit of service could not be made ready yet because on Friday, Lordship, it has been served. That is the reason I couldn't just. I will in the due course of the day I'll file it.
The mat. Why it is mentioned? It is already 10th of August. Let the matter appear on 10th August. So
It never came
why
up.
it is mentioned? The
Lordship,
the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted by an order dated 30th June 2026. The court directed filed an order for filing affidavit in opposition, but till date no affidavit in opposition is received. She submitted interim order is till 11th of August 2026 and paid for extension of interim order. None appears on behalf of the respondents. Land counsel for the petitioner, interim order is extended till 11th of September 2026 or until further order, whichever is earlier. Can number 1 of 2026 is disposed of. Next.
deeply obliged.
Lordship, item number 4, Lordship, my instant matter was mentioned, Lordship.
Yes, Vaika, what is the correction?
Name of the state advocate was wrongly appeared, Lordship. I am appearing on that day, but wrongly. Sudeepa Banerjee name was appear, but it was allotted to me. Only correction of the name of the state advocate, Lordship.
Yes. Yes, anything?
Your lordship, for the petition, no, your lordship.
The matter is listed as to be mentioned on the prayer made by the counsel for the petition state respondent. Then counsel for the state respondent submit that in the order dated 5th August 2026, the name of the state respondent is recorded as Miss Sudeepa Banerjee, but she is not appeared in the matter, and he submitted so and so appearing in the matter. In view of this submission, in the order dated 5th August 2026, the name of the advocate for the state shall be read at so and so instead of Sudeepa Banerjee. This order be read with the order dated 5th August 2026.
Highly grateful, your lordship.
Next.
This is the order passed by the Honorable Division Bench.
Yes.
But my lord's order was modified to the extent that the new rates will be applicable to the existing contract. But so far as the new tender, this is the order.
It is here.
It is there.
Order dated 4th August.
My lord.
Understood, Sangha. Impugning order is modified with the direction that the earlier order of his lordship passed WPA number shall be complied with, and with the further direction, the formalities of preparation of the bid document can be completed by the state, but the tender notice shall not be published. The order. The hearing of both the matters brought forward. Yes.
But what my lord has not granted in my favor, that the existing Division Bench has granted that. This is the summary substance of this is the exception, my lord. My lord, the new deed application has been filed and my learned friend mentioned this matter. Your lordship was of the opinion that when the matter will be taken up, it will be tagged with that matter. May I hand over the slip of that matter? This number there.
Yes, who is on the other side?
here. In the exception, my lord, I have taken the point which are the anomalies, which will argue in the main read also.
Nobody is there.
Then kindly keep it along with that matter any day suits, my lord.
I beg to appear for this state, my lord. We have served them with the supplementary affidavit before the division bench. It is recorded in the division bench.
Yeah, they have filed the exception.
Exception.
They have filed the exception.
Lord, this is a supplementary affidavit. They were supposed to give us, Lord, in advance. That's the order of the revision bench.
Yes.
Lord. Lord, as per the order of the division bench, my lord comes to page 12. Exceptions to the same shall be filed within 10th August and the matter shall appear on 10th. So I'm getting it today.
Yes.
So I need to go through this, Lord, what they are filing it. If say tomorrow I'll go through and come back.
No, my lord, may I know my understanding is appearing in that read? Then, my lord, both the matters can I take it?
Both the matters are appearing today.
Read file kori dilo.
They have
No,
filed
no,
another.
that I do not know, Lord.
Have you served?
Yes, yes.
That I do not know.
अब है नहीं. File kori. Only is filed.
Not served.
Today, my lord, if you lordship leave, may I serve today?
Served.
Lord, one after another matters are being filed every day.
That is for the benefit of the bar, I think. My lord is not. My lord will be annoyed because filing the matters, but we are happy.
The respondent number 124 filed their supplementary affidavit.
কি আনন্দে?
তো কাল না রেখে তাহলে
WPA
কবে
number
রাখবো? সেটা বলো, তারপরে গাড়ি
2914
আছে।
of
একটু নাম্বারটা
2022.
দে।
চব্বিশ সঙ্গে তো যোগাযোগ করার প্রয়োজন মনে করো না। এটা instruction ই দাও, বলে
The
রাখো।
counsel for the petitioner has filed exception to the said supplementary affidavit,
Lord,
having the counsel for the state. Let the same be considered.
Lord, only one
Yes,
request. Lord, may I make this request, Lord?
yes.
Lord, today we are on. My lord, give me 2-3 days time. The advocate general is appearing. I need to take instruction for the department. This is 3-volume document. So if I,
Okay, in the meantime, you also serve the new petition, all the
Absolutely, sir.
it cannot be served on me. It has to be served on the government speaker office because if they allow us,
Master office, no,
so
nothing.
now it's functioning. Now it's functioning.
Nothing is doing.
Hey,
I have a good experience. Nothing is doing.
My lord, he
In
normally
spite
appears.
of my order, the government Peter office is taking and sending it to the pawn shop.
huh?
Lord, if
The writ petition is sending because the panel advocates are not getting. They are telling before that we are not received the.
Actually, we are
if
getting.
Mr. Chakraborty can accept it.
No, I can't. Lord, do not burden me with this. No?
My lord,
What can be done? You
Not
are
appearing.
appearing, you receive it.
Function.
I will regularize your appointment in that.
Lordship, I have filed an intervention application.
Now see, good.
And Lordship, let it
They have-
clear my.
In which matter you have filed the intervention? Which
Huh?
matter? Huh?
terms and conditions পুরো যেটা নতুন বেরিয়েছে
Which
সেটাই।
matter you filed the intervention?
6, my lord.
In both?
Lord, I believe my lord keeps it make Tuesday week. I will come back ready in all that.
You filed the
6. WPA 182.9.
কাগজগুলোর উপরে তুলে দিও না, এগুলো সব এত তোমাদের মামলার চাপ না এখানে, খুব ঝামেলা।
18829. That's the new writ petition.
আর কোনটা?
Who are you?
I'm one of the interveners, my lord.
Who are you?
Tenderer. He is also a tender like me.
Shall be affected if there is no increase in the rate, my lord.
Yes. Increase.
Increase. So they are fighting now against each other.
Not at all. Not at all.
In already increased.
Already increased.
Yeah.
Thing from 2018. Now, Lordship, there is.
Go to the damage suit. File the damage suit against Mr.
Mr.
No,
Well,
we have already.
Mr. Basu's client has been successfully installing the process for last 9
That's
years.
telling. Go and file the suit.
So they sir,
That's why for deciding for once I pass this direction.
absolutely not.
It will decide.
Because of your lordship's tender.
Only the lordship's signature is required.
The reason says unless your lordship allows the tenders on it. But may I just beseech your lordship?
This is one.
Lord,
keeps it on 18th of August, all the matters.
18
Next Tuesday,
18 August.
Tuesday week, কালকে Tuesday পরের week Tuesday. ও বাবা, 19, 19 তারিখ,
Subject to my lord's pleasure, 19.
আমাদের তো এখন তারা কিছু নেই, আমাদের তো এখন তারা কিছু নেই,
কি বলছি? File the,
আমাদের এখন তারা নেই।
Land counsel for the petitioner submit the petitioner has also
আর একটা
filed
নতুন
another writ application being WPA number
হ্যাঁ, আমাকে অ্যাপ্লিকেশন গুলো দাও,
being WPA number
কাকে করেছো, আমার কাছে আসেনি,
police
আমি কি করে
connected
নেবো
with
বলো?
the sit.
তোমার স্যার কোথায়?
Similar matter. According the petitioner is directed to solve the copy of the said application to the land advocate appearing for the estate in course of the day.
কেউ নেই বলে পাঠিয়ে
The day. Police of land council so and so so and so submit that he has also filed an application naam likhte na. She has also filed an application for intervening for intervening in the matter in WPA number 18829 of 2026 being CAN number. What is the CAN number?
Number is one.
Being CAN number 1 of 2026. Police. Considering submission made by the council for the police land council for the estate press for time to go through the record, go through the exception filed by the petitioner. Consider the submission made by the council for the respective parties. Let the matter appear on 19th of August 2026.
19th. Well, may I get the, this is my lord accepts that and the application file.
You
is
also serve the copy.
If we accept,
No, I cannot accept, if the, I cannot
I
accept.
told in course of the day serve to you.
Up to Mr. Chakraborty, very good.
No, not me, my lord, Mr.
So you-
Mondal, Mr. Mondal.
Yes,
Whatever it may be.
and
Mr.
regularize.
So the land advocate for the estate. কি বলছি?
Now he is the state.
Let the matter appear on 19th August.
The GP office is now regularized, my lord can trust us, it is regularized now.
My lord only knows you are state.
Who is appearing before me? I know them as
He
a
is the
state.
state.
Is the state. Because I will give the seven, even Friday. 3 matters.
To appear করেনি,
No, pay copy not served, but they are showing the GP receipt not a day, 10 days before, 1 week before. That's why I'm telling you.
It will take time.
Otherwise, 19th within 5 matters.
Application may be served upon us.
Lordship, Lord.
বল না আগে,
Amendment,
স্যার আপনি করি।
all connected matters, including the intervening application.
বল আমি খুঁজে দিচ্ছি। It is between us, subject to my lord's consent. 20th.
Already it was fixed on
20th.
20th earlier,
20th.
হ্যাঁ 20 তারিখ, ঘুরে ঘুরে 20 তারিখ,
Serve the copy to all.
Lordship.
in the, my lord, in the earlier order, my lord fixed it on 20th.
2 PM is there.
In the earlier order, my lord fixed the matters which was challenged with the division bench.
20th August, 2 PM है?
He already ছিল, দেখো ডায়েরিতে,
Slot দেখো আছে কিনা?
এর আগে তো এগুলো চলে গেল।
20th August, 2 PM.
2 PM কি অবস্থা?
এটা ছিল।
হ্যাঁ।
But, within 5 না 2 PM as a specially fixed
একটা
matter.
নতুন রিট ফাইল করেছে, সেটা আমাদের দিতে বললো, দিদি একটা অ্যাপ্লিকেশন করে সেটা দিতে বললো।
They will never stop. If the value is enhanced, they will file litigation. If there is fair
That's
competition,
why I'm telling, let all, whatever
Yes.
the application comes
kindly
together.
puts an end to it on the
সব
return.
মামলাগুলো রাখ।
Well, if
Yes.
it is end to litigation, then court will be wound up. You want that?
কারণ
This
দেখো,
admitted
আমি তো
advocate general, additional advocate general. Once that court will be wound up.
Great.
এইটাও জেরক্স করে দিতে রাজা বাবুকে বলো।
Yes, next.
সব মামলাগুলো একসাথে।
Item number 7.
Lordship, not this week.
Yes.
Lordship,
Who is for the petitioner?
I'm for the petitioner, my
Yes.
lord. My lord,
Lord-
this is an urgent
Lordship,
matter.
The urgent matter, I fix the urgent matter
Yes, my
7.
lord, but
Yes,
we are
what is the
praying for-
urgency?
Urgency is, my lord, the
Where is your
petitioner,
affidavit?
my lord. দাও একটু দিয়ে দাও। And what are the?
Served.
And I've also take a leave to file the supplementary affidavit.
Supplementary right
Some
is there.
managers are.
All advocates have the right to file the supplementary affidavit. Within 2 hours, you filing the writ application, mentioning this, and when the court has fixed the matter, then you coming with the supplementary addition the list of documents and all these things.
So in the consequence, we have got some documents, managed to receive those documents I
Yes,
have.
what is the matter?
The matter is, my lord, my client is a lady who lives in New Jersey. His father is an acute,
Client is,
stays in New Jersey.
this stays in
Hello?
New Jersey, yes.
Her father is an acute Parkinson patient
Hmm.
He's in Kolkata.
Hmm.
But thing is, the lady has provided all sorts of services, that is CCTV, installed CCTV camera so that she can monitor her father.
Hmm.
Second, she has appointed 24/7 caregivers
Hmm.
as well support elders institution who takes care of elderly citizens if they fell sick and all.
Hmm.
She had done all these arrangements, but her mother, that is respondent number 4,
Hmm.
as well her aunt, respondent number 5,
Hmm.
has terminated those caregivers, disconnected all CCTV connections, and also the support elders that the petitioner has appointed. So actually, there is a denial of treatment for this person, and subsequently he met 2-3 accidents, and the lady has to come down all the way from New Jersey to treat his father.
Who is not allowing?
Her mother,
Mother is not allowing to meet
my
the
lord,
children.
and
to
there's
meet
an
the
aunt.
father.
Yes, my lord.
Mother is restraining the children to meet their father.
Yes, my lord.
Where the children reside?
Children is in New Jersey. That is one. So
They are in New Jersey.
lady,
Where
yeah.
the father reside?
Mother resides in Kolkata along with
The father reside.
Kolkata.
Mother is also
Also
Kolkata.
from-
Father is Kolkata.
Yes.
The children are in New Jersey.
Children is only sole child.
Ah.
That is the petition.
How they came to India? He came to India or she came to India?
She came to India. She is
Correct.
coming to India repeatedly, my lord.
Where she is residing now?
She is residing in her uncle's home,
Uncle's home. And the father is not allowing, mother is not allowing to meet the father.
my lord.
What is the dispute?
Illness in ICU. She denied to meet her.
What is the dispute?
There is no such dispute in ego issue.
Dispute how-
I'm just showing a prescription, my lord. My lord, please come to P3, running page 31 of the writ. That is in Dr. N. Vasu.
Have you served the copy to the mother?
Yes,
Who
my
is the
lord. We
mother?
have served everything, but
What
they
is the
have
name of the
refused.
mother?
Shumita, my lord. Respondent number 4,
Sudipa.
Chudipa.
And who is the Sumita?
That is the aunt, my lord. Respondent
Aunt.
number 5,
These both are not allowing.
my lord.
Aunt so where the petition resides now?
Petitioner is residing in his uncle's home.
Uncle so.
My lord.
And how this aunt connect? Aunt is the sister of the respondent number 4.
Yes, sister of respondent number 4,
Respondent number 4.
my lord.
Both are not allowing.
My lord.
Yes. And where is the affidavit of service? Served notice?
Yes, I said they will refuse to take it.
Refused. Where is that?
In the postal receipts, my lord, reflected.
Where is the refuse? Refuse, it will come to you. Where is the postal?
It is marked there as refused, my lord.
Might be written to you. Where is the packet?
Haven't got the return yet.
How it is possible, madam?
Oh, it's on the way, my lord, on the way to return, but it's refused.
Refused on 24/4/2026. Refused on 24/4/2026. Kindly come to the page 11 of your affidavit of service. So 4 months there is it is still under transit.
Oh, it is in our chamber. The clerk just
It's in
said.
a chamber.
My lord, we can.
And how you filed? When the writ petition was filed?
Writ petition was filed on 9th April.
9th April.
Yes, my lord.
Yes, you are appealing for whom?
Lordship, I'm appealing on behalf of the state led by Mr. Nikunj Valia, the learned AGP. He is not here, Lordship, due to some medical emergency. Kindly keep this like in next week, Lordship.
What is the necessity of the state here?
Don't know,
My lord, the
Lordship. We have been served like few days back, Lordship, last week only. Though appear
So give the police protection to the child to meet the father. Why the mother is not allowing to meet the child of the father who is in under treatment at hospital?
Yes.
Lordship.
She has been released from hospital.
Where she
Somehow the
residing?
Fearless Hospital managed a lady to meet her father,
Huh.
but she is not allowed to enter the house, my lord. She cannot take even any medical care.
What is the age of the petitioner?
Petitioner's age is 50, 49, 50, 50. But the father's age is 89, my lord. And denied for all medical services. Even the doctor has prescribed. I have the prescription. I've got just yesterday night for the care to be taken. These are all denied, my lord. If my lord provides a leave, I will submit this petition, this prescription also, as well the discharge certificate.
You serve the press notice to the private respondents?
My lord.
The petitioner has filed the service, affidavit of service, but this court find that the service has not been affected. This court find that the private respondents refused to accept the same. But this said service was affected in month of April 2026. Accordingly, the petitioner is directed to serve a fresh notice upon the private respondent and to file the affidavit of service on the next date fixed. Reach the matter on 21st of August 2020.
My lord, in the meantime, should I be able to see my father as interim order, my lord?
Service is not completed. How can be? Yes, next.
Lord, we have served, my lord.
I appear for the petition.
So in item number 8, my lord, I appear for the writ petitioner.
State.
Lord, kindly permit me to address your lordship online, my lord.
Is leading me, Malad, he is online. He may be.
Malad, we being led by Mr. Razim Mujumdar, Chief Minister one. Malad, we kindly request if a short passover can be given.
It's less than a week. The hospital is closed down without any authority of law.
My lord, we can do it at 12:30.
Yes, what is the case?
Yes.
Tell me.
My lord, I appear, my lord, for the petitioner, my lord. Kindly permit me to address your lordship online.
Yes.
Now, my lord, here, my lord, the writ petitioner, my lord, is a clinical establishment. My lord, all services over there, my lord, has been suspended by the respondent authorities.
Correct.
Now, my lord, on 27th of July of this year, my lord, an unfortunate incident had happened. My lord, a young boy, my lord, he came for treatment, and my lord, ultimately, my lord, expired. Now, my lord, the immediate action was that, my lord, a mob, my lord, ransacked the hospital premises, for which, my lord, we wanted to lodge a complaint. My lord, the police did not register the complaint. Be that as it may, that is a separate proceeding. Now, my lord, on 28th, my lord, the officers of the respondent, my lord, they come for an inquiry, and my lord, thereafter, my lord, issues the impugned order, which is, my lord, your lordship would find, my lord, at page 66. May I place, my lord, two paragraphs of this letter, where it says subject is suspension of all clinical services of the hospital until further orders and preservation of records relating to the treatment of the deceased patient. Whereas a 16-year-old boy reportedly died while undergoing treatment at your hospital, and an inquiry into the matter is under progress. Now, this is very important. It is under progress. During the preliminary inquiry, various apparent irregularities have been noticed. Therefore, pending completion of the inquiry and until further orders, you are directed to suspend all clinical services of the hospital, including admission, OPD, indoor diagnostic, and all other patient care services with immediate effect. Whereas an inquiry into the matter has been initiated by the competent authority and is presently in progress. And whereas during the course of preliminary inquiry, various apparent irregularities have been noticed, which require detailed examination. Now, therefore, in the interest of patient safety and to facilitate a fair and unhindered inquiry, it is hereby ordered that all healthcare services of, including admission of patient, outpatient department services, indoor services, diagnostic services, operative procedures, and all other clinical services shall remain suspended with immediate effect until further orders. Then we're not skipping, then the hospital is directed to preserve everything. We don't mind that. Now kindly take me the last line. This order takes effect immediately and shall remain in force until further orders. Number 2 or 3 points are very important over here. Number 1 is what are the irregularities is not stated. Number 2, the inquiry is under progress. And number 3 is suspension of all clinical services. Now, this is one action taken. The other action is a show cause notice is issued to us, which is at page 67. Where the subject matter of the show cause notice is, please take me of the second paragraph. As Dr. Shonbarto Pal is posted in a non-practicing post at a government health facility, he cannot be engaged in any capacity RMO or consulted in any private health facilities. Now you are requested to show cause so and so, such and such. In other words, this doctor is a non-practicing doctor. We give a reply to this at page 68. Page 67 is replied at page 68. Please take note paragraph number 2 at page 68. That as per your queries at the time of starting the said hospital as per your requirements, we submitted before you a list of doctors engaged in our hospital, wherein the name of Dr. Sombarto Pal was there as holding the post of RMO in the hospital. Again, in the month of June 26, we submitted the same list of doctors so attached with our hospital the purpose of renewal of the for the purpose of renewal of the license, wherein it was mentioned the name of Dr. Sombarto Pal, RMO of the hospital, and on both two counts, no intimation was or objection was raised from your end, for which we took it granted that Dr. Pal has obtained necessary permission from the government authority. Then, Millard, the name of Dr. Pal, Millard, your lordship will find it at the end of the list, which is at page where it goes, where at the last page, that is page 78, where in the list of RMOs, the last name in the middle of that page, RMO Dr. Sombarto Pal. But we are not very much concerned with this for the present. But for the present, Millard, we are concerned with Millard the direction to suspend all clinical services. Then what they do is on 28th Millard, they come at our hospital and Millard close down the hospital. More than 150 patients were required to be removed, and Millard, including Millard patients in ICU. Now, Millard, the legal infraction is, Millard, number one, that Millard, there is nothing in the statute called suspension of clinical services. Therefore, Millard, my respectful submission is, Millard, that this is completely alien to the statutory scheme which is laid down by the Clinical Establishment Act. Now, Millard, a few provisions of the Act, Millard, I'll place before my Lord. Mr. Roy, kindly hand up the Clinical Establishment Act to the court. Millard, the statute contemplates two things before Millard operating Millard hospital. Section 6, Millard provides for registration and license. Well, kindly have a look to Millard, section 6. No person shall keep or carry on a clinical establishment without being duly registered by the registering authority in respect thereof, except under and in accordance with the terms of a license granted thereof. So first is registration in terms of a license. Now, license, your lordship will find that section 7. The licensing authority, if satisfied that the applicant and the clinical establishment has fulfilled such standards as may be prescribed, shall register the clinical establishment and shall grant a license in respect of the clinical establishment in such form and in such manner as may be prescribed. Now, Millard, the license was granted to me, Millard, on 30th of May 2025, last year.
Yes.
Now, Millard, subsection 2 says, no license shall be granted in respect of so and so, so and so. Millard, these are, Millard, the conditions. Then subsection 3 says, every license granted under subsection 1 shall be subject to the following terms and conditions. Then, Millard, the terms and conditions are, Millard, provided, Millard, in subsection 3. Then, Millard, the next important provision is, Millard, if your lordship may kindly directly come to, Millard, section 20. But section 20 provides for, Millard, cancellation and registration of license. Millard, that has not been done. Therefore, Millard, I do not trouble your lordship with that. Then comes, Millard, section 21, which speaks of prohibitory orders.
Yes.
If any establishment is convicted of an offense under this act, B, clinical establishment is kept or carried on without a valid license, C, the license of the clinical establishment is cancelled, or D, the licensing authority is satisfied that an imminent danger to the health and safety of any member of the public or patient exists with respect to that clinical establishment, the licensing authority may, after giving the establishment an opportunity of being heard by an order, impose the following prohibitions, namely, a prohibition for the use of the process of or treatment for the purposes of the service delivery by the establishment. II, a prohibition on the use of the premises or equipment for the purpose of service delivery by such establishment. Now, this is the only prohibition that is contemplated under the Act, provided, my lord, A, B, C, and D, or either of them, my lord, are satisfied. But in our case, my lord, none have been satisfied. Therefore, the question of issuing any prohibitory orders do not arise. Then kindly take, my lord, section 23. But I'll just show your lordship what is the scheme of the statute. But section 23, my lord, provides for improvement notices. If the licensing authority has reasonable ground for believing that any clinical establishment has failed to comply with the provisions of this Act, he may, after ascertaining the opinion of the clinical establishment thereon by a notice served on that clinical establishment, state the grounds for believing that the establishment has failed to comply with the rules, specify the matters which constitute clinical establishment's failure so to comply, specify the measures which, in the opinion of the authority, the clinical establishment must take in order to secure compliance, and require the clinical establishment to take those measures or measures which are at least equivalent to them within a reasonable period. Now, but this is the scheme. Now, my lord, the license can be suspended under subsection 4 of section 23. If the clinical establishment fails to comply with improvement notice, its license may be suspended for such period as to be mentioned in the order. Then skipping over subsection 5, 6. If the clinical establishment during the period mentioned in the order of suspension fails to comply with the improvement notice, the licensing authority may, after giving the licensee an opportunity to show cause, cancel the license granted to him, and if complies with the improvement notice to the satisfaction of the licensing authority, he may revoke the suspension within a reasonable period not exceeding 14 days. Therefore, this is the scheme of the Act. Either the license can be suspended, it can be cancelled, improvement notices can be issued. This is the scheme of the Act. Now, how these are to be executed? Please have a look to section 24, which speaks of an inspection.
Yes.
Inspection of a clinical establishment, the licensing authority or an officer authorized by him shall have the power to cause an inspection or inquiry in respect of any clinical establishment, its building, laboratories, and equipments, and also services rendered by the clinical establishment or any other matter connected with the clinical establishment, and that establishment shall be entitled to be represented thereat. Therefore, this is the provision for inspection. Section 24 thereafter, speaks or gives power to enter into a premises for the purpose of ascertaining something or examination of the services. That is section 24.
Yes.
Now, this is the scheme of the Act. Now, how is it to be enforced? Is under the rules. Kindly have a look to the rules, a few provisions in the rules. Please take rule number 36.
At page 178 of that book.
Yes.
36.
Yes.
But rule 36, please have a look to sub rule 3. The licensing authority, as soon as possible after reasonably being satisfied, shall order an unscheduled inspection and or inquiry in respect of a clinical establishment to verify the material facts and statements made in the complaint upon receiving such written specific complaint of serious nature from a patient or a representative body of patients, citizens alleging non-compliance with the provisions of the Act by that clinical establishment. Then where the proviso says that provided that reasons for such inspection shall be recorded in writing in such order. 4 says the licensing authority as soon as possible shall order an unscheduled inspection and or inquiry in respect of any clinical establishment if she is reasonably satisfied that there is possibility that such clinical establishment is being kept or carried out without a valid license, and 2b, an imminent danger to the safety and security of the service user, service provider, or public at large is existing with respect to such clinical establishment or such clinical establishment not complying with any of the provisions of the Act, provided that the reasons for such inspection shall be recorded in writing. 5. For the purpose of inspection and inquiry under sub-rule 1 to 4, the licensing authority issuing a general and specific authorization notice shall constitute a supervising committee. Therefore, a supervising committee, my lord, is required to be constituted, my lord, for the purpose of this inspection and inquiry. In our respective submission, my lord, subject to correction by my learned friend, this has not been constituted. Be that as it may, my lord. Now, please take note subsection 8, sub-rule 8. The supervising authority at any reasonable time with such assistance as she reasonably require shall enter the premises of a clinical establishment as per Rule 39 and may inspect this, that, etc. But I don't trouble your lordship with that, my lord. This is the power to enter. Then please take, my lord, Rule 37, which contains, my lord, all the powers of suspension, cancellation, or prohibition. Rule 37 says, my lord, the supervising authority on completion of inspection and inquiry shall record the salient points of his observation and recommendation to the clinical establishment, detailing the specific deficiencies to be corrected, if any, in the inspection book. As part of mandatory and record keeping, the clinical establishment shall generate and maintain such inspection book mentioned in sub-rule 1 in such a manner as may be notified. 3. The supervising authority on completion of inspection and inquiry shall record her observation of inspection and recommendation to the licensing authority in the inspection inquiry report as specified in the statutory clinical establishment form 5 and submit the report to the licensing authority. 4. In the event any licensing authority is of the opinion that there is reasonable ground to believe on a review of the report under sub-rule 2 or any such report of any scheduled or unscheduled inspection made under Rule 36 that such conditions exist warranting issuance of improvement notice under Section 23 of the Act, such authority may forthwith issue such improvement notice or may take any necessary action according to the procedure notified by the government from time to time. 5. Under the provision of Section 20 and 21, the licensing authority, if she is reasonably satisfied, may issue an order of suspension or cancellation or prohibition and may consider publication of such orders in public domain to any public servant or public interest. But the rest I skip over. Then please take, my lord, Rule 38. But this is the power to seize also. Rule 38(1). The supervisory authority, preferably in presence of 2 or more independent and respectable persons, enter any premises specified in the authorization notice, including a private dwelling, seize and take into custody any material object if she has reason to suspect that it might be used as evidence in a trial. But I skip over the proviso for the time being. Then kindly take, my lord, the power of seizure is once again, how to prepare it is sub-rule 2. The supervisory authority shall prepare a memo containing list of any material object seized under sub-rule 1 at the place affecting such and such. Then 3 is very important. The supervisory authority shall hand over under acknowledgement 1 copy of the seizure memo to the person from whose custody the material object has been seized. Then, my lord, if it is perishable in nature, I don't, my lord, trouble your lordship. Then, my lord, the last important provision is Rule 39. We can skip over, my lord, sub-rule 1 and 2. Please take, my lord, sub-rule 3. The supervisory authority shall hand over to the person in charge of the premises a copy of the authorization notice, or if such person is not present, affix such a copy to a prominent place on the premises and on the request of the person in charge of such premises, show her identity card, etc. And your last power of sealing is, my lord, under sub-rule 11. In case of non-completion of search and seizure operation, the supervisory authority may also make arrangement by way of mounting a guard and sealing of the premises to prevent any tampering of such material object. Now, this appears to be, my lord, the scheme of the statute.
Yes.
Now, my lord, my points of arguments are, number 1, where, as I said, my lord, suspension of clinical services is unknown. my lord, this is a body, my lord, which is regulated by a statute. So once, my lord, it is regulated by a statute, my lord, it is a body, my lord, which is sui juris. It can only do those things which are permitted under the statute. It can suspend my license, it can cancel my license, it can issue prohibitory orders against me, but it cannot do something which is unknown to the statute. This is number one. Number two is, my lord,
Yes.
number two, my lord, it appears that, my lord, the action is not completely, my lord, unregulated. Why I say so, my lord? Assuming, my lord, they have the power. Then also, my lord, there has to be an authorization notice.
Procedure
which
is
is procedure is there. My lord, we have not been served with any authorization notice authorizing any person to undertake this activity. Number, this is for our protection. The clinical establishment's protection that the statute provides, that the supervisory committee, before constituting the supervisory committee, my lord, it has to be preceded by an authorization so as to ensure that the powers are not, my lord, misused by the competent authority. My lord, this, my lord, protection, my lord, has been negated, my lord, in respect to our case. This is, my lord, my second point.
Yes.
The third point is, in the suspension notice itself, my lord will find at 3 places it says that the inquiry is under progress.
Yes.
Therefore, my lord, in the absence of the inquiry being completed, my lord, in my very respectful submission, my lord, there cannot be any formation of opinion to, my
Yes.
lord, take any adverse action against me. But the statute does not permit, my lord, any adverse action during the pendency, my lord, of a proceeding. Well,
Yes.
number 4, my lord, my point is that no show cause, my lord, is there in respect of the suspension.
Yes.
But the show cause is in respect of the Dr. Shombarto Pal's, my lord, engagement. But so far as, my lord, the suspension of services, assuming, my lord, it is permitted under the Act, assuming for the timing, my lord, no show cause given, no hearing given.
Yes.
And finally, my lord, what the materials on which, my lord, they allegedly, my lord, take, my lord, adverse steps against me are completely missing. That is very important. Why do you come to this conclusion? Tentative. I can understand it is tentative. But for, my lord, a tentative conclusion also, my lord,
Yes.
they need to, my lord, supply me the materials. But how do I defend myself?
Yes.
Therefore, my lord, these are the grounds, my lord, on which I say, my lord, it is without jurisdiction. And my lord, I don't want to, my lord, bring in those, my lord, decisions which starts from Taylor versus Taylor, then, my lord, Nazir Ahmed and all, which says, my lord, that the statutory procedure, my lord, has to be complied with. And my lord,
Yes.
lastly, my lord, I am preempting, my lord, an argument that, my lord, they may come up with a contention that, my lord, there is a statutory appeal under section 26. Now, please have a look towards section 26 of the Act. Well, section 26 is appeal to the appellate authority. Any person aggrieved by I, failure of the licensing authority in communicating or allowing rejection of application for registration and license to the clinical establishment after the expiry of the prescribed period doesn't apply. II, an order of the licensing authority refusing to allow registration or to grant
That
or renew a license does not apply. Then,
II.
Miller 3, II means, Miller, cancellation or suspending a license.
Correct.
My case is not a case of suspending license. It is a case of suspending the services. Number 4 is, Miller, an improvement notice, and number 5 is prohibitory orders. Now, Miller, assuming for argument's sake, Miller, somehow it may be connected to a prohibitory orders, Miller, please have a relook to section 21. But prohibitory orders, Miller, please come back to, Miller, section 21 once more.
Yes, the ABCD, that is, you have.
Right. Therefore, Miller, this is a case, Miller, in my very respectful submission, an action taken uncontemplated under the statute, alien to, Miller, the measures provided under the statute, assuming it is provided somewhere in the statute, then also, my lord, the principles of natural justice, my lord, has not been complied with, because I need to know what are the irregularities I have committed, what are the material deficiencies in my institution. Then and then only, my lord, some action can be taken.
Yes.
Well, the incident is unfortunate. I cannot, my lord, say anything on that. But, my lord, every incident, my lord, cannot, my lord, result in suspension of services. It is otherwise also, my lord, contrary to public interest, because patients from ICCU had to be removed, my lord, within half an hour.
Yes.
These are my submissions, my dear lordship. May kindly, my lord, protect me, my lord, stay the order of suspension of services, my lord, and, my lord, your lordship may direct filing of affidavits, my lord, for final adjudication of the matter, my lord. But these
Yes.
are my submissions.
But so far as my understanding is concerned, the authority has acted in terms of the act. Now, your lordship knows, Lord, this case was started with a unfortunate incident of a death of a boy, 16-year-old. Your lordship knows better than me, but the Supreme Court is very clear on that. But if there is medical negligence on the part of the doctors, then, my lord, the Jacob Matthew will apply. But so far as hospitals are concerned, my lord, straight away FIR can be drawn. Straight away FIR was drawn. On 27th, the boy died. Immediately FIR was drawn. Now, my lord, what prompted us to take this action? If your lordship kindly see two notices. First notice, your lordship will find in page 67, where, my lord, your lordship will find show cause relating to engagement of a government medical officer holding a non-practicing post of a government residential officer. Page 67, annexure P6. Memo number 3433. This memo was issued first, then the second memo was issued. But this is nothing to do with the provision order. Provision order, which they are challenging, but this has nothing to do with the provision order. Your lordship will find 3433. It says show cause regarding engagement of a government medical officer holding a non-practicing post as a resident medical officer RM.
Yes.
Your lordship knows better than us, but no government employee or government doctors are permitted to being a RMO in a private nursing. That is the reason, when it was detected on the course of inquiry, immediately on 28th this notice was given and he was supposed to reply within 3 days. We have nothing to do with this. The provision order has nothing to do with this. Now, kindly turn to the provision order in page 66. Provision order, I'm sorry. Annexure P5.
So page 67 is the personal notice to the Dr. Shah.
Not to the doctor, right? To the hospital. To the hospital, your lordship will file it as addressing to the hospital.
Correct.
Yes. And it is a show cause notice. Why they are allowing one Dr. Shonbroto Pal to be a RMO who is also the doctor in a government hospital.
Correct.
And your lordship knows better than us, my lord. No government doctors are permitted, but being a employee of a private hospital. That is the reason that is a violation of the rules.
Yes.
So that is the reason that this show cause notice was given, and he was supposed to reply within 3 days, which he did. And the inquiry is still pending so far as this issue is concerned.
If a government doctor
Yes.
is working in a private establishment
As a RMO.
Just a minute. As a RMO, regional, whatever it may be, whether the government first has to take action against the doctor or the hospital.
Well, definitely.
Tell me, give me answer. It is your government doctor. Your doctor.
Yes.
Government paid servant.
Yes.
It is a misconduct under the service rule. Correct. So if he is working, because if he is working in the private hospital, so what is the first action? First action has to you have to take action.
Your lordship is correctly said.
Correct.
But we are not on this notice. But
Hmm.
we are not challenging any action taken by against the doctor.
Okay.
But this page 66 is an independent consideration.
Yes.
Please see page 66.
Yes.
To the director, so the hospital, the petitioner hearing.
Yes.
Sir, whereas 16 years old boy reportedly died while undergoing treatment in your hospital. An inquiry into the matter is under progress.
Correct.
During the preliminary inquiry, various apparent irregularities have been noticed. Therefore, pending completion of the inquiry and until further order, you are hereby directed to suspend all clinical services of the hospital including admission, OPD, indoor diagnosis, all other patient care service with immediate effect. Whereas an inquiry into the matter has been initiated by the competent authority is presently in progress. Whereas during the course of preliminary inquiry, various apparent irregularities have been noticed, which require detailed examination. Now, therefore, in the interest of the patient safety and facilitate a fair and unhindered inquiry, it is hereby ordered all healthcare service of including admission of patient, outpatient department service, indoor service, diagnostic service, operative procedures, and all other clinical services shall remain suspended with an effect from until further order. The hospital authority is further directed to preserve all original records, documents relating to treatment of deceased boy, including admission record, case sheet, doctor and nurse's note, investigation report, prescription, consent forms, so and so, and other relevant documents. Ensure that no record or document is altered, tampered, destroyed, concealed, or removed in any manner until completion of the inquiry or until further order from the competent authority. Full cooperation of the inquiry committee and produce all record, register, or documents also. Violation of the order, transmission, and record shall be viewed seriously and shall be invite appropriate legal and administrative action under the applicable provision of law. The order shall shall remain in force until further order. But this is an independent consideration. Now, Milord, this prohibitory order.
No, this order on pass under which
Under
provision?
section 21. Milord, kindly turn to this. Section 20. Milord, kindly see, Milord, there are four categories.
Correct.
Milord, it is very, Milord, kindly read with me once. Milord, your lordship will get, Milord, what is the understanding of the statute? If any clinical establishment is convicted of an offense under this act, we are not falling in this category. Then second, the clinical establishment is being kept or carried on without a valid license. This is also where we are not present. The license of the clinical establishment is cancelled.
That is not.
For pause here for a moment. Now, Milord, kindly skip D and directly come here. After giving the clinical establishment an opportunity of being heard.
Where from you reading?
Skip, Milord, kindly skip D. Straight away, Milord, come to the sentence starting with after.
Correct.
But these are the three categories where, Milord, he was convicted, where, Milord, without a valid license, or, Milord, the license is cancelled.
Yes.
Here, after giving the clinical establishment an opportunity of being heard by an order imposing the provision.
Correct.
So, in these three categories, it is mandatory, Milord, whenever, Milord, the establishment, that any prohibitory order is passed, Milord, they have to give notice.
Correct.
And right of audience is there.
Yes.
Now, Milord, kindly see D now. Because of the emergent situation, Milord, this D was incorporated.
Correct.
In our case, Milord, we are falling in D.
Correct.
The licensing authority is satisfied. Milord, a satisfaction, Milord, kindly mark it.
Correct. Satisfied.
It is a subjective satisfaction that an imminent danger to the health and safety of any member of public, kindly mark this word also, or patient exists with respect to the clinical establishment. The licensing authority may, here the word may has been introduced. Correct. So, your lordship, this provision, section D, is a discretionary power.
Correct.
And subjective satisfaction of the authority.
Correct.
So, then your lordship will find it may not also. If the situation is so great, emergent intervention is required.
Correct.
They have the authority without hearing them an opportunity
Correct.
to, Milord, pass the prohibitory order.
Then it is to be read with your suspension. What is the emergent situation here?
Yes, the emergent situation, the boy is died because of their latches.
Correct. Where is that? Where is that? You are telling the inquiry is still going on.
Yes.
And not to disturb the records and all these things. So inquiry is going on. You have not come to the conclusion because of this doctor's negligent, a wrong treatment. It was done.
There is the emergent situation.
That's why you. That is itself. That's why you.
A person has.
Sir, every day you don't try to open. My mouth should not be open before this court in the open court. it is not in none of the the hospital, no death is occurred. Then
Hospital is even open.
if FIR is lodged, if a mob has come, incident has happened, so it is immediately you suspend this license without following the procedure law.
But procedure has been followed.
You satisfied from this order? Yes, this is the thing which it has been stuck to the department. Yes, it is imminent danger. What is the imminent danger?
Whereas, kindly see, whereas a 16 years boy reportedly.
Correct. Reported, died, FIR, no. And you himself is telling that inquiry is still going on. That's why you should not keep the document intact. Where is your opinion? If it is opinion, yes, we can say you are the expert. It is the opinion because see, if the boy is dead, I am giving this example. There might be a postmortem report. Under the postmortem report, there will be a medical doctor's opinion. Where is that opinion due to the negligence of the doctor?
But it is not about the negligence of doctor.
Then-
If it is a negligent, I am telling you, Lord.
Then what?
Those better than us. If it is a negligent of doctor, then straight away the FIR cannot be drawn up and the inquiry, internal inquiry has to be set up.
Death,
Then
unless
the lack of Matthew will follow.
that will follow.
But
But
hospitals are concerned.
yes, hospital means what? Hospital is provided the service of the doctor.
Not only the doctors, the
Whatever
other
it may be,
also.
whatever it may be. So show me what is the imminent you have got, your authority has got that from this order.
Malat, when the inquiry is in progress, Malat, in terms of D, Malat, it is my humble submission, the prohibitory order
Okay.
can be passed.
Okay, okay.
Malat, kindly see the two aspects.
Yes.
D, after giving the clinical study, now, Malat, a provision of the use of progress of treatment for the purpose of service delivery by the clinical establishment, a provision on use of premises or equipment for the purpose of service delivery by the clinical establishment. But here in D, your lordship will not find but the satisfaction is a subjective satisfaction. It need not be expressly.
Has to be read with D.
Yes, my lord.
Read with D. You are you as per your submission, this impugn order is page number 66 in accordance with D. And D, if you have satisfied the D, then I and III. Correct.
Yes.
So and so with regard to the D is the satisfaction. So regarding II and III is the consequence. Consequence is the consequence. So you have to satisfy with regard to D.
Yes, my lord, the licensing authority is satisfied.
Satisfied.
Well, we are satisfied. That is the reason, my lord, the inquiry has been initiated.
Okay.
My humble submission is this.
Okay.
Now that is the reason, and
Okay.
your lordship knows it's relating to the, my lord, the safety, security of the patient also.
That is different thing.
One
That is
person have died because of their latches. My lord, primary it was, my lord, the
okay. You do one thing. I am fixing tomorrow. You bring the postmortem report of the that person.
Then, my lord, case diary has to be called for.
You are inquiring into the matter. You come to the imminent satisfaction. How the case diary is required? You have immediately when the death was occurred. 27, 7,
28. This was
28. This
initiated.
was done. So and you are not telling with regard to the death. You are telling that the total establishment. So what was the satisfaction?
No, but the satisfaction date is one of the criteria. If you
One
look
of the
at
criteria.
first para, it speaks about the date of the young boy.
That is
of the
correct.
Medical negligence.
That-
That is one of the reasons that this prohibitory order was passed. And your lordship now 26. So 26, they have shown it to your lordship.
Yes, yes. Appeal.
The section 26 is very clear. But kindly see, any persons aggrieved by, well, there are 1, 2, 3, 4, 5. Now we are coming in 5. The prohibition order.
Prohibit order.
So there is appellate provision.
Correct. Correct.
So number one, they have come up before your lordships here
Yes.
that no, the authority has not given any right of audience.
Okay.
But my humble submission is this in terms of the clause D. No right of audience is required for subjective satisfaction.
Okay.
This is number one.
Yes.
Number two is, my lord, if they are aggrieved by the order, my lord, their remedy under section 26
Yes.
before the competent authority, which is an appellate authority.
Yes.
Now, my lord, kindly see, they are pleading also, which is para 20.
Para 20.
Para 20.
Yes.
And I shall show it to your lordship. They were very much present when the inquiry was being conducted in the hospital. 20, the petitioner respectfully state, no point of time prior to the issuance of equivalent memo so and so. There was a prior information of precise allegation, deficiencies or irregularities which was purportedly noticed by the respondent authority during the course of preliminary inquiry. The petitioner was never apprised of the factual on his respondent. Proposed to initiate any coercive or adverse action against the petitioner in hospital in absence of disclosure or allegation. Petitioner effectively deprived of the meaningful opportunity to explain his position and requirement provided so and so. Now 23. The petitioner respectfully stated that on 28/7/2026, the respondent authority issued a notice calling upon the petitioner's hospital to explain within 3 days why so and so was allegedly posted in a non-practicing post at the government health facility has been engaged in any capacity of the petitioner's hospital. Immediate upon of the same notice, the executive officer so and so submitted a detailed and comprehensive reply on the petitioner. However, notwithstanding the fact, respondent themselves granted 3 days time. But this is relating to the other notice, but this is not the cause of action, but for passing the prohibitory order. Now kindly turn to para 12.
Yes.
The petitioner further states the subsequent to the unfortunate incident, the Office of Chief Medical Officer Health Bureau, along with other authorized officers, constituted a 4-member inquiry team headed by Deputy Chief Medical Officer of Health. He visited the premises of the petitioner of the hospital and examined the relevant medical records. So it was examined.
Yes.
Interacted with the hospital authority and also collected such information as they considered necessary for purpose of conducting a preliminary inquiry. The petitioner extended full cooperation to the members of the inquiry team and made available records, documents, and information sought by them. What else is required? So an inquiry was conducted. They were participated in the inquiry on 27.
No, that's correct.
28.
They are not.
This prohibitory order was passed.
It is not. Mr. Dutt has not tell that. Yes, they have not conducted inquiry. They have passed. He has told that. Yes, they came inquire. But the procedure which has now you are coming to the D. If you are coming to D, I totally agree with your yes D. There is no requirement of notice. But what is the situation? What is the imminent situation?
Well, imminent danger is.
What is the imminent danger?
Well, I'm telling your lordship, subject to your lordship satisfaction. But imminent danger was without any medical, will be providing adequate medical attention.
Yes.
The 16 years board will kindly go through the FIR once. Your lordship will get everything there. How will not be painful it
But
is.
that is not with regard to that FIR.
Yes, it is regard to the FIR. Will not kindly see this.
Kindly come to the impugned order 66.
Yes,
Kindly come to the 66.
kindly see suspension of all clinical services.
No, kindly come to 66 as per the complaint you have conducted negligently. Where is that? You were telling that.
Kindly see this.
Just Mr. Just you stated that FIR has having the detailed allegation. So where is that mentioned? That's what I'm telling. You show me something in the order. So yes, this is the thing.
Although the citation of the FIR has not been incorporated in this notice, but your lordship will find the crux of the allegations are same. Suspension, can you see the subject? Suspension of all clinical services of the hospital until further order, preservation of records relating to the treatment of the deceased patient. So this is relating to the deceased patient only, not the first line. Then first line, whereas a 16-year-old boy reputedly died, although the FIR number has not been mentioned here, but it relating to the same incident.
And the inquiry is under process.
No, during inquiry, during the inquiry, which in para 12,
Either you argue, either your junior will argue. This is
para 12, we are lordship seeing the inquiry was initiated and there was a progress of the inquiry. Now, during the preliminary inquiry, various aspect irregularities has been noticed. So, they are also attended. They attended the preliminary inquiry. And
Yes.
there it was found below the various latches on the part of the hospital authority, which caused death of a 16-year-old boy. That prompted us to issue this prohibitory order.
Okay. Anything?
That's it.
Yes, Mr. That you're admitted in paragraph 12, which corroborate the paragraph 16, paragraph page 66.
Yes, there is no dispute. There is no dispute that the inquiry has started. There is no dispute that we have cooperated in the inquiry. There is no dispute that whatever documents were required for their perusal, that were they were offered inspection for perusal of the documents. But the final thing that is required is, my learned friend, with respect, has not read the section 21 in its correct perspective. But please come back to section 21. The word may is not only confined to D. The word may is applicable to all A, B, C, and D. This is number one.
Yes.
Number two is, he has skipped over one provision which says after May, after giving the clinical establishment an opportunity of being heard, where no submissions have been made, that I was given an opportunity of hearing. Now, this is, a precious right of mine, that assuming that this to be a prohibitory order, then also, it must be preceded by a hearing. Therefore, natural justice violated, and your lordships have held that natural justice is part of Article 14. This your lordships have held. This is the second part. The third part is, what your lordship has been asking my learned friend as to what is the imminent danger. The impugned order, does not, say that allowing this establishment to function would result in imminent danger. Please take 21D once more, Please take 21D once more. Your lordship is pleased to ask my learned friend. My learned friend, with all humility, I say, has not responded. D says the licensing authority is satisfied. So some satisfaction has to be recorded. Whether it should be subjective or objective, we can address your lordship at the final hearing. What is the satisfaction? That an imminent danger, not only imminent danger, to the health and safety of any member of the public, means an identified member of the public or patient exist. Now, which member of the public, for whom, it is the functioning of the authority of the establishment would result in imminent danger is not provided. Member of the public or patient. One unfortunate incident has happened. Nobody is disputing that. I cannot support a death. But the statute does not say that a death, assuming for argument's sake, is negligence. The negligence being on the part of the doctor, would result in an imminent danger to an identified member of the public and identified patient. But this is the scheme of the statute. These are, the protection that I have. The authority is concerned to see that the powers are not misused by the authorities. That is why, so many things have been said. And then, kindly see, what could be the prohibition? The prohibition is use of the process or treatment, and prohibition to use the premises, not to stop the services. Using the premise, not to use the premises, and stopping services, in my respectful submission, are completely different. None of the provisions in the statute, provides that services can be stalled. Today, you can cancel my license, you can suspend my license. That may ultimately result in, stoppage of services. But prohibition is not on, rendering services. Prohibition is on the use of the premises or equipment.
Yes. Anything
These are my respectful submission, and section 26, natural justice violated, Whirlpool's judgment is here, I don't think, I need to, detain your lordship on that. That 26 is not a bar, assuming it is a prohibitory order. but it does not qualify to be a prohibitory order. That is, my lord, my last submission.
Two corrections only. My lord, one is kindly come back to paragraph 13. My lord, this inquiry was held on 29th. That is after the notice.
Yes,
It's a
yes, yes.
post-decisional inquiry. Paragraph 13, my lord, kindly read. The petitioner state that to its utter shock and surprise, the respondent number 7 issued a memo number such and such directing immediate suspension of all clinical services of the petitioner hospital until further orders. Significantly, the imbued memo itself purports to have been issued on the basis of preliminary inquiry. However, chief of the deputy chief medical officer health 3 admitted visited the petitioner hospital 9/7/26. So they came after the notice.
Our instruction from the next day, they visited and inquiry was conducted.
That's one word. And the second part is, Malad, kindly come to page 57. This is a part of the FIR. I'm grateful to my learned friend, Malad. He has said that against doctors, an FIR could not have been registered without complying with Jacob Matthews' judgment. But kindly see, they're all doctors. Hospital is not an accused. Page 57. This is a part of the FIR. The name of the accused, Malad, kindly see, Dr. Devosmita Devnath, Dr. Rizwan Aswin, Dr. Sambarto Pal, Dr. Sobosati Saha, and 2 others. The hospital is not named as FIR. Yes, director of the hospital is all right. But that doesn't mean that you can rope in the doctors, RMOs. They are RMOs. So therefore, without Jacob Matthews, well, just by naming a director of the hospital, you cannot rope in the doctor. No, very well. That is in a different jurisdiction. We will take steps in accordance with law. But to say that Jacob Matthews applies and we have proceeded against the hospital, that is not correct. So these are the two factual clarifications. And second is, while reading the, of course, Mr. Datta has already said that, but while reading the first paragraph of the impugned notice, my learned friend had used the word medical negligence. But that is not there in the entire notice.
Yes.
That's just one thing I'm clarifying. Let's say when passing a provisionary order, blood the establishment cannot be closed, or blood the emergent medical services cannot be closed. Kindly see blood at the subclause 1. A provision order use of process of treatment for the purpose of the service delivery by the clinical establishment. It covers everything. It's not that only the premises can be closed.
The premises
No,
closed.
no. May I clarify? My lord, this process or treatment, for example, my lord, if somebody is offering, my lord, for example, my lord, say kidney replacement, my lord, that process can be stopped. But the other part of the hospital cannot be stopped. This is not the entire establishment that can be stopped. There has to be a difference between cancelling and, my lord, stopping.
And doesn't have license. Whether he can run without giving any adequate medical service to the patients or not. That is the reason why this Roman 1 and Roman 2 was incorporated. I will say 2. A provision for the use of devices or equipment.
Okay. The petitioner has filed application challenging the
May I take your lordship's leave, Miller?
Challenging the impugned order dated 28th of July 2026, wherein the Chief Medical Officer of Health, Birbhum has suspended all clinical service of the hospital unit until further order. Learned counsel for the petitioner submits that the impugned order of suspension of the clinical service of the hospital of the petitioner is issued without following the due process of law. Full stop. The petitioner submit that the petitioner is having the registration certificate, and it is which is valid up till.
It is valid till 2029.
Up
I'll just give your lordship the date.
2029.
It's at page 37, Malad, till 29/5/2029.
Till 20. Valid up to 26.
29, Malad, 2029. At page 37, Malad, the renewal is there. The second paragraph is 37. The last two words, 3526 to 29/5/29.
2029, full stop. The petition submit that on 27th of July 2026, an unfortunate incident of the death of one boy of 15 years was happened, and on account of the death of the child of 16 years, an FIR was chalked out by the police for the offense under section 304A/3420 106 within bracket 1 /318 within bracket 4 /238/61 within bracket 2 of the BNS 2023 20 full stop. He submitted that on full stop on 28th of July 2026, the impugn order is passed by the respondent authorities. And simultaneously, a so-called notice has been issued to the hospital asking the explanation why Dr. Sanbrato Paul is posted in a non-resident and non-practicing post at a government health facilities be engaged in the said hospital. Full stop. The hospital has given the reply to the said notice, but the said notice is not connected with the suspension order or impugn suspension order. Land Counsel Mr. Datta Leonard, senior advocate appearing for the petition, has relied upon section 21 of the West Bengal Clinical Establishment within bracket registration, regulation and transparency act 2017, and submit that section 21 provides for provision order. For issuance of the provision order, altogether the four conditions has to be established, and if the authorities have to issue an opportunity of hearing, then a provision order can be passed. But in the present case, no opportunity of hearing was given to the petitioner, and the impugn order is passed. Full stop. And counsel for the petitioner further submit that Rule 36 provides the inspection and inquiry. Full stop. As per this provision, the licensing authority may necessary shall order for schedule of inspection or inquiry in respect of any clinical establishment at a periodical interval as often as may be necessary to satisfy himself that the clinical establishment is being kept or carried on the accordance with the terms and conditions. He relied upon sub-rule 5 of Rule 36 and submit that for the purpose of inspection and inquiry as per Rule 1 to Rule 4 of the licensing authority by issuing a general or specific authorization notice shall constitute a supervisory authority consisting of one or more member of the government servant headed by the government medical officer. He further submitted as for clause 8, subclause 8 of clause 36, sub-rule 8 of Rule 36 provide that the supervisory authority at any reasonable time with such assistance as he or she reasonably requires shall enter the premises of the clinical establishment as per Rule 39, and he can inspect as per the law provided under the set rules. He further submits that as per Rule 37, inquiry report, improvement notice and suspension of the cancellation and provision order can be issued. But in the present case, no inquiry report has been provided to the petitioner, no inspection has been carried out by the supervisory authority, and no improvement notice has been issued to the hospital authority, but directly the hospital authorities have passed the improving order by suspending the clinical service of the hospital. Fully. Per contra, an advocate appearing for the state, the additional advocate general appearing for the state submit that this the respondent authorities have issued the order by under section 21 of the act. He submit that section 21 provides for provision orders. He relied upon clause D of section 21 and submit that as per the said provision, if the licensing authority is satisfied that the imminent danger to the health and safety of any member of the public or patient exists with respect of the clinical establishment, the licensing authority may pass a prohibition order. And accordingly, the inquiry was conducted, and the authority find that has satisfied that there is an imminent danger to the health and has passed the order. He has referred the impugn order and submit that in the impugn order it is categorically mentioned that in the interest of patient safety and to facilitate a fair and unhindered inquiry, the authority has suspended the clinical services of the hospital. And as such, full stop. He further submit that the authority have passed this impugn order under section 21 within bracket B of the act, and as such, the order is an appealable order under section 26 of the said act. He submit that the petitioner instead of preferring an appeal has filed the present writ application, and as such a writ application is not maintainable. Had the learned counsel for the respective parties furnished the materials on record. It is the specific case of the state that the state has the authorities have passed the impugn order by taking into consideration of section 21 within bracket D within bracket II of the Act of 2017, which reads as follows. Section 21 within bracket D. The licensing authority is satisfied that an imminent danger to the health and safety of any member of the public or patient exists with respect to the clinical establishment, the licensing authority may, then II, a prohibition on the use of premises or equipment for the purpose of services delivery by the clinical establishment. In the present case, as per the case of the state authorities, that on 27/7/2026, a incident of death of the child was occurred in the hospital at the time of treatment of the said child. Accordingly, an FIR has been initiated. Immediately after the said incident, the authority have inspected the premises. Then counsel for the petitioner has brought the attention of this court to paragraph 12 of the writ application, wherein the petitioner has admitted that the authorized officer constituting 4 members of inquiry team headed by the deputy chief medical officer of the health within bracket 3 visited the premises of the petitioner hospital and examined the relevant medical records, interacted with the hospital authorities and collected such information. As such, correct, full stop. From the said, by referring this said provision, Common Council appearing for the state submit that inquiry was conducted in presence of the hospital authority, and opportunity was given, and after the inquiry, the authorities has found that there is an imminent imminent danger to the health and safety of any member of the public. Accordingly, the authority have passed the impugn order. Passed the impugn order. Full stop. Learned counsel for the respondent has relied upon paragraph 13 of the writ application and submit that it is a specific case of the petitioner that the impugn order was passed on 27th of July 2026, but the inspection was carried by the authorities on 28th of July 2026, and as such it cannot be said that the order was issued, the impugn order was issued before the inspection has been carried out, as mentioned in paragraph 12 of the writ application. Full stop. Admittedly, there is an incident of death of the child during the treatment in the hospital. The petitioner and the learned counsel for the state has submitted that the so-called notice issued by the authorities on 28th July 2026 is only with regard to the Dr. Sanbrato Pal and not with regard to the hospital. And as such, the so-called notice is not connected with the impugn order. Full stop. Section 21 of the Act of 2070 provides that the licensing authority is satisfied that an imminent danger to the health and safety of any member of the public or patient exists with respect of the clinical establishment, licensing authority may, after giving the clinical establishment an opportunity of being heard, by an order, impose the following prohibitions, namely, number I, a prohibition on the use of process or treatment for the purpose of services delivery by the clinical establishment. II, a prohibition on the use of the premises or equipment for the purpose of services delivery by the clinical establishment. The clause A, B, C, D. A, B, C, D. As per the said section, a proper opportunity is to be given to the establishment. But in the present case, the opportunity is missing. Only after the incident of the death of this child in the hospital and after registration of the FIR, the authorities have passed the impugn order. The respondent authorities have not placed any document before this court that any notice was issued or any supervisory authority have been appointed or any notice for improvement has been issued to the hospital authority for improvement of any lacuna in the said hospital. The hospital authorities have immediately suspended the services of the clinical services of the hospital. In the impugn order, it is mentioned that in the interest of the public patient safety and to facilitate a fair and unhindered inquiry, it has been suspended. But the authority in the impugn order not mention what was the public interest of the public or the patient safety. In the impugn order, there is no mentioning with regard to any lacuna or any lacuna was found during the inquiry. It is in the inquiry in this impugn order, it is also mentioned during the preliminary inquiry various apparent irregularities have been noticed. But when the preliminary inquiry was conducted, as per the statement of the petitioner, the inquiry was conducted on 29th of July 2026. The interim order, the impugn order was passed 28th of July 2026. Thus, there is a contradiction in the statement made by the petitioner in the affidavit, in the writ petition by way of an affidavit, and the submission made by the counsel for the state, as well as the averments made in the impugn order. Considering the above, this court find that the authorities, without following the due process of law, due process of law have issued the order for suspension of the clinical services without giving any opportunity of hearing. Full stop. The respondent authorities have raised the point of maintainability of the present writ application as the impugn order is appealable order. But this could find that it is the specific case of the petitioner that the respondent authorities have not given an opportunity of hearing to the petitioner before passing the impugn order. This court also satisfied that the impugn order is passed without giving an opportunity of hearing and in violation of section 21. In section 21, it is categorically provided that after giving a clinical establishment an opportunity being heard by an order can pass an order for suspension. But in the present case, it is admitted that there is no opportunity of hearing was given. Thus, the stand taken by the respondent authority that the order passed by the appellate authority cannot stand. Considering the above, this court find that the impugn order is issued without following the due process of law and without giving an opportunity of hearing, and thus the impugn order dated 28th of July 2026. The operation of the impugn order is state. That will be better. Impugn order is set aside and quashed. Set aside and quashed. Impugn order being memo number 3436 dated 28th of July 2026 is set aside and quashed. Full stop. However, the quashing of the impugn order will not prevent the respondent authorities for taking appropriate action against the petitioner in accordance with law. In accordance with law, after giving an opportunity, after giving an opportunity of hearing to the petitioner.
To be very honest, in the brief, I was
Automatic.
thinking
Now
that
the
the
content
first thing
code.
that I should make this sufficient. Then will not.
He knows.
I read the entire the schedule only. That main point was helping.
But the affidavit of service may be kept on.
Thank you for this book.
Grateful, my
Because
dear.
otherwise, again, it will linger.
It will be dragged.
I'm grateful to your lordship.
105.
May it please your lordship. Lord, I appear for the petitioner in this matter, my lord. This, your lordship will recall, is that matter wherein I was, my lords, denied the ad interim order, my lord.
Yes, what is the matter?
Yes, my lord. My lord, the scope of my writ petition, my lord, is twofold, my lord. One is the unreasoned, irrational, and illegal representation dated 19th November 2025 passed by the respondents pursuant to an order of the Honorable Supreme Court, my lord. I'll tell your lordship, my lord, before taking your lordship through the case papers, my lord, there's an NIT issued for construction of a university. I am adjudged as the lowest tenderer. The work order issued in my favor had to be executed within a
So what
stipulated
is the prayer
period of
here?
time. My lord, insofar as my reliefs are
What is the
concerned,
prayer?
my lord, for setting aside of the 19th November 2025 representation, my
What
lord.
is the representation?
This your lordship will kindly have, my lords, my reliefs at page 41, please, of my writ petition, my lord.
41.
40, my lords, page 40.
Track, my lord. My lord will not be.
41.
The rate, my lord.
41.
40, my lord, my reliefs.
Now, where is the impugn order?
Impugned order, my lord, that your lordship will have at page 403. This is, my lord, volume 3, my lord.
403.
Yes, my lord.
Reason order, compliance of the Honorable High Court met number so and so so and so. Supreme Court of India.
My lord, your lordship will kindly permit me to apprise your lordship of the factual backdrop, my lord, once before your lordship kindly has this order, my lord.
Since the contract is already terminated in accordance with the penal provision and reversion of the same, though the honorable terminated is not acceptable, proposal for preservation of credential of the future work cannot be accepted. Hence, on going through the merit of the matter, the procedure followed by it is hereby ordered that the presentation dated Madhumita construction is considered and rejected. Yes.
Yes, my lord. My lord, I'll tell your lordship, my lord. Insofar as the notice inviting tender and the contract executed between the parties, I will only rely upon their documents. They have suo moto from time to time granted me
So what
extension.
you will get if that order is set aside here?
My lord, I'll tell your lordship, my lord, what I will get, my lord. Today my security deposit that has been retained by them, my lords. The contract has been illegally and unlawfully terminated, my lords. The machinery and material that is there at site that has been retained, my lords, as on date. And today, my lord, in pursuance of the Honorable Supreme Court's order, they passed this order dated 19 November 25, which they consider to be a reasoned order. This, my lord, is in reply to the representation dated 4th July 25. Your lordship will kindly once have, my lord, my representation dated 4th July 2025.
When the order of the this court?
This honorable court's order, my lord, your lordship will first kindly have the division bench's order, my lord, at page 392, my lord.
392.
Yes, my lord. This, my lord, is at volume 3, my lord.
396, 392.
And against this honorable division bench's order, did the Supreme Court uphold the same and say that please consider the representation expeditiously. My lord, shown of unnecessary facts, your lordship will kindly have paragraph 13 of the order once, my lord, at page 395. That is the ordering portion, my lord. Although we are not minded to interfere with the order impugned and the decision of the learned single judge, that disputed questions of facts are involved and therefore the writ petition was not maintainable. Nonetheless, we request the authorities to consider and decide the contents of the letter dated 4th July 2025 by passing a reasoned order thereon. The authorities will communicate the recorded order to the appellants within 3 weeks from date.
Parties arises out of the commercial contract and several disputes of question. Yes. Then the authority is directed. What the Supreme Court said?
My lord, 397, your lordship will kindly have. This is the order dated 10th October 2025, my lord. With 2-paragraph order, my lord.
Representation made the petition referred to by the High Court in the impugn order may be considered and disposed of. Yes,
my lord.
They are disposed of.
My lord, the order has to be reasoned, my lord. Any administrative action, your lordship knows of settled proposition of law that at least some reason and some fairness has to be attributable.
What was your grievance?
I'll tell your lordship what my grievance was, my lord. I have written a letter dated 4th July 2025. In that letter, I say that because of X, Y, Z reasons, I have not been able to complete the work.
Correct.
You have taken cognizance of these reasons.
Correct.
Pursuant whereto you have granted me an extension.
Correct.
In 2025 itself.
Correct.
Suddenly, after a month, they issue a show cause notice upon me, imposing penalty upon me, and thereby terminating my contract.
Correct.
I say that such and such amount is due and owing to me, and please give me that money. And it was understood between.
How this court can, again the question is that how this court can.
I'll tell you.
I am referring you. You're giving. I am dismissing with the liberty to challenge before the appropriate forum.
Your lordship will invite
This court can, once the single bench has passed an order that has been affirmed, but giving some breathing to you that okay, if the representation be considered representation, you went to the Supreme Court. Supreme Court also said your representation. Now the representation is considered rejected. Again, the question is again the zero. Then it has to go to the contract.
May I?
Sir, just a minute.
Yes.
Again, we have to go into the contract. What is the contract condition? What is whether you have completed the work, whether you have not completed the work, whether the rejection is correct or not? How this writ court can do decide that?
Would your lordship kindly appreciate? I appreciate what's falling down from your lordship, my lord. Insofar as this is concerned, I am not venturing into the disputed questions of fact. There's one Supreme Court judgment that your lordship will kindly allow me to place before your lordship, where the writ courts can exercise jurisdiction in private realm. My lord, I'll place that.
No dispute.
I'll tell you, lordship, I am relying upon their own correspondence.
No dispute. But how this court can say, yes, you have not completed the work. Admittedly, work was awarded to you. Admittedly, the work was not completed within time. Admittedly, they have extended the time. Admittedly, you have not completed the work within the extended time. They have foreclosed the work.
Yes. Before the extended time expired, my lord.
Whatever it was, they have foreclosed the work. After the foreclosing of the work, you have made a representation. That was not considered, you filed the writ petition. This court, in the first round of litigation, stated that this is a disputed question of fact. It cannot be decided, dismissed. You went to the Supreme Division Bench has not gone into that, not disturbed the finding of this court, but given you the authority directed, okay, representation be considered. Then you went to the Supreme Court. Supreme Court also same, yes, representation. Now representation has been considered. Again the same, they will repeat the same thing and you will repeat the same thing. What is the
My lord,
change?
I'll tell your lordship, my lord. Just allow me to complete, then you can have. My lord, the question that really begs your lordship's kind consideration, while my lord's disposing writ jurisdiction, my lord, is can the state today act arbitrarily without any reason?
So there is
irrational-
arbitration clause.
There's no arbitration clause, my lord. There's a dispute
So
resolution clause.
go and
with-
file a damage. If suppose today this court held that yes, this impugn order is not in accordance with law, the foreclosure order was wrong. What this court will, that this work has already been completed. This court cannot pass any order.
My lord,
How this court can assess the compensation? Then
I am not asking your lordship to venture into any of that.
Correct.
Just a solitary relief, my lord.
What relief you
I'll tell your lordship, my lord. Insofar as, my lord, today my scope is very confined and I completely, my lords, abide by what's falling down from your lordship, my lord. Insofar as my representation is concerned, and qua that, the reply that has been filed by him, my lords, there is not a spectrum of reasonableness, consideration, application of mind. Your lordship will prima facie have that, my lord. I will, my lords, exercise my reliefs in courts of competent jurisdiction insofar as damages.
That's what I'm telling.
All of that is there.
You want seal of the court that order is wrong. Then taking into that sealed order, you will go to the civil court and say the already High Court has stated that it is wrong. Now you are entitled to compensation. You go and take the opportunity before the civil court.
No,
They will
if-
get an opportunity to
if-
produce the evidence and whether it's reasonable or not reasonable. Civil court decide.
My lord, to this limited scope, your lordship kindly, my lord, once for my sake, my lords, indulge me in this judgment once. Very relevant, my lords. Insofar as this issue is concerned, and the jurisdiction of the writ courts to venture into this, a contractual dispute, particularly, my lords. This, your lordship will, my lord, kindly, my lord. This is 2023, volume 2, SCC 703, my lord. Facts your lordship will have at paragraph 2, just one para. I'll trouble your lordship with facts so that your lordship has a brief backdrop on which the case is proceeded, my lord. The appellant, which is a wholly owned company of government of Madhya Pradesh, my lord, again your lordship will see is a government company, my lord, is responsible for the bulk purchase of electricity in the state of Madhya Pradesh for onward sale / supply to the distribution utilities. The appellant issued a request for proposal dated such and such for long-term procurement of 300 megawatts of solar energy through tariff-based competitive bidding. The bid of Messrs. Sky Power Southeast Asia Holding Limited was accepted. Same, my lords, facts. Yeah, it was declared the successful bidder for 3 units of 50 megawatts each at different tariff rates. The bidder subsequently incorporated the first respondent with Sky Power Southeast Solar India Private Limited as a special purpose company. This was for developing one project of 50 megawatts. The rate which is applicable in respect of the first respondent was such and such. So disputes arose between the parties insofar as this supply is concerned, my lord. Now your lordship will kindly have paragraph 12.
Paragraph?
Para 12, my lord. These I'll take your lordship to the submission, my lord. Very similar submissions to the instant case. Para 12, your lordship will have this, my lord, is at page 734, my lord. Shri K. M. Nataraj, learned additional Solicitor General, submits that the impugned judgments are clearly unsustainable. He would first point out that the writ petition filed by the first respondent is not maintainable. The PPA in question is not a statutory contract and therefore interference with the order terminating the contract was not justifiable. In this regard, he drew support from the judgment of this court in Kerala SEB versus Kuriani Kalathil. He would next contend that the PPA contemplated provisions to resolve disputes. He further contended that the first respondent should have resorted, if at all, to a civil suit to claim redress. He pointed out that a writ petition is a public law remedy, the contract in question not being statutory in nature, there was no public law element so as to justify the approach under Article 226. This is the exact submission that is being made by my learned friends here, my lord. Now, your lordship will kindly have paragraph 16. I am just taking your lordship to the relevant submission, my lord. Sri Nataraj would further submit that there is another vital circumstance which should have dissuaded High Court from granting relief. The case threw up disputed questions of fact. On the one hand, it was the case of the first respondent that the first
But
respondent.
problem is that here the one court has already decided and that has been upheld by the division bench up till the Supreme Court. Again, how this court can now it is maintainable?
Now, my lords, I'll tell you, lordship,
Tell
the
me.
relief sought
And
for
this
there.
judgment is which year?
This, my lord, is
2023.
2023 volume 2,
Then-
my lord. My lord, I'll tell you, lordship, this judgment precisely answers the query that is fell from your lordship. Whether the courts can exercise their writ
That's
jurisdiction.
correct. That's correct. But this judgment is before the judgment passed by this court, which was upheld by the High Court, which was upheld by the Supreme Court. Now, how this court can sit over the order passed by the coordinate bench of this court, which was upheld by this division bench?
Because my lord, the scope of my writ petition that was initially preferred is different from the scope that I've preferred from the scope of the instant writ petition.
Why?
I'll tell you, lordship, why, my lord. The scope of the instant writ petition, my lord, is limited to the representation dated 9th November 2025.
Correct.
I am not venturing into the contract, not venturing into the merits. What I challenged in the first writ petition, my lord will kindly appreciate, was the show cause notice and the order of penalty that was imposed upon me. The show cause for termination that was issued upon me. So the relief sought for, my lord, are not overlapping.
That's why, see, that was not decided by the court. Correct. It was a disputed question. On the basis of that cause of action, you file the representation before the authority. That's why the court stated that you go and representation become. If the representation has been dismissed, rejected, correct. Now you are challenging representation. What is your grievance? Again, the same grievance. That is illegal. That is illegal. If the same grievance that is illegal, then again come to the same, the earlier prayer. So how this court?
My lord, I'll tell your lordship, I completely follow what's following down from your lordship, my lord. The first set of reliefs that I sought for in my writ petition filed initially, my lords, that was particularly challenging the correspondences issued. Today, I'm not on that, my lords. I'm not even on the contract, my lords. I have nothing to do with that. I am just saying that the letter and spirit and the dictum of the order of the Honorable Supreme Court has not been followed by them. And it is duty incumbent
That's
upon
why.
them to do so.
What was your representation?
My representation was that you have failed to discharge your obligations.
Why?
Insofar as payment is considered,
Yeah.
so far design and drawing.
Cancellation of the
They
contract.
simpliciter give me a blanket representation saying no. I have done what is right, and this is the order pursuant to the order of the Honorable Supreme Court, my lord. All that I am saying today, my lord, is that can this administrative action not be gone into by your lordships, my lord? Can they give any representation under the sun that they deem fit? They have to comply, my lords, with Articles 14, 19, and 21, my lords. And particularly being state authorities, my lord. Lordship will kindly indulge me once with this judgment, my lords.
Okay, I will hear you. If this court will not satisfy, then you will ready with the cost. Yes, I will hear you. No problem.
Your lordship, in that event, my lords, will kindly indulge me.
I am
because
giving
tell
you. I have giving you liberty. If you are telling that you insisting upon the hearing, no problem. I will hear you. You argue the matter 1 month, 1 hour, 2 hour, whatever it is. I will hear them also. But in case this court not satisfied with your submission, then the cost will. Then I am telling you. Then you start the argument.
They cannot.
And then you start your argument. There is no problem at all.
But they are better advised, they at least withdraw, they get section 14 benefit
But
there.
they're not taking the benefit.
My lord, I'll tell you, at the end of the day, I am a creature of instruction, my lord. I am not here to pester your
I am
lordship.
not telling you. That's
My lord,
why.
your lordship will kindly appreciate.
You are the advisor of your client.
Yes, my lord.
You have to give the advice to the client.
I completely bow down,
Correct.
my lords.
I also appreciate your submission, but if I entered into the marriage and I pass, suppose the order passed by the authority is not in accordance with law, it is required to be set aside. What would happen?
Your lordship will not touch upon the order of termination. What your lordship will do in that event is direct them to pass a reasoned order.
Why?
That's the simplest.
How it can be? How it can? If
My lord, I'll tell you, lordship, why, my lord. Because that is particularly within your realm, my lords.
you take instruction,
Would it be your lordship's
if
pleasure
it's
to fix
not,
it on
if
any
you
day,
can,
my
you
lord?
take instruction,
Yes.
if even though your client is ready to giving instruction to argue the matter, no problem.
I
will
follow
give
that.
the hearing.
I
There's
follow
no
that.
problem.
I
There's no
follow.
problem.
I'm so grateful, my lord.
But this
Always-
court, kindly see that the burden of the court.
No, most definitely, my lord. It's always an honor, my lord,
No problem.
making submissions
But
before
I will give no time. If you're telling that you will argue the matter, there will be no problem.
In that event, my lord, your lordship
has to give the time.
Your lordship will kindly allow me to take instructions and come back on any day. Your lordship will have it on to be mentioned.
Come.
My lords.
Learned counsel for the petitioner has argued the matter at length. Pehले affidavit in opposition and affidavit in reply filed by the parties be kept with the record. Counsel for the petitioner has argued the matter at length, but he prays for time to take instruction. According cases adjourned, let the matter appear. একটা date দিন 12 p.m. I am fixing a specific matter. You come. If you are ready to argue, I will. 17 September at 2 p.m. 12 noon.
I'm so grateful, my lord,
Yes,
for the
next.
indulgence. Grateful.
Number 9.
Yes, who is for the petitioner?
I appear for the petition. I'm led by Mr. Bhattacharjee.
Yes.
So long he comes, we'll start with the argument.
What is the matter?
But we have challenged the MSME proceedings.
Huh?
The proceedings initiated under MSME Act.
Proceeding initiated under the MSME Act.
Yes, ma'am.
What is the prayer?
That was
What is the prayer?
for quashing of the entire proceedings. On the ground that MSME is not applicable to this.
Arbitration referral.
Yes, the reference.
Issued by the West Bengal Migrant.
The reference made to the tribunal and the entire proceedings.
Yes.
On the ground that MSME is not applicable to the respondent number 1. Namlet.
Who are you?
Ram Tamlet.
Director General of Police.
Yes.
Crime record.
Yes. There is an agreement for installation of wireless.
Have issued the tender notice for
Yes.
installation of
Wireless
wireless set. Wireless tower.
Yes, wireless tower and the service contracts also. Agreement is at page.
My lord, I am appearing online. I cannot hear. My mic is muted.
If your is kindly takes.
Now you are hearing. Now it is on.
Unstoppable.
Yes, it's on.
Yes.
My lord, I cannot hear. I'm not
Can you hear
hear
now?
anyone.
Am I now audible?
Check your system, madam. Here system is all on. Check your system, laptop or what you are using. Your junior is here.
My lord, I cannot hear anything. I am appearing in item number 9.
Ask check either
Your system is not
Laptop
working.
system
You see.
Log out once and then log in again.
Yes.
Can you hear me now?
Yes, I can hear now.
Yes.
Now let kindly takes up statement at page 26. This is the agreement.
Page 26 of the writ petition.
Of the writ petition.
Yes.
This executed was, this agreement was executed on like 22nd March 2019. First line.
Yes.
Now, let kindly takes up page 58.
So this was entered between the Kerala government and
this
Polbar
private
violation.
respondent number 1.
Polbar's violation. Yes. You are appearing for respondent number 1.
Yes.
You are appearing in person.
Yes.
Who are you? How you connected with the respondent number 1?
There are the managing part of the LLP company.
Respondent number 3, not 1. Respondent number 3.
Respondent number 1.
1 is the state of West Bengal.
Oh, I'm sorry, 3. I'm sorry.
3. You are 3. Respondent number 3. So you have given the authorization. You filed the
Have you given the forward on?
Have you filed the authorization? This is a company.
Yes.
You are one of the member, one of the director,
Yes, sir.
one of the director, one of the partner.
Yes.
So whether there is any resolution of the company giving authorizing you to appear in person and to contest this writ application.
This is handled by the lawyer previously. So I don't know what it give me.
No, otherwise the court cannot hear you as per the provision. If you are appearing in person, no problem. Welcome you to argue the matter. There is no problem. But that has to be recorded. Otherwise, if today any order is passed, tomorrow it will be caused by the appellate court. Unless and until you have to satisfied with regard to your personal appearance before this court, if it is a company, you have to come with the resolution authorizing you to appear in the matter and to argue on behalf of the company. Otherwise, tomorrow another director will say you have not been authorized. So what will happen? No, you Vakalatnama will not do because you are not the practicing advocate. You are appearing as one of the partners. So then the resolution of how many partners are there? 2. Then where is the resolution authorizing you? There can't be. You have a resolution of the company.
As I said, the lawyers were handling before. So I'm not. But I'm sure they will be there, sir. They are very forthcoming.
My lord, apart from the company, has been made as a party in person also. He is respondent number 4. And it is LLP, my lord, it is like a partnership firm.
Correct.
So he can represent the firm also because it is not a company.
No, there is a common affidavit.
Common
So-
affidavit. You are also what is your name? You tell that you are appearing in person. You have been made as a party respondent for. Yes.
Amlad is claiming that benefit of the MSME Act. So Amlad kindly takes up page 58.
This is an agreement.
Yes.
Correct.
Yes.
Yes. Then
what MSME registration was done
when?
on 22nd March 2022 at page 58.
Page 58.
Yes, ma'am. In favor of MS Kohli Brothers Wireless Solution LLP for manufacturing at the top.
This is a registration.
The registration of MSME.
Yes.
Of this LLP.
What is the date? 26th May 2026.
22nd March 2022 at the bottom left.
22nd March 2022.
At the bottom.
Yes. After the agreement.
After the agreement.
Yes.
Then work order was issued in 2019 at page 107.
Who is appearing for the MSME is a party here?
Yes, yes.
Who is appearing?
My
MSME?
lord, I am appearing for the MSME.
My senior is there.
Okay.
107 is not
07 is the work order.
work order, blood. Now kindly see the date, 22nd March 2019. Therefore, prior to registration.
Yes.
Now, kindly takes up the agreement clause of the agreement at page 36. This is relevant because he will be placing that.
Page 36?
Yes.
Yes.
Since long he is making submission that she is facing financial hardship. Clause 11. Payment will be made on percentage basis, 30% as advance, 50% completion of the payment will be made on successful installation of all equipments, and then 20% on successful completion of the project as decided by the Technical Evaluation Committee.
Yes.
As of now, we have paid more than 50%.
Just a minute. I will hear you. I will hear you. Yes. So 11 is the payment schedule. 30% as advance you have to pay, and 50% completion
After completion.
of the installation, all equipment, and 20% successful completion by the
This is
project.
yet to be done.
Correct.
According to
So
us,
how much payment you have made?
50%. But according to us, work is yet to be completed.
Yes. The work not completed?
No. And we have made request.
What is the time of mentioning the agreement for completion of the work?
It was 6 months, but it was extended.
Last when it was extended? Last extension?
That 20. Yes, my lord. So for the date is concerned, blood, I have
Initially 6 months.
initially for 6 months.
Where is which clause?
Blood, page 47 of the agreement.
Then where is the extension?
An extension we didn't annex possibly, millet.
Okay, lot extension till extended till
Fundamental question, the point that I will be arguing, millet, that has been recorded in previous order also, that if the registration is done subsequent to millet
that
agreement,
is the only question to decide.
and the second question is millet, the conciliation officer cannot be part of the millet arbitral tribunal. Millet. That is the second question. I'll be placing judgment on that.
That is pending before the Supreme Court.
No.
No.
That is not pending.
Okay.
Millet, this is the sum and substance of the facts, millet.
Yes.
Now, millet, kindly take some, millet, page 181. Because this is their case before the tribunal.
181.
180. The statements of facts that they have placed from their statement, I'll be placing one paragraph. Our team worked time from March 20 onwards and completed the setup for 4 temporary towers and were ready to showcase the trial.
What is this? This is reply. What is this?
No, this is the statement before them at MSME.
Okay.
180. 19.
Yes.
From this paragraph, only I'll be placing that according to them, the work was complete by 25th June 2021.
2021, yes.
Therefore, that is also prior to registration. Now, kindly take some judgment. I am not placing the other facts because this court will not ultimately decide the facts of the case. Only the jurisdiction of the MSME. Now, kindly takes up the law as of now settled by the Supreme Court.
Where is the order?
Reference. Yes.
So it was before the MSME
It was not the MSME.
MSME Facilitation Council.
Yes. Now, conciliation proceedings I have annexed at page 171. 172 is the decision. From here also, I'll be placing that who are the members of the MSME council. Kindly see at the second line at page 171, Mr. Alok Tibriwal
Member.
was one of the member of the MSME.
He has passed the order.
Yes, passed the order.
Correct.
Now, thereafter, it was referred to the tribunal. Now, kindly takes up page 263. This is the reference.
Two
263. Kindly takes up in the middle the name of the arbitrators. Because I will be placing judgment on these.
Yes.
Kindly see the third name is the same person at whose instance conciliation was done. Alok Tibriwal.
Where from your
The name of the arbitrator in the middle.
name of the arbitrator, West Bengal Micro Facilitation
Third line.
Council as will preside over the hearing of the ex officio along with the other members.
Third name.
Yes, Alok Tibriwal.
The same person. That is also my challenge. That there cannot be the same person at whose instance the conciliation was done.
Yes.
Now on fact, this is my case. I must submit to your lordship that judgment I am placing and the other judgments has now subject matter of consideration before the larger bench.
That's what I'm telling.
Yes, yes.
It is pending.
That has been recorded in the previous order also. Therefore, before the court, according to me, there is two options. Either to follow the ratio that has been decided or to wait for the larger bench. That is what I have understood from the other judgment. So this is 2023 6 SCC 401.
Yes.
Now at paragraph 11, issues are framed whether the provisions of chapter 5 of MSMED Act 2006 would have an effect overriding the provisions of Arbitration Act 1996. Whether the party to a dispute with regard to any amount due under section 17 would be precluded from making reference to the micro MSME
Facilitation Council.
Yes. Now, these are the reference. Now, court has considered the provision at paragraph 17, the definition of appointed day.
Yes.
to demonstrate this is prospective, not retrospective. Then my lord, straightway takes up paragraph 45.
Paragraph
45. There cannot be any disagreement to the proposition of law laid down in various decisions of this court relied upon by the learned counsel for the buyer that the court has to read the agreement as it is and cannot rewrite or create a new one, and that the parties to an arbitration agreement have an autonomy to decide not only on the procedural law to be followed, but also on the substantive law. However, it is equally settled legal position that no agreement entered into between the parties would be given primacy over the statutory provisions when the Special Act of MSMED 2006 has been created for ensuring timely and smoothly payment to the suppliers who are micro and small enterprises and to provide a legal framework for resolving the dispute with regard to the recovery of dues between the parties under the Act. Also, providing an overriding effect to the said law over any other law for the time being in force, any interpretation in derogation thereof would frustrate the very object of the Act.
Yes.
The submission, therefore, that an independent arbitration agreement entered into between the parties under the Arbitration Act would prevail over the statutory provision of MSMED Act cannot be countenanced. As the case as such, subsection 1 of section 18 is an enabling provisions which gives the party to a dispute covered under section 17 thereof. Now, that kindly takes up that page. This is where the how this court is answering the issue. Then page paragraph 49. One submission made by the learned counsel for the buyers was that if the party supplier was not the supplier within the meaning of section 2N of the MSMED Act on the date of contract entered into between the parties, it could not have been made reference of the dispute to Micro and Small Enterprises Council under section 18(1) of the MSMED Act 2006. In such cases, the council would not have the jurisdiction to decide the dispute as an arbitrator. At the juncture, the very pertinent observation made by this court in Shilp Industries case on this issue are required to be reproduced. In our view, to seek the benefit of the provisions of MSMED Act, the seller would have registered under the provisions of the Act as on the date of entering into contract. In any event, for the supplies pursuant to the contract made before the registration of the unit under the provisions of the MSMED Act, no benefit can be sought by such entity as contemplated under MSMED Act. While interpreting the provisions of the interest on delayed payments to small scale industries, this court in the judgment of so has held that the date of supply of goods service can be taken as relevant as opposed to the date on which the contract of supply was entered. For applicability of the aforesaid Act, even applying the said ratio also, the appellant is not entitled to seek the benefit of the Act. By taking recourse to filing memorandum under subsection 1 of section 8 of the Act, subsequent to entering into the contract and supply of goods and service, one cannot assume the legal status of being classified under MSMED Act 2006 as an enterprise to claim the benefit of retrospectively from the date on which the appellant entered into contract with the respondent. The appellant cannot become micro or small enterprise or supplier to claim the benefit within the meaning of MSMED Act 2006 by submitting a memorandum to obtain registration subsequent to entering into contract and supply of goods and services. If registration is obtained, same will be prospective and applies for supply of goods and services subsequent to registration but cannot operate retrospectively. Any other interpretation of the provisions would lead to absurdity and confer unwarranted benefit in favor of the party not intended by legislation. Following the aforestated ratio, it is held that the party who was not the supplier as per section 2N of the MSME Act 2006 on the date of entering into the contract could not seek any benefit as supplier under the MSME Act 2006. A party cannot become a micro or small enterprise or supplier to claim the benefit under MSME Act 2006 by submitting a memorandum to obtain registration subsequent to entering into the contract and supply of the goods or rendering service. If any registration is obtained subsequently, the same would have the effect prospectively and would apply for the supply of the goods and rendering service subsequent to the registration. The same cannot operate retrospectively. However, such issue
May I?
Now, the point is very simple and basic point. According to us, you cannot claim yourself to be MSE in respect of the contract,
Which was entered earlier. That's why I'm asking.
That's the for which I don't think that any judgment is called for. Statute itself would show. You will kindly come to the statute.
MSME Act আছে কি? কোথায় আছে? MSME.
আমি এক্সিকিউটিভ ডেট ফিক্স করে দিলে রাখি।
Yes.
Will kindly come to section 2. Subsection E. Enterprise means an industrial undertaking or a business concern or any other establishment by whatever name called engaged in the manufacture or production of goods in any manner pertaining to any industry specified in the first schedule. Then I am not troubling my the goods kindly come to medium enterprise. Means an enterprise classified as such under subclause III clause A or subclause III of clause B or subsection I of section 7. Micro enterprise means an enterprise classified as such under subclause I of clause A or subclause I of clause B of subsection 1 of section 7. Then kindly comes to Lord, the definitions of suppliers are given. Then question comes, who would be considered for MSME? Kindly come to section 8. A person who intends to establish a micro or small enterprise may, at his discretion, or a medium enterprise engaged in providing or rendering of services may, at his discretion, or a medium enterprise engaged in the manufacture or production of goods pertaining to any of the industries specified in the first schedule, shall file the memorandum of micro, small, or as the case may be, of medium enterprise with such authority as may be specified by the state government under subsection 4 or the central government so and so. Provided that, what is important, any person who before commencement of this act established, that here this was established before the commencement of this act, a small scale industry and obtained a registration certificate may at his discretion, and an industry engaged in the manufacture or production of goods pertaining to an industry so and so, having investment in plant and machinery of more than 1 crore, but not exceeding 10 crores, and in pursuance of the notification of the government dated so and so, filed an industrial entrepreneurs memorandum, shall within 180 days from the commencement of this act file memorandum in accordance with the provisions of this act. The form of the memorandum, the procedure of its filing and other matters incidental thereto shall be such
as may be notified by the central government. The authority which the memorandum shall be filed by medium enterprise shall be such as may be specified. Therefore, my lord, the only registration comes after he makes an application and gets, my lord, the registration.
That is the effect.
That's therefore, my lord, the MSME recognition would come only after, my lord, acceptance by the government. Here, admittedly, that this MSME, which he is now claiming, came into being as an MSME after the contract with my government already entered into and started doing work. Therefore, whether he can not get the benefit of MSME Act retrospectively. Now, my lord, the question came up before the Supreme Court very recently. I must be very frank to your lordship. Now, the two benches differed.
Yes.
And the latest bench said, though we are differing, but we are not sure, therefore referring it to the larger
bench.
That if the matter is now pending before the larger bench, that I would.
What would be the effect?
The larger bench now effect is not the court on this very same issue. Therefore, court would be little slow to give any opinion on this. Therefore, the matter, as per the amity of proceedings, should be adjourned till the larger bench decides.
Yes.
But these are the accepted forms and factual. And on merit, if your lordship kindly comes to the clause, which your lordship may be pleased to look into, the payment clause. That is that. Oh, well, I'm told it has been already placed.
Yes, yes, placed.
Therefore,
by which judgment by this judgment
yes.
only it was referred? No.
No.
Subsequent judgment.
Subsequent judgment. The issue, of course, was a little different. Whether supplier or anybody can go before the MSME benefit. And while dealing that, they say, this point comes to them, whether this is registered after this, the agreement.
After the agreement is entered and contract.
That would also come or not. That is the issue raised.
Must be the file.
Which one? The copy must be the file. Give a reference to follow.
Give the reference. What is the reference?
2025 SCC online.
2025
SCC online. SC 73.
73. Name of the party? Okay, I will see.
NBCC India Limited versus State of West Bengal and others.
Yes. Yes, who is appearing with the MSME, Miss? Where is Mrs. Manju?
I'm there. My lord, now all these points, my lord, have to be considered, my lord. Can we come back on tomorrow or day after tomorrow, my lord? Today I am not in Calcutta. So day after tomorrow, my lord.
Now, whether
because I have to consider these judgments and come back.
The question is that whether this court can proceed with the matter once the matter is pending before the full bench of the Honorable Supreme Court for deciding the matter.
My lord, that is why I am saying, my lord, let me consider those judgments, my lord, and then I shall come back day after tomorrow. I am not seeking for a long time, only day after tomorrow.
Yes,
because
sir.
So, I just want to submit Act under 2006, basically done to protect the MSMEs.
No, that's correct. Now, the question is that whether this court, once the matter is in session before the full bench of the, referred to the larger bench of the Supreme Court, how this court, which judgment this court can rely upon?
All the judgments are what we given to you by the role manager. Just take this particular one which is applicable in this case. Sir, the NBCC versus
Correct. That matter went to the Supreme Court and the Supreme Court has framed the issue and referred to the larger bench.
Correct, sir. But they've also said that if there's no stay on the matter, proceedings under the MSA council can continue.
True.
And so, just please allow me to clarify what they said for just so one thing what they said is that we supplied on 26 June, that is prior to the date of resolution. So what they failed to, and received as per their own judgment, writ petition of page 201. Sorry, sir, page number 202. They themselves are saying that as per R4 that we have completed we have finished the demo, etc. trial by 31/5/23, which in fact was done by 3rd and 4th of May 23. And they themselves have generated a verification report saying that demonstration trials were very successful. And now they are hiding, submitting this back to you that post 22nd March 22, when we got our extension, we complete to do the work. And sir, do you know what they have done to us, apart from other things? They could not give us the land to construct the tower. The final thing was stuck on one tower in a place called Mukia. So we had to buy the land from the local person and give it to the Kerala police. Then only the second thing they say they is not completed. Sir, they themselves in the verification report asked defense statement. They themselves said it has done very well, given a coverage of 90 to 95%. Sir, if it was not completed, how could I get a coverage of 90 to 95%?
Okay.
Sir, and if we see this judgment of NBCC, sir.
Give the citation.
In the NBCC judgment, sir, let me briefly just tell you, they identically same thing in our case. They went to the MSP council. Arbitration was announced. They filed a case in the High Court under the single bench of Justice Rajshekhar Mantha. We dismissed the petition, including disputed to the state. They appealed, went to the division bench, headed by Chief Justice Prakash Srivastava. He dismissed the plea, didn't give them a stay. They went to the Supreme Court, didn't give a stay. Sir, the point what I'm making, sir, they are the only company or organization who has got a stay in any of the courts of India. After going to the MSP council, it is just a delaying tactic to demand money.
Correct. See, now the main fact here, the issue is that whether you can claim the MSME once you have been registered after the work order is issued. That is the only issue. Correct. That is the only issue. Let the authority come. Let the authority come, and he will they may submit. The MSME authority will come and submit.
Here's the judgment of the very court. Justice Mausami Bhattacharya. Just read this court. Just only this.
So that can my judgment can override the Supreme Court judgment.
Supreme Court judgment says that, sir.
That's why what I am telling. That's why the MSME Council is telling that she will go through these judgments and she will make a reply. Okay, you are relying upon the NBCC judgment.
No,
which,
not even the Supreme Court judgment. So they have said very clearly.
Correct. Correct. I appreciate your act. Which paragraph you are referring to?
Sir, if you see the front page, I'll just show you.
You are not having the copy.
No, sir.
Take this. Which paragraph you are referring?
Sir, Justice Narasimha said very clearly.
Please not to name the Supreme Court judge before this court. Either tell the Honorable Supreme Court or tell the Honorable Apex Court. Not to address by name of the judge before this court. Of this court also. Not to address the name of the judges before this court. Yes, tell me.
So which paragraph I'll just tell you?
Which paragraph you are relying upon?
Second thing, sir. If you see there the writ petition, the 5-point objections they've done, everything has been answered. Everything, not one pending.
You do one thing. Come. When, madam, when you will be when will come?
Milord, kindly keep it day after tomorrow, Milord. By this time, I will go through the judgment and come back.
Tomorrow, come ready with the paragraphs and the one set of the copy of the judgment. What you are referring, mark it, give to the court. I will hear both of you and I will decide.
It will be 13th instead of 12th.
Sir, no, sir. Sir, please give it after tomorrow.
Very well, 13th.
13th. Come on, 13th.
And kindly fix a time, Milord, so that it becomes convenient.
No time.
Very well.
The counsel for the petition has concluded his argument. Full stop. Counsel for the MSME press for time to take instruction and to to give reply, full stop. The consequent, the private respondent appear in person and he has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 13th August within 5 matters.
Deeply obliged.
Yes.
One PM fixed matter. SIR matter.
Matters already named has been.
Item number 106.
Who is the part of it?
It's been included.
Record. Item number 106. It is submitted that the appeal of the name of the petition already been included in the total list. Accordingly, writ petition is dismissed as infractious.
Same for 124.
Just 107.
Same.
Same order.
Same order.
Same order. 107 means dismiss.
108.
107 is already included. Included. Same as 106. 108. Disposed of.
109, my lord, page number 31 is the appeal.
Disposed of.
10, my lord, page number 28.
Disposed of.
The scanned copy. The scanned copy.
111. पीछे क्या दूसरा वाला कहाँ गया? दूसरा एसईओ कहाँ है?
Which item has been called?
देख फाइन
Excuse me.
उसको सिखाओ ना कहाँ
हाँ बहुत
तो कैसे करो भेजूंगा
Page number 115 to
111
115.
disposed of
Scanned copy will be scanned copy.
112 give the
And 112 matter, I am for the petitioner matter, but this is not a SIR matter. I have been briefed yesterday only, but this is not the SIR matter. Can it be adjourned for a day matter?
तो फाइल को जो होगी उसको उठा के यहाँ रखो passport matter. Yes. Yes. Next. 100.
But the petition, my lord, page 38. Annex 36.
Next.
Petition, my lord, kindly comes to page 20.
Disposed of. Next.
Your lordship.
Disposed of. Disposed of. I could not hear you.
Two petitioners is paying additional court fee. Petitioner number 1 is the second independent candidate.
Second petition.
Second SLST impellent candidate.
SLS?
Pending. SLST.
I can't.
Secretary Purikha School Service Commissioner.
Secondary school education as a teacher.
Police verification is pending with regard to the petition number 2. For what? Which post? Which post?
School. Teacher.
Huh?
Teacher for.
Teacher. Item number 117. 117?
117, your lordship. Page
Huh?
number 31.
117. Counsel for the petition submitted. The petitioner number 1 name is appearing in the merit list for appointment of teacher, but due to the deletion of the name of the petitioner from the voter list, verification could not be conducted and is not getting the order of appointment. She submit that being agreed with the order deletion of the name of the petitioner from the voter list, the petitioner has already preferred an appeal before the appellate authority. She pressed for a direction upon the appellate tribunal for disposal of the appeal as early as possible. Consider the submission made by the counsel for the petitioner. This court find that due to the deletion of the name of the petitioner number 1 from the voter list, the petitioner is not getting the order of appointment to the post of teacher. Accordingly, the appellate authority is requested to consider the appeal of the petitioners and to dispose of the same as early as possible, preferably within a period of 2 weeks from the date of this. Next. Disposed of.
22 to 23, appeal page.
Disposed of.
It's a criticism.
Disposed of.
Yes, I am for the petitioner, page 39.
Disposed of. Disposed of. Disposed of.
On the petitioner, your lordship, already implemented.
For the petitioner, my lord, appeal is at page number 71, annexure P4.
Disposed of.
Page 47, your lordship.
Disposed of.
Page 49, your lordship.
Disposed of.
My lord, I am for the petitioner, page number 27.
Disposed of.
129.
Disposed of.
129.
Lordship, I am for the petitioner, Lordship, 130. My lord, 130, I am for the petitioner, 130. 130. Lordship, 130, I am for the petitioner. However, Lordship, my appeal is at page 39.
He is telling that it is not the SIR matter?
No, no.
You are telling that
130 though?
130.
SIR matter no hai?
130. Union of NESL.
Election Commission of India to.
अरे यूनियन में होती पर है ना और पूरा कारण नहीं तो
Lordship, he has mistaken.
Page number?
Page number, my appeal is at page number 39, Lordship. However, Lordship, I have applied for FPS dealership, Lordship. Now, Lordship, that interview is pending. My lord, that is the urgency, Lordship.
The petitioner submitted the petitioner has applied for the FPS dealership and the interview is pending, but the authorities are not considering the request of the petitioner for issuance of the dealership, FPS dealership to the petitioner as the name of the petitioner is deleted from the voter list. The petitioner submitted that the petitioner already preferred an appeal before the appellate tribunal and prayed for a direction on the appellate tribunal for disposal of the appeal as early as possible. Consider the submission made by the counsel for the petitioner. This court find that due to the deletion of the name of the petitioner from the voter list, the authorities are not considering the request of the petitioner for issuance of the license of FPS shop. Accordingly, the appellate authority is requested to consider the appeal of the petitioner dated 31st of March 2026 as early as possible, preferably within a period of 3 weeks from the date of receipt of this.
131 also, Lordship, same.
Same means?
Same means, Lordship, their husband and wife, they both applied for FPS dealership, Lordship.
Same.
And my appeal is on the same page, page 39.
Next.
133, Lordship, I am for the petitioner, Lordship.
132. Disposed. 28. Disposed of.
133, Lordship, I am for the petitioner. My only agency is that he is assistant teacher of the government school.
Disposed of. He's working. No?
He's working, Lordship. He's working. My appeal is at page number 48.
Disposed of.
For the petitioner, my lord, application page number 32.
Disposed of. Disposed of.
Yes, my lord. Page 40.
Disposed of.
Page 40. Page, my lord, 36, my lord.
Disposed of.
Page lord,
Disposed of.
139 petitioner is a legally entitled to family pension lordship. Legally entitled to family pension lordship.
That will decide. Disposed of. Disposed of.
32.
Disposed of.
And for the petitioner, your lordship 32.
Huh? Disposed of.
And the petitioner, page number 91.
Disposed of. How many petitioners?
3 petitioners.
Who are they?
They are all brothers.
How? In the give 143. Disposed of.
144.
144. Give the file. Disposed of. None appeal. Disposed of.
145. My lord. My page number 31, my lord.
Disposed of.
My petition, my lord.
Which one? Disposed of.
146, I am for the petitioner, page 34.
Disposed of.
Without 147, I am the petitioner. The appeal is at page number 6.
Disposed of.
150.
148.
162, सामने कितने लगा?
Disposed of.
149.
Disposed of. None appeal. Disposed of.
My lord. Page number 35, my lord.
Disposed of.
I am for the petitioner, your lordship, page number 32.
Disposed of.
I am for the petitioner, my lord. My lord, page number 42.
Disposed of. Disposed of.
154.
Disposed of.
155.
Disposed of.
156.
Disposed of. Disposed of.
58.
My lord, I am for the petitioner, page number 60.
Disposed of.
59.
Disposed of.
160.
Page number 29.
Disposed of.
161.
Page number 35, your lordship.
Disposed of. Of.
163.
Dispose. Others, how are they? Huh? Who are they? What will not do if they are not the relatives? Mother, father, brother, sister, it's okay. Vidhan Sabha, you go to the Vidhan Sabha. He's telling that from the same constituency.
Yes.
No. This court find that there are 7 petitioners have filed jointly the present date application. According, writ petition is not maintainable. Writ petition is dismissed. However, the dismissal of the writ petition will not prevent the petitioners to file their separate application if so advised. Next,
Page number 32.
disposed of. 165 others. No. Okay, yes. Disposed of. What is the urgency? Applied for assistant record and order. And the council for the petition submitted, the petition has applied for the post of assistant professor, but due to the deletion of the name of the petitioner from the voter list, the authority is not considering the request of the petitioner for appointment to the post of assistant professor. Council for the petition submitted, being agreed with the deletion of the name of the petitioner from the voter list, the petitioner has prepared an appeal before the appellate authority and the appeal is pending before the appellate authority. Separate for a direction upon the appellate authority for disposal of the appeal as early as possible. Consider the submission made by the counsel for the petitioner, and this court find that the petitioner is aspirant of getting the job as an assistant professor, but due to the deletion of the name of the petitioner from the voter list, the petitioner not getting the job. Accordingly, the appellate authority is requested to dispose of the appeal as early as possible, preferably within a period of 3 weeks from the date of receipt. Yes, next.
Appeal is at page number 33, your lordship.
Disposed of. Disposed of. Disposed of.
My lord, this matter, it says the NEET qualified student, my lord.
Huh?
NEET qualified student,
Ah,
98.7% has got, my lord.
correct.
And SDO is not giving any domicile certificate, my lord. And counseling will be start on 13th August. So it is very much urgent, my lord. Within 1 week, if it is possible to hear the matter.
The counsel for the petition submit that
Spoil, my
the
lord.
petitioner. Huh?
So within 7 days, my lord.
13th August. Today's
পাঠিয়েছি তোমাকে আবার পাঠিয়েছি
1 week. और क्या करते हैं?
আমি তোমাকে আবার দিয়ে দেবো
नहीं, वो तो चलेगा ना, एक ही दिन नहीं होगा, 1 week कर.
very very urgent oblige
Yes,
Yes, my lord. Page 16, my lord.
disposed of.
Page 13, my lord.
Disposed of.
Page 16, my lord.
Disposed of.
Page 16, my lord.
Disposed of.
I'm grateful, my lord.
Lordship, I am for the 175. There is an urgency, Lordship.
What is that?
Petitioner is a student of Arabic language in Kingdom of Saudi Arabia. Documents are annexed at page number 19 and 20. He has his return ticket on 17th of August. Passport is there, Lordship, but there is a problem at the immigration. If the AP card is not there for verification, that's why, Lordship, some urgent order may be passed. Page number 22 ticket is also annexed. Page number 1920 documents of his education at Saudi Arabia is annexed.
You are in Saudi Arabia.
At present in India. At present,
To go to Saudi Arabia.
he will go and his ticket is scheduled on 17th of August. That is page
17th of August.
17th of
How it
August.
is possible? The learned counsel for the petitioner submit that the petitioner is required to go to Saudi Arabia for higher education, but due to the deletion of the name of the petitioner from the voter list, the authorities, it is not possible for the petitioner to move out from the India, as the passport authority will not allow the immigration authority will not allow the petitioner to go out of India. Accordingly, counsel for the petitioner submitted, the petitioner already preferred an appeal, and the same is pending before the appellate authority. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to dispose of the appeal as early as possible, probably within a period of 2 weeks from the date of receipt of this order. Next.
My lord, I am for the petitioner, my lord. The petitioner herein is the NEET UG, my lord. Candidate counseling is on 13, my lord. Petitioner is not getting, my lord, his domicile certificate and non-criminal certificate, my
The
lord.
counsel for the petitioner submitted the petitioner is net qualified candidate, but due to the deletion of the name of the petitioner from the voter list, comma, the authorities are not allowing to appear in the interview. And full stop. See, submit that being agreed with the deletion of the order of deletion of the name of the petitioner, comma, the petitioner already prepared an appeal before the appellate authority and wait for a direction upon the appellate tribunal for disposal of the appeal as early as possible. Consider the submission made by the counsel for the petitioner. The appellate tribunal is requested to dispose of the appeal considering the emergent situation and to pass appropriate order within a period of 2 weeks from the date of.
Can it be, my lord, 1 week? Because, my lord.
Okay, 1 week.
Action upon the respondents to file affidavit.
Hmm.
Private respondent has filed, state has not yet filed. My lord, in the month of March, time was extended, but till date, we have not received any affidavit. If my lord
For the
considers-
state. Yes, filed affidavit.
My lord, so far, my lord, I have very limited number of papers. Many other papers are exchanged between the parties in the meantime.
Hmm.
My lord, I do not have a copies,
Hmm.
but my lord, I have a report which was submitted in the month of January, dated 8, 2026.
Hmm.
From where it is appeared, my lord, that the land where they have been running their business upon demarcation, that the land pertains to the irrigation department. And that report, my lord, affirmed by the state authorities.
No, if you tell that you will not file and you will go by the report, then I will record
But
the.
after considering the report, your lordship was pleased to give a direction for affidavits.
Many other, my lord, reports which were submitted in the meantime, my lord.
No other report, my lord, no other report.
Exceptions, affidavits. My lord,
Nothing,
I don't have
nothing.
any copies of the same also.
My lord, we have filed only petition and an exception to the report, nothing else.
Appeared for the first time, my lord. I do not have all the copies. But in terms of the orders passed in earlier occasions.
What can be done? See, in the month of June, other advocate had appeared before this court and on behalf of the state.
My lord, there is nothing else. We have served all the copies.
And the brief, my lord, was come from the legal remembrance, my lord. I was instructed to appear, my lord.
My lord, we have served copies of the writ petition, the report upon which Sudeepa Banerjee.
Search in the Sarthak, you will get this.
No, we have served upon the advocate of record who has been newly appointed.
My lord, then, my lord, I pray before your lordship. This is my humble submission.
All the documents have been served, my lord.
Kindly give me 14 days time, and my lord, I will file the affidavit, my lord.
The interim order is expiring on 13, my lord.
The petition counsel for the state respondent prays for time to file prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks after serving the copy to land counsel for the petitioner. The petitioner is liberty to file affidavit in reply, if any, within a week thereafter. Full stop. This is the matter. Give the date. 5th October at 2 p.m.
My lord, the interim order is expiring on.
Order is extended till the next date of hearing or until further order, whichever is earlier.
My lord, can it be extended until the disposal?
No. Come on that day, we'll see.
My lord, it's number of occasions when it's being extended.
It appeared from the report, my lord.
More than 20 times, I probably it has been extended.
Let. Yes, next.
Wait.
Item number 10.
This is my affidavit of service.
Yes.
It's a petitioner before you is the last stage of renal failure.
Hmm?
Last stage of renal failure. The doctor advised for kidney transplantation. Out of without family friend has agreed to give one of her kidney. Everything has been done. Domicile certificate issue. Only the kidney board hearing has been done before the kidney board. On the date of hearing has been done twice. That is firstly on 24th of March 2022 and secondly on 17th July 2026. Till date, my lord, they are on the date of hearing, they said they will not grant the permission. I am covered by your lordship's judgment, my lord. May I now place the documents, my lord?
What was the report? What they have stated during the inquiry? The statement recorded?
Yes, they have recorded.
Where is the statement?
The statement is not supplied to me.
Well, firstly, they are stating that there is an impugned order rejecting the transplantation of their kidney. That I could not find from the writ petition. Number
What?
The order which they are challenging, that somewhere it has been rejected.
No, he is telling that twice the meeting has been done, but they have not taken any, they have not informed the petitioner with regard to the decision.
Well, may I begin with certain facts?
I don't want any certain facts. Every day I am doing this matter. Only I want whether the authorization committee members have examined the donor and the donee and the relatives and the guardians and what is the statement before the authorization committee. That's only required.
Then, my lord, we have to come up with a report. But
That's why.
My lord, kindly appreciate if they are aggrieved by the report, then only they will come before your lordship.
So then you said that they are allowed, then you tell that yes, it has been allowed, instead of allowing, they have filed the writ application.
My lord,
Because I have done 100 matters coming before this court, in none of the matters your authorities are passing any order. When the writ petition is filed, then you persons are coming with the report, it's not recommended. It is the experience of this court, that's why I'm telling. None of the case authorization committee has passing any reason order, either rejecting or allowing. When the repetition is filed, then this court call for the report, then you are coming with the police report, you are coming with the verification report, you are coming with the authorization report, you are coming with the CD. Then telling that it has not been recommended. That's why I'm telling you file the report. The only the thing is that because it is not a relative, it is the family friend. It is a family friend that as per the act, he has to prove and he have to justify, yes, they have proved. So for that, they have executed the affidavit before the judicial magistrate. Now, what is the statement before the authorization committee? Because what the verification authority with you, the verification authority, what is the statement is making by the donor or the donor or the recipient, he is giving the report to otherwise. I examined two reports. I have set aside the verification report. I directed the matter to be sent to the authorization committee, and authorization committee is directed to consider the evidence recorded in the video clips. So that's why I'm telling you to before placing the video clip before this court, you examine the video clips whether the verification committee has correctly given the report to the authorization committee or not.
Very well, I will come up.
That is the only here, because every case, this is the lacuna.
Lacuna, but my lord, kindly appreciate, it is a statistics. World Health Organization states 5 to 10% of organ trafficking happens every year.
That's what, see, no. Your authorities has giving their conclusion finding there is no commercial transaction. There no commerce. Their authority and the police authorities are giving. There is no commercial transaction. If there no commercial transaction, now only we have to see what is to see whether they have established with regard to the relationship. Not the family relation. If it is the friendly relation, how they have established. That is to be seen.
A huge nexus. I am not going into the fact that whether
that with this court also knows.
Yes.
But once the report has come and you accepted, the court has to accept that.
Yes.
That's you first you call the report of the verification committee, you find it. What I am telling, the same thing you will find it.
Yes, maybe.
Correct.
May I hand over the judgment passed by in identical matter? This is same thing happened.
I know what are the judgment I have passed.
So for this matter is called the
Learned counsel for the respondents, the petitioner is submitted. In the case of the petitioner is that though twice the authorization committee held the meeting with regard to transplantation of the kidney of the donor to the recipient, but no decision has been taken by the committee. Learned counsel for the state is directed to file the report whether the donor, guardian, recipient and the guardian have been examined by the authorization committee or not, or whether any decision has been taken or not. If any such decision is taken and any statement is recorded through the video clip in terms of the act, the total and the report be filed along with the video clip before this court within 2 weeks.
Within 2 weeks.
Within 2 weeks.
It will be a hardship to the petitioner.
On or before आज कितना 10 है ना, on or before 21st of August 2026, after serving the copy to London counsel for the petitioner is at liberty to take exception to the report if any by 25th, leave the matter on 26th.
Yes, a bit only one thing, my lord. Can it be the last report?
What? That's correct. First, we have to see whether you have established.
But let them file instead of 2 weeks. Give me 1 week.
How the authority will
file?
When you applied for?
I have applied for 19th 2026.
Then
19th of January.
Then 8 months to just 2 weeks.
17 years Pramananda Maharaj, my lord.
That case also come. One of the donor has given the statement before the verification committee. Yes, I am not a friend, I am family friend, I am following so and so, so and so. That's I am intending to.
Your lordship knows.
That was the statement.
So far this case is concerned, there is
Come.
only
Yes, next.
1 week. I am praying for 1 week.
But not it, because I will fix, they will not. I know.
Yesterday done.
Yes, next.
Item number 11, my lord, I beg to appear for the petitioner.
Yes.
My lord, I'm led by Mr. Amit Ranjan Poti. I'll start the matter.
Yes, what is the matter?
My lord, the petitioner before your lordships, they are the committee members of Badhi Adharmara Forest Protection Committee. My lord, they have been taking care of that forest since 2014. My lord. Now, what has happened, my lord? They are the
Which
legal.
part of state you are?
My lord,
You are appearing.
Appear for private respondent, number 15 to 21.
Why private respondent here?
my lord, private respondent, my lord.
Why the private respondent the party?
My lord, I shall. My lord, the private respondents are the members, my lord, they have been the committee members of the Badhi Adharmara Forest Protection Committee.
Correction. Bandhi Forest Committee and Andharmara Forest Committee are two different committees which are not related to each other. We are the members of the committee of the Bandhi Forest Committee, and the petitioners, they are the members of Andharmara Forest Committee. They want to step into
my lord,
there is belonging to Bandhi Forest Committee. They are already the member of Adharmara Committee.
My lord, there is no hijacking happening. My lord, our names have not even been inducted, despite our.
Because they are not the member.
My lord, our predecessor in interest have been members for more than years, and upon their demise, our names have not been inducted. Subsequently, other legal heirs have been inducted. However, our names have been left out.
My lord, there is a report.
Okay, let me hear. Yes.
But this report is enough to show, my lord.
Show.
My lord,
Which
last
report?
2 pages are in Bengali. I have just given you exactly. They are the complainants in regard to Bandhi committee, and my lord, the forest officer says that they are not in any way connected to Bandhi committee, my lord.
Yes.
My lord,
where is the document? You are the members of the
my lord, if
Bandhi committee?
if that is the case, a meeting was held. A meeting was held pertaining to the induction of the petitioner's name. Kindly comes to the page number 75, my lord.
The Bangla language. There's no translation copy.
My lord.
Then how the court can?
May I humbly say this, my lord, one thing? Well, prayer B, my lord, they have prayed for a consideration of a representation made by them, my lord. Now, my lord, I have taken instruction, my lord, that pursuant to the representation made by them, a field inquiry was, my lord, conducted. I have the field inquiry report, my lord. If your lordship directs, I can come back with the report along with the annexures. Or in the alternative, my lord can direct the divisional forest officer, my lord, to give them an opportunity of hearing, my lord. And
if you already inspected and already
our report says, my lord, I have the report, my lord.
Which report? Order date? Report dated?
Report dated, my lord, 5th August 2026, my lord. This report I am handing over, my lord. This is without the annexures. I have the annexures as well. My lord, kindly seize, my lord. Second page, my lord. It says that, my lord, petitioners are not the registered members of the, my lord.
That's why this is given.
JFMC, Joint Forest Management Committee.
Correct.
And, my lord, paragraph number 5, my lord, of the report would say, as categorically recorded in the said field inquiry report, complainants, being the petitioners, are not members of the existing registered Bandhi JFMC, and it is recorded that there is no evidence or record available on file to establish that the petitioners were at any point involved with the forest protection work or wildlife conservation work.
Same thing is there.
Yes, my lord, this is, I have. My lord, paragraph number 2 of the report also stipulates that there is a resolution of 2017. It states that, my lord, a continuous period of 5 years of, my lord, association has to be there.
My lord,
So
we
there,
have been- we
there
have
is
been
no
engaged-
association.
Okay, do one thing. You file this report along with the annexes, serve the copy to them. They will file exception to the report and this will be disposed of. No problem.
My lord, I have
Because
been-
see, you are already inspected, taken the decision. Now referring the same thing will happen, then again they will come.
If, yes, my lord, if
I have-
any exception, they can.
They can
My lord, I have
give the
only one
exception, I will
humble-
file the exception, and I will decide the matter once for all. Let they file whatever.
One humble submission regarding to the referral of 5 years being in practice. My lord, I have already
Madam, there is a report from the range officer. You were not in the property, you're not,
My lord,
not
I'll come with
executed any work for the purpose of
with you.
this, correct?
I'll
So
come
let
with
they file the report,
I
you
will.
take the report, you file the exception,
My-
and this court will decide on merit.
My lord, I have one more submission, humble submission. My lord, since showing this writ petition where there is no stay, nothing, my lord, our usufructs have been held by the forest committee, my lord. Those may kindly be released for the time being.
Council
My
for
lord, that
the
is under question.
Council for the state submit that inspection has been carried out by the forest authority and the report is ready, but the enclosure is not available. Accordingly, press for a week time to file the report along with the enclosure after serving the copy to the land council for the petitioner. Land council for the private respondent has handed over a document, a letter issued by the range officer dated 10th of February 2026, wherein it is mentioned that the complainants are not the member of existing registered Bindi JFMC, and there is no evidence or record to prove the complainant are involved in the forest work, wildlife conservation work. Full stop. In view of the above, the state authorities are directed to file a comprehensive report along with the annexes, if any, within a week. Within a week after serving the copy to the London Council for the petitioner. Full stop. The petitioner is liberty to take exception to the report, if any, within a week thereafter. Full stop. List the matter on 27th of August 2026 under the same heading. Within 10 matters. It is made clear that this court has not passed any type of interim order in the present writ application. Has not passed any interim order in the present writ application. Yes. I clarified, no interim order is passed. Let a file the affidavit, report, you take exception, then we'll see to that.
Well, my lord, my read is very simplistic.
That's why,
And the consideration.
that's why they are filing the report that you are not the member. Let they file the
I
affidavit.
am not even a member. I am admitting that. fact.
Let the
That is
report
the
come.
reason I want to incorporate in the
Okay.
beneficiary.
Okay, let that come.
Great.
Yes, next.
Well,
This is my application. It is for all. For the bank.
Respondent number 5.
My lord, on the last occasion, I have submitted it to lordship.
Yes. Yes, any order is passed. Madam, who is appearing?
I appear for the board, my lord. Show cause notice is at page number 40, to which he has given his reply, my lord, which is, my lord, will find from page number 42. My lord, will remember the other day we did that matter where we showed, my lord, section 218, investigation, inspection. So it was only for the purpose of investigation and inspection that the show cause was given. He's given his report. That is to be sent to the disciplinary authority who will give him a hearing. So, my lord, that we'll need 2 more weeks for the disciplinary authority to be constituted. We'll give him a personal hearing, my lord. We'll pass the final orders, my lord. My instruction is within 6 weeks.
Very well.
giving
Then, my
the
lord,
hearing.
this 102 in the interregna, how they are issued? May I put this question?
My lord, why?
That's why I'm asking. Kindly come to 102.
My lord, that suspension. My lord has the book.
Which book?
IBC.
Yes.
My lord will kindly take regulation 23A.
Page
So
kota
that ballot probably will be at page number 342 if we have the same book. My lord, this is 342, probably, my lord. This is, my lord, the
Rule, which IBC regulation?
my lord, this is the model bylaws and governing board of
No,
insolvency.
regulation?
23A. My lord, there are several regulations. So, my lord, will kindly take the model bylaws and governing board of insolvency professional agencies regulation 2016. My lord, may I then hand over this book?
What is the number? What is the page?
My lord, mine is 342.
342. Let me check.
No. IDBI inspection.
IDBI insolvency agency.
My lord, will kindly give me my lord's book 1 minute.
Check it.
Inspection and investigation.
Inspection, sir. এটা হলো অন্য আপনার
কোনটা? Regulation 217 bankruptcy board.
এইটা দেখুন Yes, my lord is at the same page. 23A. Sorry.
Was it solo?
My lord, will kindly take 23A. Authorization for assignment shall stand suspended upon initiation of disciplinary proceedings by the agency or the board as the
Authorization is suspended, but kindly see here. What is the status of the AFA suspended?
AFA, that is authorization for assignment. AFA is authorization for assignment.
Okay.
My lord, this, my lord, came up for here under challenge before the Honorable High Court at Madras. My lord, may I just hand over the copy of this judgment? Sir, sir, 23A.
পাচ্ছি না ভাই তোমার বইটা একটু দাও তো
Yes. My lord, this came up for, my lord, consideration before the Honorable High Court at Madras. Venkata Shivakumar versus the IBBI, my lord, that had come up. Here, my
You
lord,
are appearing for whom? Respondents?
I am for the board, IBBI. 1, 2, and 3, I guess. 1,
Yes.
2, and 3. Now, my lord will kindly take, my lord, here it was the same thing. Suspended, his AFA stood, my lord, suspended also. My lord will kindly take, my lord, this is not paginated, but my lord will kindly take last 7.1. My lord has found that 7.1. Grievance of the petitioner is that the board as well as the professional agencies initiated parallel proceedings in respect of the same action. And if the same punishment imposed twice, it would be double jeopardy. Applying principles in disciplinary proceedings on the basis of rule of issue, estoppel, and lack of authority under the relevant service rules, a second punishment would be bad in law. But the very provision of the twin tier control will not give rise to illegality or presumption of double jeopardy. My lord will then skip that. My lord will then come to. My lord will kindly come to. My lord. 8. My lord, after 7.5 comes to 8.
Yes.
As regards the challenge to bylaw 23A, earlier the petitioner challenged regulation 7A, including on the self-same ground of twin tier control. When it comes to the constitutional validity of the self-same regulation, petitioner cannot pick and choose the particular regulation one after the other on the same grounds or different grounds and repeatedly file with petitions. If aggrieved, petitioner ought to have challenged the vagaries of bylaw 23A when he filed the earlier petition challenging the other provisions of the self-same regulation, and filing of the repeated petition would be barred by the principles of res judicata. More specifically, the issue of twin control has been specifically decided by this court who are the same parties. The entire provisions of the code was upheld by the Honorable Supreme Court in Swiss Ribbons versus Union of India. That portion has been quoted. Recently, the Supreme Court of India decided the constitutional validity of Section 96. This is with regard to the personal guarantee, my lord. My lord will kindly skip that, but then my lord will see. We have accordingly answered the writ petition as barred by the principles of res judicata, and the same is also without merit, as we have declared regulation 23A to be intra vires and petition and the writ petition so and so without any merit, and another unsuccessful successive challenge to the constitutional vires of the code. So, my lord, this was held to be intra vires. They had gone up, my lord, before the Honorable Supreme Court. Supreme Court refused to interfere with this.
Yes.
And my lord, the questions of for the writ petition, whether 23 is intra vires or not, is my lord at paragraph 5.1, and my lord, it is directly dealt with in 6.1 apart from paragraph 8. 5.1, my lord will see 5.1.1, whether bylaw is liable to be struck down as manifestly arbitrary, conferring unbridled excessive power on the insolvency professional agency, and 6.1 answers that. There is no discretion vested with the IP, and the suspension is automatic once the disciplinary proceedings are initiated. Therefore, it can neither be termed as manifestly arbitrary nor be challenged. And thereafter, my lord, it also refers to in paragraph number 8. These are the. So, my lord,
Yes,
this
sir.
is. Yes, sure.
Now, my lord, this regulation, I don't know how it is helped my learned friend, because this regulation she has indicated 23A. Let me go there first. The authorization for assignment shall suspended upon intimation of disciplinary proceeding by agency or by board, as the case may be. Now, my lord, here one order has been passed by the NCLT that they will withdraw the complaint.
Yeah.
That is the stand of the and the court said, you upload this, then I shall pass the order. Then the court passed the final order, releasing me from this, accepting my resignation. That's number one. Number, after all this, how this lies? May I put this question to myself?
But whether the discipline proceeding initiated against?
No, nothing.
That is the reason why investigation and.
Nothing. Now your lordship can see, when the disciplinary proceeding initiated, your lordship can see, a disciplinary proceeding shall be considered as pending against the professional member from the date he has.
Correct. The agency may initiate disciplinary proceeding.
Agency.
Yes.
This is not the agency. I am not the agency.
The agency may initiate disciplinary proceeding by issuing so-called notice against the professional member. Correct. And 23, the authorization of the assignment shall stand suspended upon initiation.
Agency, not the board.
Yes.
Not the board.
So,
but now, here, State Bank is the agency, corporate agency.
Correct.
No, complaint is Magnum. State Bank is the main the complaint. And moreover, what I have done, the reduction, that your lordship, if your lordship kindly come to their investigation, the notice of investigation, that is page 40. Page 40, your lordship kindly come. Yes. Your lordship kindly see here. The notice is issued in pursuance of the powers conferred upon the undersigned to conduct an investigation in the matter of Mangalam Fiscal Services Private Limited under the Insolvency Bankruptcy Code 216. Herein I refer to IBC. The Insolvency Bankruptcy Board of India Inspection and Investigation Regulation 2017. The communication serves as a notice under Regulation 8.1 of the Inspection Regulation. It has been noted that CRIP of CD was initiated by the order dated 3/10/2023, and you have reduced the voting share of SBI and refused to include the agenda of replacement of the liquidator. Now, this particular order is under challenge before the NCLT. It is pending since 2025. Now, when a particular order, which is the genesis of the investigation, is under adjudication before a court of law, competent court of law, who is the authority to investigate, to take up the issue as per section 60 of the code. Now, after that, the issuance of this notice of investigation
No, after this sort of what has happened?
He's given his reply.
After 40, page 40.
After 40, I have given my
You have
reply.
given the reply.
I have given the reply saying that the matter is pending before NCLT. I have stated, indicated page 42. I have given.
And this investigation is conducting by the IBBI.
Yes, and then they issued the show cause notice.
Yes, show cause notice.
Show cause notice on 30th March 2026.
Correct.
So 2026.
Correct.
Now I have given my reply.
Yes.
Now, my dear Lordship, kindly come to section 220. তোমার বইটা ধরো। আচ্ছা বইটা থাক একটুখানি এক মিনিট।
Yes, 228.
Section 220, your Lordship kindly come. This is the particular section for apply for me. From 217 onwards. Now, my dear Lordship, kindly come to section show cause notice to the service provider, where 219, where the board upon completion of an inspection or investigation under section 218 on the basis of the material available on record is of the prima facie opinion that sufficient cause exists to take action under.
So, okay, you issued the show cause note, reply to the show cause notice.
I have given.
Correct. What has happened after that?
Nothing.
Disciplinary proceeding and the appointment of the committee has not been appointed.
No.
Committee appointed, we'll have to give him we are within 2 weeks.
I don't know, because maybe committee appointed after I filed this petition. Prior to that, no, nothing has been done. From March.
No, if the disciplinary proceeding committee has not been appointed, how you can say the disciplinary proceeding is pending?
With the inspection and investigation.
Inspection and investigation, issuing notice to the person concerned for collecting the document, correct, and recording the evidence. After collecting the document and the evidence, if you find that yes, case is made out, then it will go to the kindly come. Yes, that is a regular.
That is his admission.
No, here kindly come to the 220, 280, 17.
217.
217.
No, it's probably 218.
Sorry, 218.
Where the board on receipt of a complaint
Yes.
under section 217, Madam will kindly pause here for a moment.
Yes.
We have received the complaint
Yes.
from SBI.
Yeah.
Or has reasonable ground to believe
Yes.
that any insolvency professional agency or professional
Mm.
has contravened any of the provisions of the code
Correct.
or the rules or regulations made or directions issued, it may at any time by an order in writing direct any person or persons to act as investigating authority
Correct.
to conduct inspection or investigation.
Correct.
Then, my lord, will kindly also read
Then,
on.
then you come to the 220.
220.
220.
Court shall constitute a disciplinary committee to
To
consider the reports of the investigating authority.
Under 218.
Yes.
Report submitted under 218.
218, we have given him the show cause.
Yes.
He has given the reply.
Hmm.
The opinion is formed and sent to the board who appoints this disciplinary
Correct.
committee.
Ah.
So, my lord, this disciplinary committee will have to give him a hearing, which we are willing to do within 2 weeks.
Correct.
We'll fix a date and call him.
Correct.
And thereafter, my lord, give the final speaking order within 6 weeks thereafter.
Correct. So now, if the disciplinary proceeding kindly come to then 23A.
Yes, my lord.
23A. That the agency may initiate the disciplinary proceeding by issuing so cause notice is issued.
Yes. Now, my lord, will kindly see authorization assignment shall stand suspended
Suspend.
upon initiation.
Correct.
So, this initiation starts with the investigating and
No. Show me law. Why the appointment of the disciplinary committee? Investigation and inquiry is other than the disciplinary. If prima facie find, then the disciplinary committee. 218 is only inquiry and investigation.
Prima facie.
That cannot be the disciplinary proceeding.
My lord, but one thing, my lord, will once come to page number 42 of his. At the bottom, my lord will kindly come at the bottom.
Yes.
If I have, my lord, 2 paragraphs just before the page ends.
If I am wrongly.
If I have been wrong, please punish me. But if the behavior of so-and-so has been unprofessional, IBBI needs to take steps and make them understand that IPs are qualified professionals worthy of being rejected. He has, my lord, if I can read from the beginning. Third paragraph, from files handed over to me by the erstwhile liquidator, I saw recordings of earlier meetings where bank was adamant in not taking me and were casting baseless allegations. On learning of personal level animosity, I called so-and-so and volunteered to move out. This was not to be. I was not allowed to take possession. Stop from posting security guards. Anguish stems from the fact that so-and-so SBI, one of the financial creditors, and no funds were released under 2. Then NCLT came to my rescue and threatened FCs to remit funds to liquidation into the liquidation account. 5 years have gone by and I share so-and-so. Frankly, I would volunteer to resign as liquidator, but if I do so, SBI will never pay the advocates. Financial creditors are in total violation of the order. If I have been wrong anyway, please punish me. There has been an almost admission to that. And
No, admission, whatever it is. Now the here is the point. Here the point.
have been given.
Correct. You have issued the so cause.
My lord.
200. Then if the inquiry after the inquiry report and after the so cause notice, if the authority finds prima facie, then the disciplinary proceeding will be started. Where is the finding of the disciplinary proceeding?
My lord will kindly take. My lord will kindly take page number 44. This is the show cause. After the investigation and inspection, this is the
Correct.
show cause. To which, my lord, he gives a response at page 51.
Yes.
Now, my lord, after this page 51, my lord, we have to give him a call for attending the personal hearing. And that would be by the, my lord, the disciplinary committee. So, my lord, this is a continuation of the entire proceeding, my lord.
Certainly not.
And then,
Now then you come to the act code. Then you come to the code.
yes, my lord.
Court, kindly read the 218. 218 only the investigation, inquiry and investigation.
My lord.
Correct.
My lord.
The person.
Thereafter, my lord will read
Then
2219.
yes, 219 so cause notice.
Yes.
So cause notice issued.
Yes,
So
ma'am.
218 you have completed.
218 I have completed. 219.
219 you issued the so cause notice.
My lord.
Then the appointment of the disciplinary committee.
My lord.
Appointment of the disciplinary committee to consider this report. Whether the so where is the committee constituted?
That constitution is yet to take place, my lord.
Then
It will
if
be
the
done.
disciplinary committee is not been constituted, now then you come to the regulation which you have shown.
23A.
Yes, 23A. 23A.
This is upon initiation.
Yes, initiation disciplinary proceeding.
By
Disciplinary
agency
proceeding
and
means
so on.
disciplinary proceeding when it starts.
When the-
Issuance of charge sheet.
My lord, here there is no charge.
No charge sheet. Whatever allegation you have to give. What the
Allegations have
disciplinary?
been given in
No,
the
no, no.
clause.
What the disciplinary procedure committee will do?
My lord, we will now consider his reply to the show cause, give him a personal hearing on the point that we have raised, and give the final order.
Correct.
My lord, that flows out of the 219. 220 would flow out of 219.
Correct. I didn't dispute. Then why the 220 appointment of the disciplinary committee?
CA does not say only by the upon initiation of disciplinary proceedings.
Initiation, my lord, comes 220. Kindly read 220 the board because this till 219 there is a board.
Yes.
The board will issue the so cause notice. Correct.
Right.
And the has to submitted all the documents. That is the inquiry and investigation.
Yes, my lord.
Then the board shall constitute disciplinary committee to consider the report of investigating authority.
My lord.
So in considering of the investigation, so investigating is the investigation is different. That disciplinary committee is a different.
Committee is different, my lord. But
Correct.
this says 23A says
Ah.
upon initiation of disciplinary proceedings,
Correct.
which had started with the show cause. Initiation, my lord, not initiation of disciplinary committee. Initiation of disciplinary proceedings. Proceedings would start from
My lord, this provision is redundant. Then this provision is redundant. That privacy opinion. That disciplinary proceeding will start.
And my lord, my learned is right. My lord will kindly see 23. Agency may initiate disciplinary proceedings by issuing show cause. So I have issued the show cause just before 23A.
Yes, that's right. Privacy opinion has to be held for issuance of disciplinary proceeding.
It's been done.
Where is that privacy opinion? May I put this question?
No, but 23A, kindly read. The authorization of assignment shall stand suspended upon initiation or discipline.
The initiation.
Just by the agency or by the board. Because this so-called notice by the board.
By the board, no doubt, no doubt. And your lordship can see in the discipline, in the order itself, these 216 code has not been referred. The reference has been given.
Not necessary.
The reference has been given in respect of all this.
Not necessary.
And moreover, your lordship can see that this.
Madam, code has also.
Then, your lordship can see page
That's why.
49. Page 49. Whatever written here, if we take it that, then there is nothing. B.
Madam, this is between the bank and him, not with the board. This is the complaint we had received and therefore the investigation we started.
No,
We
then
have-
again the one question.
My lord.
Who is the complainant?
Bank.
The bank.
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 If the bank has withdrawn the complaint,
It is
No, we are not withdrawn the complaint.
what is stated here?
No, this is a so-called notice, my lord. There is some wrong recording, my lord. We cannot humble submission.
No, kindly see. Senior senior counsel DN Mr. So-and-so assured that
So-called notice will be
upon the liquidator will be unconditionally withdrawn by the.
No, my lord, this fact, my lord, show-cause cannot. My lord will kindly come to page 97 once, my lord, and just show that order. We said that the complaint has to be there. My lord will kindly come to the order, page 93, the order start of, yes, para 70,
Which page?
97. This is an order of 9th of June. My lord will kindly read, and my lord, I am making submissions to that effect. Further, the SCC of Mangalam Fiscal so-and-so through State Bank submitted that they will not withdraw the complaint before the IDB.
Then,
But will unconditionally withdraw the show cause notice issued.
Well,
My
what
lord,
does it mean?
Issued by them.
Yes, my lord, it's a fallacy, my lord. Whatever, it's a wrong recording, maybe. We
What
are not
does it
accepting, my lord, but there's a wrong recording to that effect.
They cannot.
Show cause I cannot issue because I'm not the issuing authority.
Madam, they cannot.
Maybe,
Show cause issued by me.
maybe, but
have
this is
said
the
complaint has been made.
against this order, nothing has been done before the NCLAT.
And the matter is pending, even listed today before. the-
And your lordship can see that the thing has been challenged before the NCLT. And NCLT.
So now they are now initiated the discipline, then you go proceed with the matter, give
We
the
will
reply.
give a hearing in 2 weeks, madam. That is my
And
instruction.
complete what can be done. What this court can do, because the pending discipline. You have not challenged the proceedings. You have not.
No. Your lordship can see before the NCLT, it has been recorded that they will withdraw the show cause.
Correct, show cause, not the complaint.
So show cause. Now, my lord,
Because they cannot issue the show cause. Show cause
They-
is
they cannot
IBI,
issue.
IBBI.
But till that, it has not been clarified before the NCLT. Before it has not been. And your lordship, if your lordship
No,
kindly have a glance,
the order itself says, kindly read.
if your
Kindly read the order, sir.
if your lordship have a glance,
Unconditionally withdrawn the, given the facts and yes, so cause notice upon the
now
liquidator
your
will be
lordship can see that page 96 of the order,
Yes,
paragraph 11.
yes.
The applicant contends that while liquidator acts independently, successfully liquidation necessarily requires constructive coordination with the stakeholders. Further, that the stakeholders have overwhelmingly lost confidence in the existing liquidator. Continuation of the present arrangement would only impede efficient liquidation and diminish the value of assets with the passage of time.
Yes.
It is further contended that present application is not founded upon any personal allegation but upon larger interest of efficient administration of liquidation, coordination handling of interconnected group entities, and expeditious realization of the assets. The applicant states that Mr. Vijayendra Sharma, insolvent professional having registered or submitted a written consent, then what express then further paragraph 16. Further, the liquidator has also expressed his unwillingness to continue with the present assignment and seeks to resign. And for that, file application being I number at2.
Yes.
Further, SCC, Mangalam Fiscal Private.
So now what you have prayed for? What you have prayed for in this writ petition? What is your prayer?
Well, here, the prayer is for stay of the operation of this.
My lord, page
Uh,
26.
This is the ad interim order, page 29.
No, what is the main prayer? Including the impugned so cause notice, how this court can now, because you have already issued the so cause, reply to the so cause notice. Then as per the 220, the proceeding is to be concluded.
Number here. First of all, in my book, I did not find this 2016 bylaws. Whatever I have found, 2016 bylaws, they are 23A is not there. I am showing to your lordship.
Take this.
Your
take
lordship,
this. I am giving my book. Take this.
No, 1 minute, your lordship, kindly.
2019.
No, it is current book, 2026.
That's 2019 amendment.
2026, 2026. Whatever bylaws is there, but that 23A is not there. That I am surprised. नहीं भाई কোথায় দেখাও তো
আপনি না দেখে আমি
Which?
It is better to you appear before the disciplinary authority. If personal hearing is given, then whatever the evidence.
What is the chief has been given the power. The disciplinary proceeding shall be considered as pending against the professional member as long as he has issued the show cause notice by the agency or the board, as the case may be, till the disciplinary committee or agency of the board, as the case may be.
But the explanation is there to train.
Explanation is that disciplinary proceeding shall be considered pending. It is pending. It is pending.
Shall be considered pending against the. That's why.
That's pending. And I have given answer to the so calls.
So let they conclude.
Already.
Let they conclude.
This publication in the website, it's not correct. That is not correct.
After coming, after this all online process, this is the thing.
No, your lordship can
So,
see.
Lord, this particular person will be appointed pan-India.
No. The 23A, the authorization for assignment shall stand suspended upon initiation or dismissal by the agency or by board, as the case may be. There must be order. There must be an order. If no order is passed, because your lordship can see.
No, then you come to read 218 read with 220.
Yes.
218 to read with 220 section. 218 inquiry investigation, then 220 the disciplinary proceeding.
Yes.
So notice issued.
19 notice.
19 so cause, then 20 disciplinary proceeding.
In fact, with 19 only the.
No. Your lordship can see. I have seen in the service matter, the same procedure is being followed. What the service matter says, service matter indicates first they are the so cause. Now here the so cause amounting to charge sheet.
Yes.
The investigation notice is the so cause.
That's why you ask, because now the disciplinary authority only will give the personal hearing and pass an order.
Yes.
Not as a disciplinary proceeding, again the witnesses to be examined, cross-examined.
Nothing. Now, here, the notice of investigation can be treated as this show cause. Then the issuance of show cause can be issued. Then, my lord, an order has been passed by the appointing authority that privacy we have found that a disciplinary proceeding will be initiated.
No, then they will issue notice to you, personal hearing.
No.
That's why.
Not only that. Prior to that, there is an order passed by the board. Board will pass the order. This is because this sentence says the authorization for assignment shall start upon initiation of disciplinary proceeding by the agency or by the board as the case may be. Now, my lord, here the order because here your lordship can see 220 sub clause 1. Initiation will constitute on the disciplinary proceeding when the consisting of disciplinary proceedings will be there. Because board will pass the order saying that this disciplinary proceeding has been consistent.
Then the 22.
23 has to be read.
22.
22.
191. No, then section 220 sub clause 2.
220 sub clause 2, yes. Then 220 sub clause 2. Here, Lord, can you see the show cause notice issued under shall be referred to a disciplinary committee.
191. No, 220 sub clause 2. On examination of the report of the investigating authority, if the disciplinary proceeding satisfied that sufficient causes exist, it may impose penalty and so on. So there are before that personal hearing.
Is it? Now your lordship kindly see here the board will constitute the disciplinary committee. All right. In the order passed by the board constituting disciplinary committee will indicate the
charges.
What they have said in 219. Your lordship kindly see 200 what the board of completion of investigation, inspection or investigation under section 218 or on the basis of material available on the record is of the privacy opinion that sufficient cause exists to take action under section 220. There must be an order to that extent. There is a privacy satisfaction, sufficient cause exists under that the 220.
Then you have to challenge that. If they will initiate it, then you challenge that. Where is the privacy satisfaction? You not challenge here.
Because no, here is because prior to that, no communication has been given that the because that stage has not yet come. No communication has been given that this is because what I try to infer that the initiation of disciplinary proceeding that has to be read with this.
Okay, then come. What can be done?
Yeah.
So what do you want now?
Number here, your lordship certainly may not be inclined to pass any interim order in my favor. That I understand. Now, that I understand because madam, I am here for 42 years. I am going to complete 42 years. This
correct. That is a senior and experience.
So madam, I will not repeat all these things. Only thing I shall say that there is no privacy satisfaction regarding initiation of disciplinary proceedings.
Then I am keeping pending. Let they start. Then you challenge that, or you withdraw. Then you challenge.
No, your lordship can keep this matter pending. Only thing, let them issue the this formation of disciplinary committee. Then I shall see to it. If I see, because now I cannot take any work.
Counsel for the
and I have only I am now 69 this year, up to 71 year left. Most likely completion of disciplinary proceedings and other things, 1 year will cross.
The petitioner has challenged the authorization of assignment, wherein the petitioner has been shown as suspended. The learned counsel for the board had drawn the attention of this court to rule 23 capital A of, what is the rule? What the rule says?
Starts
Of the Insolvency and Bankruptcy Board of India within bracket model bylaws and governing board of insolvency professional agencies bracket close regulation 2016 and submits that as per the said provision the authorization for assignment shall stand suspended upon initiation of the disciplinary proceeding by the agency or by the board as the case may be. She submit that in the present case, the so-called notice was issued to the petitioner, the petitioner has submitted reply to the said so-called notice. Now the disciplinary committee will issue notice to the petitioner for personal hearing and will pass appropriate order. Considering the above, this court find that at this stage there is this court find that that there is no find that the petition has not made out any case for grant of any interim order. Accordingly, interim order is refused. Let the matter appear after 4 weeks. After 4 weeks.
After 4 weeks, under the same heading.
Under the same heading.
Lordship, may I speak in indulgence?
Yes.
Lordship, before your Lordship takes up original side matter, Lordship, item 20 of the appellate side, Lordship. It is that matter regarding where the HIT took 14 lakhs and odd, and they have. It is that matter, Lordship, where the HIT, Howrah Improvement Trust, took 14 lakhs and odd and have not executed the lease deed in favor of the petitioner, your Lordship. Lordship, if the matter could be placed within top 10 matters tomorrow, your Lordship, subject to.
You have completed LLB. You might have been completed the graduate, the 12th pass. You might have been till the class 10th. You have been mathematics. Today, how many matters have been taken?
Lordship.
How many matters have been taken? Tell. How many matters have been taken from the serial? If the 15 matters have been taken, so tomorrow your matter will come up.
I apologize, your Lordship. I apologize.
Yes.
I mentioned in the morning for extension of interim order, it's expiring today.
Which
And-
matter?
Well, item number 79 of your Lordship's list, I'm mentioning on notice, my lord. This is the last order.
Item number 79.
79, my
You
lord.
are appearing 79.
No, he's not.
Item number 79. Though the matter is listed as item number 79 in the today's list, but the matter could not be taken up for hearing due to paucity of time. Counsel for the petitioner has mentioned the matter and submitted the interim order is till today and paid for extension of interim order. In view of the submission made by the counsel for the petitioner, interim order is extended till 11th of September 2026 or until further order, whichever is certain, let the matter remain in the.
File a reply, my lord.
You file it.
So,
In the meantime, the petition liberty to file reply.
Great.
Item number? 103, same order. 103.
Please go.
Mr. Thakkar was giving matter. The Lordship will restrain the respondents from giving effect to Form D. Lordship would call
Respond. The item number?
103 of
103. Though the matter is same, though the matter is listed as 103 of the days list, so press for extension of interim order is extended till 11th of September 2026 or until further order, let the matter remain in the list.
Not as praying for my lords, leave not for
Appellate side.
appellate side, not for listing not as an urgent motion. Lord, my tender, my technical bid has been rejected without any reason, and the proceeding to finalize the financial bid, not if it could appear on Thursday, not amongst the first 10 matters. I'm grateful.
Let us query then. Thursday within 10 matters. Issue notice.
I will submit. Yes, I will submit.
May I have your Lordship's kindly to mention, my lord?
I'm grateful to Lordship.
May I have your Lordship's kindly to mention, my lord, to mention a matter upon notice to the other side,
Which
my lord?
appellate side?
No, my lord, original side, my lord.
Appellate side not yet called.
Oh, I'm sorry. I'm waiting.
ये वो फाइल है ना लास्ट मैटर का हियरिंग वो उसमें ये डाल दो लास्ट जो मैटर हो
No, the appellate side mentioned in Chulchina.
Yes, sir.
Let me have lordship's kindness to mention one matter upon notice to the other side. My lord, 5th August, my lord, had passed the order to break open the seal of the padlock and to, but two, my lord, mistake, my lord, that I have in the order, my lord, perhaps typographical, my lord. Paragraph 7, my lord, it is my padlock, my lord, that admitted position in paragraph 3, even the other side also knows, my padlock, they only close it and seal it. So, my lord, here, my lord, the LIC shall again, it should be petitioner shall again put the padlock and LIC shall seal. And that is also indicated by my lord, paragraph 5. To break open the seal of the lock, not the padlock. To break open the seal of the lock, exactly, my lord. The padlock is mine, over which with the cloth and seal, they seal the, with the resin, they seal. Only that only, my lord. I open the padlock, yes, my lord.
Let it be tomorrow to be mentioned.
My lord, tomorrow is the day, my lord, for.
Tomorrow to, what can be done without mentioning how I can correct?
But my lord, tomorrow is the 11, my lord has fixed the time, my lord.
Can be done. The order was passed when?
But 5th August.
Then today?
Well, my lord, only served on Friday evening, night. Earliest possible, my lord.
Friday evening?
Yes, my lord. I can take the responsibility, my lord. I'm saying every day we have. I'm leaving it to you.
Mentioning how it can be corrected, sir.
I know. I leave it. Very well, my lord.
Yes.
ঠিক আছে কাকু বলে নিন
It could have been mentioned in the morning. It can taken as a supplementary, but you not mentioned that.
concept that my lord 3
Yes.
p.m. since
Your lordship,
original side is taken up.
may I mention one matter with the permission, your lordship? In CS 129 of 1999, I appear for the plaintiff, your lordship, as per order dated 23rd July 2026. Your lordship has directed us to correct the cost title, which we are supposed to do by 6th of this month. Kindly give us a week time.
Sorry. If you are not able to comply with the order, this court is the last court give the extension.
Lordship,
Two
kindly.
persons having a group of the advocates working in the firm, and you are not able to comply with the order of the court. Sorry.
Your lordship, kindly.
Yes.
Only one thing, tomorrow, my
It'll-
lord, at the time of inspection, my lord, we will.
Record an order. The petitioner has mentioned the matter and submit that by an order and placed for correction in the order dated 5th of August 2026. He submit that in the order dated 5th August 2026 at paragraph 7, line number 2, the word LIC is to be replaced by petitioner, the word petitioner, and after the word and before the word seal, the word LICI shall be CI shall be added. Accordingly, in the order dated 5th August 2026 at page number 3, paragraph 7, line number 2, the word LICI shall be read as petitioner, and after the word and before the word seal in the said paragraph, line number 2, LICI shall admitted. This order shall be read along with the order dated, and this order shall be treated as the part of the order dated 5th August 20.
The petition as a DPO obliged.
Yes.
May I have your lordship's kind leave, my lord, to mention a review application for an order passed by a lordship.
Sorry. Yes.
May I be permitted to mention one correction is required, my lord, very minor correction, lordship. Like, my lord, postal department was the party, my lord. Everything has been recorded. My lord, in presence of the officers, my lord, everything has been done, my lord. But our appearance has not been recorded, my lord.
Which
That's all.
appearance?
My lord, council of the postal department, my lord. They are present, my lord.
Record an order. Counsel for the petition mentioned the matter and submitted in the order dated 21st of July 2026, passed in WPO number WPO 800 of 2025. Though the postal authorities have appeared before this court, but the name of the advocates appearing for the postal authority has not been recorded. Accordingly, in the order dated 21st of July 2026, in the cost letter, the name of the advocates appearing for the postal authority is recorded. So and so name, so and so. क्या बोला? cost title of the order, cost title, name of series so and so be recorded as appearing for the post.
Grateful.
Lordship,
My lord, may I be permitted to mention, the two suits are already running in the list, but they are very down.
Huh?
Very down in the list. So
Yes,
in September, I spoke with, I mentioned 4 or 5 days ago.
This court is not having any time to upgrade.
In September,
Yes.
I inquired with the court officer in September 3rd week.
Yes, so sit with the court officer after 4:30, then the court officer will decide. Yes, next.
Lordship, I beg apology, Lordship. I just want a leave to correct the cost title of the plaintiff, Lordship. Only leave of this court, only the defendants.
Once the court has given time, you persons are very busy in the bar,
I beg
not
apology
able
for
to
that.
comply. Sorry, madam.
I
Once
beg
the court has passed an order giving a leave to correct, you are not able to correct. Once I rejected the junior senior, I cannot allow the senior submissions. Sorry.
I beg apology, Lordship.
Concerning the judgment passed by the Honorable Division Bench of the Punjab and Haryana High Court in the case of Paramjit Kaur Soraya and the Honorable Division Bench of the Kerala High Court in the case of KG Suresh and the Delhi High Court in Pawan Relay, this court has no other alternative but to declare the Section 17 of the Maintenance and Welfare of Parents and Senior Citizen Act 2007 as ultra virus of Section 30 of the Advocates Act 1961, and the petition entitled to be represented by an advocate before the learned tribunal and the courts constituted under the Act of 2007. Grateful.
Item number 2, special district 3.
For the defendant number 2, Miller.
Yes.
We have made our preliminary submissions, Miller. Mr. Mithul Anand, senior advocate, was addressing the court.
That I was addressing on the first issue.
Yes.
The issues framed. Issues was framed on 3rd January 2018. Whether the power of attorney in question had conferred upon the defendant number 2 any authority to transfer the suit property by way of sale or otherwise deal with the same or any portion in any manner. That was the first issue. So this is the main issue. So while addressing this issue, madam, I just to go back 5 minutes, madam, I had shown to the court Article 48 of the Stamp Act. The power of attorney was registered in book 4, not in book 1. Stamp duty was paid was 50 rupees, not as a conveyance if you have an interest in the property. I have shown. Then I have shown the section 17 of the Registration Act and 51 of the Registration Act, in which book it has to be registered if it is an immovable property and movable property. This I have covered. Now, Lordship will now kindly takes the contract at once. Section 202 must be there. If it is, if a copy them. Yeah. 202.
Yes.
Section, because here the power of attorney was revoked by us. Now 202 termination. Oh,
Section 202.
202 of the Contract Act.
Yes.
Termination of agency where agent has an interest in the subject matter.
Yes.
Where the agent has himself an interest in the property which forms the subject matter of the agency cannot, in absence of an express contract, be terminated to the prejudice of such interest. So if it is coupled with interest,
Cannot cancel.
cannot be cancelled. That's
settled.
That's settled. So here we have gone ahead and terminating it, and today there is no challenge to that revocation. The revocation deed is exhibited. The revocation deed, if I can show you the deed of revocation, deed of revocation is exhibit E. Deed of revocation is exhibit E at pages 106 to 113 of the exhibit judge's brief. Anything? Exhibit E, the yes. Exhibit E. Now only thing, this section 202 is in the chapter of revocation of authority under the
Exhibit E.
E for England.
Yes.
Now the section 202 is specifically under that heading revocation of authority under the Contract Act. That's it. Now this revocation took place on 16th of March 2011. Now Lordship will see this is exhibit E. It records the next page, this document. As that was registered under book 4, so I could have gone ahead and terminated it. Had it been book 1, I could not have done it. Now this records such power of attorney is records. Page 100, the internal page 2. Such power of attorney was granted. Was granted in obtaining sanctioned building plan, other permissions for obtaining vacant possession from the tenants, without any authority to deal with my rights in the said property. It has now come to the knowledge of the attorney that the said attorney, without any authority, parted with possession of some residential part of the building, installed generator and common passage in the ground floor, thereby not only obstructing free ingress and egress.
Who has cancelled this?
The plaintiff.
Plaintiff has cancelled and accepted that.
Plaintiff.
You have accepted
the plaintiff. I gave the power of attorney. I cancelled the power.
Okay.
Sorry, I should have. The plaintiff has given his records that the power of attorney 19th January in the first page.
Yes.
Yes. Now the 3. In view of the aforesaid, by a communication dated 1st March 2011, this communication, Lordship may mark, this is exhibit F. This is the before revoking, I issued a notice.
And what is the date of this? 15 March 2011.
This is 16 March 2011.
15 or 16?
16. 15. Oh, sorry, Mala. Sorry. 15. Sorry. 15. Sorry. No, 15th is registered. Sorry, I got confused. 16th it is registered.
So you have issued notice before this cancellation?
Yes. This is on 1st of March, which is at paragraph 3 of the revocation. The notice is exhibit F.
Notice to the.
Yes, in view of the communication of 1st of March 2011, I called upon the said attorney to satisfy me as to whether the said power shall not be revoked for being misused and or in excess of the authority vested in him. The said communication was sent by speed post with acknowledgement and was received by my attorney on 2nd of March. That is exhibited document F. But instead of complying with the said notice, he unlawfully in excess of the authority proceeded to register deeds of sale in respect of a part of the said premises without any authority being vested in him and by declaring incorrect facts before the registering authority in that behalf. Now, Lordship will also mark the date of sale of these two power of deed of conveyance. First one is 17th August 2010, which is before this letter, and the second conveyance is 4th March 2011.
First is
17th August 2010. which is exhibit G.
17 March,
17th August.
August
17th August 2010.
2010. Before the
Before the notice, yes.
before revocation.
Yes, before even the letter. Yes. The second conveyance
Yes.
was on 4th March 2011. This is after receiving this letter. This letter was received on 2nd March. This letter was received on 2nd March.
After notice of revocation.
After notice of revocation. Yes, obliged.
Yes.
Yes. By complying, yes.
So now the question again, whether this has not been challenged by them,
No,
not put the
no,
challenge,
no,
no cross examination.
no. No, there is no cross-examination is there.
With regard to cancellation is
Cancellation.
revocation is bad.
There is no decree sought for from any court of law.
That's why I'm telling.
It is by cross-examination you cannot challenge.
No, that's why.
There has to be a suit filed or
No, now the question, now the
counterclaim, whatever nature.
the legal question is or will arose if it is the power of attorney, first power of attorney entered between the parties with interest.
Yes.
With interest. Correct. And subsequently, without the consent, it is revoked.
Revoked.
How it is sustainable?
Yes. That question can arise. But in the event, the power is coupled with interest.
Correct. That's why coupled with interest.
No, my case is power is not coupled with interest.
Earlier?
No. No, I'll come back, Mala. My case is, had it been registered under book 1.
That's correct. That is different thing. That is law point.
Yes.
That is law point.
Because
but as per the averments in the power of attorney.
Yes.
As per the averments in the power of attorney, it coupled with interest.
No, Mala, I'll take you there. Kindly let's come back to the power of attorney once.
May I only clarify your lordship's query? Your lordship has just inquired if there is no consent, what is going to be the consequence? Milord, the defendant's case over here is that the power of attorney, when it was executed, 15th of March, by that time, Milord, the second deed of conveyance was already executed. And the letter which, Milord, Mr. Mithul Lanet, senior advocate, has shown your lordship, Milord, it is only, Milord, asking us why they will not revoke the power of attorney. So power of attorney is after the sale had happened.
No, that's
we have
correct.
gone in cross-examination on those.
No, I'll just
that's correct.
We are not saying that. Or she will kindly come to the power of attorney once. I was placing
the date is after. That is our difference. So it was not revoked on the day we executed the deed of conveyance. That is our short case.
Lordship, the power of attorney is from the plaint, because in the judge's brief we have a type copy. So it's from the plaint is the convenience. If we look into the power of attorney, page 79 of the plaint, first important thing is this power of attorney was given to the defendant number 2. Defendant number 2 in his personal capacity. It is not as a director or any authorized signatory of the company.
Correct.
This is number 1. Number 2, Lordship will kindly record date. Note, I'll just take you for once Lordship is recording 2 dates. The development agreement is in 10th January 2006. The power of attorney is in 19 January 2006. Both the documents do not refer to the other. Had it been, the development agreement came earlier. Development agreement should have recorded that in furtherance to this development agreement, the power will be there. Is not there. The power of attorney also should have recorded that the parties have already executed development agreement and this power is given in furtherance to the development agreement. Not there. So these 2 documents no reference of each other in any of these 2 documents. This is subject to correction. It is no way referred to each other. These 2 documents. So these are 2 independent documents altogether. And the power is given to Chirodip Bhattacharya in his individual capacity. Here he may be a director of the pro forma defendant, but the power does not record.
Okay. You understand? Yes.
Now, if we look into the power, my lord, power records for vacating the
Yes, I got
tenants. Yeah, power records for vacating the tenant, to deal with negotiation, and what is most important, the word sell. We cannot import a most important word in a document. The word that you will be empowered to sell is absent. The word sell is not there, number one. And number two, if I stretch my argument to that extent, he had the power to sell. First is there's a legal bar, then you should have registered it under book 1 and paid duty as a conveyance. By paying duty 50 rupees in book 4, then you cannot say I have a right to sell. There's a legal bar in it. So, and the power is, and then it also does not record to sell what? The developers, the sell what is not there. So, and it is mainly for vacating tenant and corporation records and everything. Now, section 202 I have taken a shift. Now the developer, huh? I was on the revocation. So document, the instrument was revoked.
Yes, you revoked.
Yes, the instrument was revoked. It was revoked later, but the notice of revocation was before the deed was registered. Now, Lordship will kindly come to the development agreement once. The development agreement is Exhibit A. এটা আমরা দেখাচ্ছি judge's brief থেকে. My main case is on the power of attorney, not on the development agreement. I'll tell you why, Melon. Now, if we come to the development agreement, few clauses only. Mr. Kormokar has placed the development agreement, I find, but first is 4.6 is Exhibit A. This is 10th January 2006.
Exhibit A.
Exhibit A. Document convenient. 4.6. This is between Shorbani and Exclusive Homes. Exclusive Home is the performer. Exclusive Home is he is a pro forma defendant. Is the pro forma. It's between Exclusive Homes. Now, Lordship will kindly come to paragraph 4.6. The owner shall approve with or without modification the plan as prepared by or on behalf of the developer for submission to Kolkata Municipal Corporation for sanction. The owner and the developer will earmark their respective allocations on such plan. In the event of some reason the plans are not approved and are sanctioned by Kolkata Municipal Corporation, then the developer shall prepare such other plan as be mutually agreed upon and put necessary earmark for their allocation. So it is the approval of the owner is required once you deposit the plan. This is one clause. The next is 6.3. In as much as the construction of the said premises is concerned, the developer shall act as the exclusive licensee of the owner and shall be entitled to be in occupation of the said premises as and by way of an exclusive licensee of the owner to carry out construction of the proposed building, save and except that the developer shall not be entitled to create any possessory right over the said property which could be construed as transfer of the property within the meaning of the Income Tax Act of property. The developer shall not be entitled to use the said property for any other purpose other than the purpose of construction, nor would be entitled, nor would be entitled to part with the said property to anyone till the owner's allocation in the proposed building is handed over to the owner. Because this is one of the points will take you to the deposition, it will come in. They have not only sold it, they have handed over possession and everything done and my so this is it that you become a licensee without any possessory right. Yes. And this is the reason consciously in the power of attorney, right to sell was not given. So this is because in terms of what the parties intended, 6.3. Now, my lord, 6.6.
Yes.
Next page. The developer shall be eligible to enter into necessary agreement or agreements in respect of the developer's allocation, but shall not under any circumstances be eligible to hand over possession of any part of the developer's allocation without first delivering the owner's allocation in the newly constructed build space. So, agreement for sale is done. But the moment you enter into conveyance, possession must be there. So, this presupposes is no conveyance, no possession without giving me first. Next, minus 7.6, the very next page, 7.6. The internal page 16, 16, no, Joseph, you're looking at the document itself. the page, 60, same page matching. Internal. For 7.6, A and B, I'll place both of them, A and B. The owner shall be entitled to sell or transfer, this is the owner, or otherwise deal with the owner's allocation without interference or obstruction from the developer, for which purpose the owner shall be entitled to enter into agreements and arrangements in the name of the developer, for which no further consent of the developer shall be required. Similarly, the developer shall be entitled to sell or transfer or otherwise deal with the developer's allocation without interference and obstruction of the owner, for the purpose shall be entitled to enter into agreements and agreements in the name of the owner, for which no further consent shall be required. And these presently by itself shall be a consent of the owners in this regard. The next line, madam. The developer, however, shall not part with possession of the developer's allocation till such time the owner is given possession of the owner's allocation. Now the question is, how the owner's allocation will be given? That is, so you can enter into agreement your right to sell, but you cannot give possession unless you give me my possession. Now to give me my possession is clause 8.1. Yes. The next page, internal page 8. To give me my possession. As soon as the building is completed, the developer shall give a written notice to the owner requesting the owner to take possession of their allocation in the building, and as from the date of service of such notice and for all times thereafter, the party shall be exclusively responsible for payment of all municipal and property tax, duties and other public outgoings, impositions. So here I'm not reading the entire, the reason is a written notice must be given to me, which to say that take possession. There is a specific question put by me in the cross-examination and there is no document on exhibited that this notice was given. A written notice must be given to the owner to take possession of the owner's allocation. There is no such notice on record exhibited.
Yes.
Now, and these are the clauses in the development agreement. Now, the development agreement did not record because this was entered into prior to the corporation sanction plan. After this was done, parties entered into a meeting, joint meeting by which the sanction plan came in. So then parties agreed which area will become allocation, how it will be done. This joint meeting took place, Exhibit C. Exhibit C. Now, Exhibit E is a document of a joint meeting, is also admitted document between the parties, my lord, on 28 January 2008. Now, here, my lord, the first portion is under the agreement 50% to the developer, 50% to us. That is the broad understanding. Now, here then the parties on the next page, it records in terms of the said agreement and the arrangement they were meeting, the developer will understand the allocable built-up space between the owner and the developer shall be distributed between them as follows. Now, fifth floor, entirety of the fifth floor belongs to the owner. No problem. Entirety of the fourth floor, developer. Third floor, divided northern side, southern side, northern side, owner, southern side, developer. Not a problem here. Second floor, total built-up space shall be northern side of the second floor, developer, exclusively southern side, owner. These are all residential. Now, important is Roman 4. The first floor shall be utilized for commercial purpose, and the entire proceeds out of sale and transfer of the total built-up space in the first floor, after defraying all expenses, shall be divided between the parties, that is the owner and the developer, in equal share. Now, here one of my grounds of challenge is what the developer did. Developer has, so the first floor was supposed to be sold as a commercial, and whatever we sell, 50-50 to be divided between the parties.
Yes.
Now, the developer has went ahead to sell the first floor as commercial, a portion of the first floor, and have taken away the money without giving any accounts of the share to me. This one. And so far the second floor is concerned, second floor as per the sanction plan residential was residential. The second floor is also sold as commercial.
No, second floor where it is?
No, second floor, the sanction plan.
Only first floor.
First floor commercial.
Commercial.
From second to sixth floor is residential.
Correct.
So only the first floor is commercial.
Correct.
Amongst the two registered deeds, one is for the first floor and one is for the second floor. Right?
Correct.
Or second floor. Both are commercial. So far the first floor is concerned, you could have sold as a commercial at all. But so far the second floor is concerned, he has also sold it to be a commercial. But the sanction plan records the second floor to be residential.
How you can prove that it has been sold as a
commercial? The document records, even the corporation, I'll place the evidence, documentary documents, that it records that it is sold to a diagnostic center.
Correct.
The deed records that you have a right to use at a commercially.
But the property is the commercial property.
Only the first floor.
Sure.
Only the first floor is a commercial. Rest, the sanction plan is residential. Sanction plan is residential. You can go ahead and get a conversion. That's a different issue. Whether the KMC will permit or the other owners will give consent, that's a different issue. But as per the sanction plan, it's residential and the first floor is commercial. Now, I will say these things will obviously come later, because the first issue which I will be arguing is the issue number 1, whether the power of attorney ever had given the authority to sell. And based on these terms of the development agreement, whether you could have gone ahead and given possession without offering me possession.
So what is the value of this Exhibit C? Exhibit C is the January 2008.
Exhibit C is 2008. Now this is signed by both the parties and
questions put whether this is in furtherance of your development agreement or not. Answer is
yes, but because it's records. Now she will see the next page. I'll show you. The purpose of this is this has to be read along with the development agreement.
So what was the necessity to execute this?
Yes, the development agreement records 50-50. Then the
area not described.
Yes, allocation has to be done. The northern side, eastern side, which area goes to, the area is not defined. That could not have been unless the plan got sanctioned. The necessity of Exhibit C is to allocate the area. Lordship will kindly come to page 54, which is, sorry, the internal page 4 of this joint meeting.
Yes.
The which is internal page 4, the second paragraph, which starts with a copy of the building sanction plan, which is in which the respective allocations have been earmarked, is enclosed herewith and forms part of this understanding. So it's marked, must be in red. Yes. The allocable area enclosed within red border shall belong to the owner, and the allocable area enclosed in blue border and the said map or plan shall belong to the developer. So the necessity of this document is, and it records. So you will see the further last para of this page. This minute shall be in supplemental to the development agreement dated 10th January, and for all intent and purposes from part of the agreement. So this document is such to for allocation.
So once the area and the allocation part has been identified and
Yes.
it has been given the right to sell, so what remains further?
No, here it doesn't give a right to sell. It only the allocation is there, and he says it belongs to whom.
Correct.
It only says it belongs to whom. The parties were conscious that you can enter into agreement for sale. You have a right to enter into agreement for sale, but you cannot sell in deed of conveyance, and neither you can give possession, because conveyance and possession has to be simultaneous.
Correct.
So possession could not have been given unless it's given to me. You cannot sell because the power is, parties consciously executed the power without the word sell, and it wasted in book 4. Okay. And it was given to individually to Chiradip and not as a director. And these two documents are not connected to each other.
But Exhibit C, kindly come to the first page.
Yes, madam.
So instance, the director and the representative of the exclusive home.
He is acting as a director.
Correct.
He is adorning 2 hats.
Correct.
He is also a director, also my power of attorney.
Correct.
But in the power, it does not record that I am giving the power to
the representative of
yes. The power is independent of this.
But subsequent act you
Yes, the documents are signed by him. The documents. He may be adorning 2 hats, but it can be. A person can be.
No, you cannot say. No, you cannot say this is only the person name and the director.
No, that's not my case. There's a complete different person. I'm not. Okay. I am on that. The power given to my attorney, even if I don't use the word name, the power given to my attorney did not have any right to sell. And knowing this, once I cancelled the power, because the rest of the building has to be sold. Today the building is constructed. He did not. The reason
when the construction was completed.
Construction was completed the same time when it was sold in 2011. Yes.
So still the building is lying vacant.
Still the building is lying vacant. The
14 years.
Yes. The superstructure is complete. Internal walls are there, but there is no CC. There is no completion certificate yet. It is my client who has now applied before the corporation with my own funds for corporation's complete certificate, and for 12 years.
And what about the sold property?
The sold property.
They are occupied.
Yes. I've asked for eviction. They are parties. I've asked for delivery. Yes. I've asked for delivery and cancellation of this instrument because no title has passed. The property is lying as it is.
They are the parties here.
Yes, they are the first defendant. The first defendant is this. The purchaser. The purchaser is the first. Now Lakshmi will kindly come to the plaint. The relief sought for in the plaint. Yes.
Only one purchaser.
Yes. Both deeds, one purchase. Is it?
Only one property has been sold.
One to convince buyer.
Okay.
To convince same buyer. Now today I seek the relief sought for, my lord, is for declaration that these 2 deeds of 17th August 2010 and 4th of March is null and void illegal. Which page 34 is not binding upon the plaintiff. This is the first declaration. Then he asked for delivery upon cancellation of the.
So they have not filed any counterclaim, claiming
No.
the right title.
No, they have a written statement.
They
But
have
there's
not
no.
filed the counterclaim.
Even my lord, the defendant number 2, even the defendant number 3, there is no written statement. So far, defendant number 3 is concerned, the pro forma, there is no proceeding by him, by that entity, that United, sorry,
Exclusive.
exclusive. There is no proceeding by him. Even Chirodip has not filed any proceeding asking that my is coupled with interest. You cannot today cancel it. Violation of section 202. Party's name is not coupled with interest. Book 4. You have paid only 50 rupees stamp paper. Sorry, the stamp duty. Okay. You could have gone ahead and challenged my action when I have did it. And so today, defendant number 2 is only my attorney against whom I have challenged. And the action done by my attorney. And then the other release, my injunction and other release which I have sought for. But I know. But
Yes.
But this is already there on day after tomorrow.
Yes, but 12.
And I think Mr. Kormokar was in the midst of his submission and Lordship wanted to hear me. I'll finish my entire.
Yes. You complete it. I will hear them.
But give me an option to reply because Mr. Kormokar has not completed.
The learned counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 12th under the same heading. 3 p.m.
3 p.m.
Yes, next.
Obliged. I'm deeply obliged, bro.
I appear for the respondent. I'll be seeking directions for affidavits. There's various documents he has not annexed, which are material over here.
You are for the 2.
Not that.
Civil.
3 and 4.
4 is also there.
My lord, I'll indicate to your lordship, my lord, what is my main relief. My lord, in the writ petition, the petitioner is challenging, my lord, the action of the civil authorities so far as, my lord, the credit ranking or numbering is concerned. And my lord, Mr. Bachawat's client, respondent numbers 3 to 4, they report to civil. My lord, why this grievance? My lord, here it's an admitted position, and I shall show from the admission made by Mr. Bachawat's clients, that is respondent number 3 to 4, my lord, there were two-way transactions. My client, that is, my lord, the individual, his wife and his group of companies, admitted position had advanced a sum of 450 crores to, my lord, 2 Shrey entities. Shrey Equipment Finance and, my lord, Shrey, what is the other? Infrastructure. My lord, 450 crores were financed by, 450 crores were given by my client to them. And, my lord, the Shrey companies had given a sum of around 330 crores by way of advance to two of our concerns. Now, my lord, kindly straight away, before I take your lordship any further, kindly take volume 2, page 252.
Whether it can be disposed of?
Yes, but if they want, because my lord, my main grievance is against CIBIL. My main grievance is because whatever dispute I have with Shrey, my lord, my civil ratings only on their unilateral basis, my lord, cannot be altered. Because it has other far-reaching consequences. My entire business, other business gets affected. So that is why I am saying, my lord, we have challenged that this action of CIBIL, that only on the basis of reporting by Shrey, when on the teeth of there is an admission that, my lord, I have paid him much more and the dispute is there without adjudication, how can you alter my civil score? But kindly first comes to 252. I want to, my lord, show the factually volume 2, page 252.
Yes.
Let kindly see the right at the top. Tarini Minerals Private Limited, DR Patnaik Group, overdue of 22 mm of 208 DPD reflected in the loan of INR 1500 mm. Let kindly see who is writing this. Pradeep Kumar Parida, pradeep.parida@shrey.com. My lord, he is giving an independent report to a gentleman in Yes Bank, Vishal Jain. Because, my lord, seeing the civil ratings at that time, my lord, the Yes Bank started inquiring that what has happened. Dear Mr. Bishal, Mr. D.R. Patnaik and Mrs. Indrani Patnaik's group is one of our most valuable and important customer as well as investor for the last 15 years. This is very important. There is an investment of 450 crores with us in various instruments. So Shrey is admitting that the Patnaiks and their group have an investment of 450 crores with the Shrey group. At the same time, there is a loan which is lesser to the investment value. So Shrey is admitting two things. The investment of Patnaiks is 450 and whatever loan that has been given by Shrey is lesser in value. Relating to CIBIL record as it is auto-generated, which may have reflected some dues, but there is no due outstanding as on date. At the same time, we have received an application from DR Patnaik Group to adjust investment in the loan account, which is under process. The repayment behavior is satisfactory and accounts are standard since last 15 years, never defaulted in any of the loan accounts with us. So, my lord, the admissions are threefold. Number one, Patnaiks have made an investment of 450 crores.
Yes.
Whatever loan Shrey has granted is lesser than 450.
Yes.
And there is already instruction from the Patnaiks that you adjust it and you return whatever money the Patnaiks get due, which is under process.
Yes.
But CIBIL account is showing erroneously because CIBIL account only reflects what the financiers show. CIBIL accounts does not reflect the true position. And this is on the part of Shrey. Now, on the reporting of Shrey, my lord, I must indicate the two companies of Shrey, my lord, it went into, my lord, under IBC, my lord, it went CIRP. At present, my lord, the shareholders of both these two entities are, my lord, two government entities wholly owned by the government of India. So, present, my lord, the shareholders of these two Shrey companies, because of CIRP, are, my lord, the company, the shareholding company's name is National Asset Reconstruction Company Limited, which is, my lord, a 100% government holding company. Subcategory of company, union government. I have got the Ministry of Corporate Affairs and I have stated that in paragraph 3 also. Now, my lord, what is the immediate cause of action? My lord, kindly see what is the current report at page 552, which will be at volume 4.
$552.
552.
Yes.
Now, my lord, kindly see civil score and report. Lordship marks the date 27 September 2025. The date is 27 September 2025. The score is 673. Your civil score is 673 as of 27 September 2025. Lordship finds that?
Yes.
And my lord, why this has happened, Lordship will find straight away comes to page 555.
Yes.
In open accounts, Lordship find member name Shrey, construction equipment loan, credit limit,
Sanction amount.
99 crores, 99 lakhs, so and so, amount overdue 99 crores, so and so. This is what they are showing. And date of last payment 11th August 2025. This is what they are showing. But in this 200-page report, this is the only default which is being shown. And Miller, this is in the teeth of the background. In 2021 itself, I had said that, look, my money lying with you is much more. You adjust whatever it is and you do the rest. And that was pending. Then, my lord, it goes into CIRP. Now, my lord, we are in, my lord, part of it is in NCLT. And now, my lord, we have gone for arbitration also. We have gone for arbitration also. Who owes money to whom and all that. But I am on the primer because Shrey has very little to say over here. I have shown from there what is the quantum, that's a dispute before another forum. Now, will it kindly see what was the position in CIBIL prior thereto? Will it kindly comes to page 413, which Lordship will find at volume 3.
Yeah.
October 2020, my CIBIL score is 728.
Yes.
That gets reduced to 673 because of reporting of one default by Shrey, which they have done it wrongfully. Now, the challenge is I don't have any place to, or I don't have any voice to go before CIBIL and say this is incorrect. And this is happening when? In 2021, it's an admitted position. I have, this is something, it was a group transaction. Patna Group 450 crores invested in Shrey, and in that 330 was the principal amount. Now, the legal issue is we are fighting out in other forum. They are saying that, well, the Shrey companies have gone into CIRP. So whatever money you have given us, because it is CIRP, clean slate. Clean slate, I have gone into CIRP, I have become clean. But I am entitled to recover money that are due to you from us. This is legally tenable or not, we are fighting it in another forum. But this is the, my lord, inequity or the unjust. Now, my lord, CIBIL, why we have challenged it, kindly see, my lord, paragraph 3. Because I understand, I don't know who is appearing for respondent number 2. My main grievance is, my lord, they should immediately remove this thing. Or prima facie, it doesn't happen in CIBIL.
I am appearing. I like my senior Miss Sonia.
Huh?
I'm led by my senior Miss Sonia.
Okay.
So what is your instruction here?
Well, kindly see paragraph 2 and 3. Paragraph 2, respondent 1 is Reserve Bank of India. My lord, we have made them parties because, my lord, they should also know what is happening. Respondent 2, and this is important because the interim relief I am seeking is limited. Respondent 2 is a credit information company within the meaning of Credit Information Companies Regulating Act 2005. Respondent 2 discharges various public functions under the 2005 Act. Moreover, the respondent number 2 maintains and is responsible for keeping and storing credit information of customers across India on its platform CIBIL. The respondent 2, in the usual course of its function, maintains a CIBIL score of individuals registered on its platform. The banks and financial institutions across India inevitably refer to and rely upon the CIBIL score of customers applying for credit or loan facilities from such bank and financial institutions. An appropriate CIBIL score has become practically a mandatory and essential requirement for any person to obtain credit loan facilities from any bank or financial institution. The respondent number 2 enjoys a monopolistic status in respect of control and maintenance of credit information of citizens and customers. As such, the respondent number 2 is discharging public functions and duties which forms part of everyday life of citizen. Respondent 3 is wholly owned subsidiary of respondent 4, Both respondent 3 and 4 were and are engaged in the business of granting finance. Both 3 and 4 have undergone corporate insolvency resolution process, whereby and whereunder the respondent number 3 and 4 have taken over the successful resolution applicant being by the successful resolution applicant National Asset Reconstruction Company NARCL, a government company. The respondents 3 and 4 are in any event credit institutions within the meaning of 2005 Act and perform various statutory functions. A copy of the master data of respondent 3 and 4 at the MCA website is annexed. Well, that is to show their state entities. Copy of the order of 11th August that all the respondents thus fall in state. Now, Milord, the immediate relief that I am asking is, Milord, this I am showing your lordship, Milord, I anticipate because in some cases, civil had made an argument that I am not amenable to the writ jurisdiction. So this I showed your lordship in case that argument is made. Milord, kindly come to page 27. Milord, all I am seeking as of now. But in affidavit, lordship may have the detail. I have shown that admission over there, page 27. Milord, kindly see, Milord, order in terms of, Milord, prayer I. H and I. Or my lordship can, J would suffice my purpose. I think J would suffice if lordship. That whether they should for the time being, because it is disputed, they should disregard it and update the score. Or if they are doing it, there should be a note that it is disputed in this background. Otherwise, today, my lord, my credit rating, my lord, I have enjoyed all along. My lord, one of the, my lord, most strong financial credentials so far as the Patna group is concerned. And in teeth of, my lord, what I showed your lordship at page 5, at page 252, Lord, in teeth of that, where it is an admitted position, Lord, because civil is not taking into consideration that Shrey is itself admitting that I have got 450 crores investment from this Patna group.
Yes, civil, where is?
My lord.
Civil? What is your stand?
Lordship, as per section 21 of the Trade Information Companies Act, Lordship, Trade Information Companies Act, Lordship, as per subsection 1, Lordship, it clearly states that the company who is granting finance to them has to make a request to us, has to make a representation to us. Lordship, post that we are going to change the credit score. Lordship,
So you consider the 252 to page 250, you have a writ petition.
Lordship,
I'll explain that. Not there's much which has happened after that. Not my learned
Lordship,
keep saying admitted. There's nothing which is admitted. I'll point that out.
Lordship, my stand is limited that when I am in receipt of an instruction.
That's why you have a page 252 writ petition.
Lordship, I do have it. Lordship, the communication to that effect that
Writ petition you are not having.
Lordship, I do have it in soft
Good.
copy. I have to.
Without the writ petition,
Lordship, I do have it in soft copy. I'll just surely open.
Huh?
Lordship, I do have it in soft.
You are appearing.
No, Lordship, it's
Your senior.
Lordship, Sony Oja. Lordship,
Huh?
Sony Oja, Lordship. Lordship, I do have it.
Yes, Mr. Bachav.
Lordship.
My learned friend has used the word admitted about 20 times. There's nothing admitted. Please first take that letter at 252. Please see the date of the letter. But my learned friend is proceeding on the basis that what happened in 2021 is stuck at 2021. Now, under the loan agreements, nothing was repayable on that day. There was nothing repayable on that day. Thereafter, please make a note that this letter is dated 17th August 2021. The agreement was terminated on 26th of November 2021 when the entire amount became due. A letter of demand was issued to the principal guarantor. My learned friend suppresses it. There is no reply at 5 years. So demand as long back as 2021.
Who has made the demand?
That was.
Where is that?
Say, my learned friend has suppressed it. But I'll show you lordship the letter. Letter copy achi to do. hard copy. They have suppressed it. Now, this is the difficulty. That's why I said I need to file an affidavit. Now,
What was the demand?
well, the demand was made for sum of Koto. Well, give me the amount. That's why I asked for it. But just give me a moment. Lord, the letter of demand is dated 26th of November 2021, and the claim is for a total of 452 crores due on termination, plus further interest, plus other things. But I can show your lordship a soft copy of the letter. This is suppressed, number one.
So what about the then 250?
Yeah, I'm coming to that. So, my lord, like my learned friend says, he says it is admitted that he asked for a set off. Now, on that date, please make him note. Why is it said that there is no due on that date? Because there was, in fact, no due. Learned friend is relying on this line. There was no due.
Correct. When the amount become due?
But on 26th of November, I'll show your lordship the letter. May I just hand it up to your lordship? A soft copy, I'll annex it on affidavit. But please go to the third page of that letter. Your lordship will find the total amount due. So 26th of November 2021, on termination of the agreement, this amount became due. Your lordship will find that this notice is issued both to the principal borrower and the guarantor. This was never disputed by anyone. My learned friends did not reply. They did not raise file any proceeding. So it cannot be disputed that this amount became due. Now comes the second part. So, Lord, this explains the note outstanding on that date. In the letter at page 252, my learned friend talks about no dues outstanding. Said answer is there nothing due later. So, Lord, this is one part. Now, the second part, what my learned friend does not tell your lordship is he made a investment in NCDs, not a non-convertible debenture. That is an investment. Now, the investment she made was a company which went into insolvency under the RBI insolvency. He made a claim specifically for this. It was rejected. So this claim that he has, or his counter claim or whatever, became extinguished by application of law. So two parts. One part made the submission, there was nothing new on that date, it became due later. The other part, but that claim made against the other company was rejected. But in the CRP process, I'll show your lordship the order.
How soon you'll file the report?
But 1 week. 1 week. No, because today what my learned friend is asking for order in terms of praise is a mandatory order of injunction. But how would I be interlocutory step? Interrupt my learned friend. I did not interrupt my learned friend.
Let him finish.
I did not interrupt my learned friend. But
he is not saying he has repaid my money.
Look at how sweetly he interrupts now, as if he is not interrupting. Now, but I was just trying to explain that letter. There were three looks. I will say the look. Number one, this happened. There was action. Number that investment CD, that claim he made before the flood in the CIRP, that was rejected, that became extinguished. So he can't claim that. So, and the third is, he says that he had asked for a set off. He can't show your lordship that a set off was permitted at all. So, this admittedly, which is admitted. Number one. I have hard copy of that letter. My learned friend has suppressed it. No. Oh, yes. So, that's the letter of termination, which I showed your lordship a soft copy though. Now, but second part, what is civil reporting? I'm not going into maintainability for the point. For the time being, I'm showing your lordship it deserves no interim order. Now, civil reporting is it's mandatory for us to furnish all this information so that a credit score is there for the benefit of the public or people dealing with them, etc. Now, in this case, My learned friend does not and cannot say that there is no due to him. But we'll assume for a second, for the sake of argument, that his blood NCD claim had not been rejected. I'll assume it for a second. He still owes money under this agreement. The interest rate in this petition says that the interest rate on my agreements is much higher. Some money will not be due. The fact is some money is due. He admits this. Again, Milord, during the pendency of the petition, তুমি ওটা কি দিলে আমার দিচ্ছি 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 আমার একটা কপি দাও আরে এটা ওকে তো দেবো আমার জন্য একটা কপি দেবে তো I'll just read it. But this is from my learned friends. He makes it for a one-time settlement on 10th March 2026. He's offering to pay at least 80 crores. So money is due. He cannot dispute that money. Learned friend is not offering to it. For the fun of it. Please have a look. That first page, he will pay 10 crores in 90 days. Look it. Total of 80 crores. You know. First on the page.
Yes.
So Lord, how does he say that there is nothing? Say admittedly, 17 times admittedly.
Yes.
Company proposed to pay. For what? And then the company become challenging this before your lordship is the guarantor. Guarantor.
Yes.
So Lord, this is pretty much clear that Lord, he owes money. Now, this civil reporting of the judgments on repetition in such disputed not facts not permitted. But I have a division bench of, not I have two single bench judgments of this court, division bench of Delhi. It is now not perhaps a well settled proposition. Not easy lordship going to get into these disputes in a repetition. This fact-finding commission, not fact-finding exercise can't perhaps be done, not in a repetition, but it's something I'm loath to challenge maintainability. But Lord, this is now fairly covered. Lord, may I just show your lordship, Lord, three judgments. Now, very quickly, they are short judgments, they won't take up your time. First, give me the Dipankar Datta. Dipankar Datta. Two copies. Kaiser. I don't need it. But please take the first page, your lordship will find the players are set out. Please have a look at player C. Challenging the substandard scoring in civil. Same kind of challenge. There is also a challenge with regard to other matters, not that I won't trouble your lordship with. Then if your lordship would come straight away to para 14. Finally, Mr. Mitra argued that the equity of redemption that continued to exist in favor of the petitioner was lost because certain arbitrary actions of the respondent bank. Attention of the bank was also drawn to the representation made to public database that the petitioner's account was substandard, although in the record books of the respondent, the same was described as standard. The relationship between the bank and the petitioners is in the realm of a contract. Examination of the contention urged by Mr. Mitra would necessarily require ascertainment as to whether the respondent bank has violated any of the contractual stipulations between the parties. It is well settled law. It is settled law that a writ petition is not an appropriate remedy for impeaching contractual obligations, and therefore the remedy provided by the general laws of the country ought to be produced by the petitioner, etc., etc. So, this is one. একটা দুটো should find that this is to do with CIBIL, only for that purpose, not. Para 3, your lordship will find the respondent say that not the entire amount has not been repaid, money. Para 4. The repayment, according to the petitioner, was made in the word of the court. First representation was submitted almost after 3 years on 12th September 2017. The dispute involved in the present part petition involves disputed questions of fact relating to repayment of the loan amount, and such a dispute cannot be decided by this court. In such circumstances, this court is unable to grant relief, etc., etc.
Yes.
But then I'll give your lordship, not this is also the Delhi view, I'll give your lordship a division bench. Copy nahi. अरे यार but can I just show your lordship the soft copy and immediately give a hard copy? But I'm sorry, Munada. Munada expected that. I'm sorry, Munada. Your lordship will find this is also fairly recent and what is the judgment. For lordship note comes not to the third page, not para.
Yes, para.
But your lordship will find it takes the similar view. You will find para 10 circular, but same kind of challenge made, not. And your lordship will find that para 13 saying that not court is not warranted, not interference by court is not warranted at this stage. But para 11, what you will find uses the same language as the Calcutta judgments. First and foremost question to be addressed is whether the present petitions are required to be entertained by court. It's apparent from a plain reading of the petition that the petitioners have founded their claim on contractual agreements entered into with the respondent bank and the developer. And the developer. Petition filed essentially to preempt the bank from instituting pursuing proceedings before the DRT under the DRT Act. We are not persuaded to accept any interference at this stage. Petitioner based their case on contractual obligations entered into, etc. And Milord, on that view of the matter, your lordship will find Milord, para 17, if your lordship comes to, insofar as not the other part not being dealt with, insofar as the petitioner's prayer for restoring the CIBIL score. Now that's the prayer J he's asking for. No directions for the same are required to be issued at this court, at this stage. If the petitioners prevail of the defense before the learned DRT, respondent bank shall ensure that the same is communicated to the. So as and when he succeeds, but there are arbitral proceedings pending between the parties. As and when he succeeds, not section 21 notice has been given, section 11 has been filed, not it will be decided in arbitration. If he succeeds, not CIBIL will change its score. It's simple as that.
21 notice is given.
Yes, section 11, but arbitration had been started off long years ago. Then they took the point, like the lordship remembers, after the Supreme Court judgment came, that there could be no unilateral appointment of an arbitrator. So the arbitrator then recused. Then we had to file a section 11. Then they said there is no fresh section 21. So that was withdrawn. Another 21 given and 11 filed. This is
pending. 11 is pending.
11 filed by us,
yes,
not by them.
So there is some dispute. Filed a section 9. That 9 has been there. So this dispute is there. If and when my learned friend succeeds, this will be corrected. But his claim is basically not founded on contract. As your lordship has seen, under this contract, this money is due to me. There was an agreement to set off, etc., etc. Which leaves.
Okay. My lord, may I just? He is not finished. Let him finish. I'll take not more than 3 minutes.
What difference does it make?
I appear for CIBIL, my lord.
Now, Lordship,
CIBIL Suomoto has no authority to make any correction until it is confirmed by the member institution, my lord.
Just give me 2 minutes. Now, my learned friend then relied on page 413. Please have a look at that 413. Let me finish dealing with it. Now, please see what's the date of the CIBIL score he shows. 10th of October 2020. Obviously, it would be good. There had been no termination. Can you rely on this to say, I have a clean record? But this is completely misleading. It doesn't take into account the termination. Reliance on this date is useless. This is no criteria or factor.
Yes.
This petition was filed in the month of February. 25th of February, it's been pending for 4 months. Well, I'm sure suppressions, which I intend to deal with in an affidavit if your lordship upholds maintainability. If your lordship does, I will not do it, but there is no ground for interim order after so many months. There is no. Not as against page 413, he now showed your lordship page 552 that presently his CIBIL score is bad. So that takes care of this.
Yes.
And that also is at least from September 2025. But 11 months have gone by. It has not bothered him. What is the urgency for or the rush for a mandatory injunction today? Please have a look at page 400, page 552. 552. That is showing your lordship that the default is from data 552.
Yes.
Please see. Now your CIBIL score is 673 as of date 27 September. So he had a bad CIBIL score for 11 months. There is no need for interim order at all, and that too of a mandatory nature.
Yes. Yes.
That is no.
Anything further?
Not that. But if I may just, because my learned friend laid a lot of stress on that letter, if your lordship just takes that letter once, page 252.
What about the 555?
But page 555. But 552 is the first page of that. It is showing that this CIBIL score was bad on 27th of September 2025. And this is the amount due.
Okay.
There is amount due to me. There's no doubt about that. Because what I'm saying is not that CIBIL score of 2020 is irrelevant because there was no demand by me at that time. No, page down.
Now I just take two.
I'm just going to take your lordship through that letter. At page 252. Now, my lord, please take that letter once more. I'll double your lordship with page 250. Who's taken my copy here? Now, my lord, please take page 252. So, my lord, in this background, let us read this so-called admitted position by my learned friend. Lord, please see first. This is not a letter written to him, but to his bank. First point to note. Number 2. Mr. D.R. Patnaik and Rani Naik Group is one of our most valuable and important customers as well as investor. Please mark the note, but it is not a loan. Learned friend said loan. It is an investment. Now, as one knows, I can invest in a share. It may turn out to be a dud. You suffer that loss. That's your bad luck. That's your bad luck. It's not mine. As well as an investor for the last 15 years, there's an investment of 450 crores. This is in various instruments. At the same time, there's a loan which is lesser to the investment value relating to the CIBIL record as it is auto-generated, which may have reflected some dues, but there is no dues outstanding as on date. Now, let me pause here for a moment. It seems to say that his CIBIL score even at that time was not good. Yes Bank is inquiring about this. Now, please see this relating to CIBIL record is auto-generated, which may have reflected some dues, but there is no dues outstanding as on date. Now, please mark the word outstanding as on date, because my outstanding, as I said, came after the termination notice dated 26th of November 2021. So this is not an admission of anything. It is a past position. Then, At the same time, we have received an application. Now, my lord, mark this, an application from Mr. D.R. Patnaik Group to adjust the investment in the loan account, which is under process. So no one has agreed that, look, you can set off one against the other. It can't be done like that. The repayment behavior is satisfactory and the accounts are standard since last 15 years. Never defaulted in any loan account. Now, my lord, if I may be permitted to ask this in the form of a question, that what is the admission in the letter? My learned friend says that there are 3 admissions. Now, but first January, thanks on this letter.
On 17th August 2021, you stated that yes,
Correct. There was nothing due.
450, there is nothing due, when there is no due outstanding on that day. So how this due on November 2020?
Because the amount under the loan agreement became due. Because the agreement was terminated. Please have a look at that letter which he has suppressed. Now, my lord, please have a look at that letter of 26th November. Now, তুই তো hard copy দিলে আমাকে softটাই দাও. Your lordship has a hard copy.
Yes, 26 November 2021.
My lord,
26 November 21.
but I don't have hard copies. Just give me a moment to pull out the soft copies. আরে শুনে নিয়েছি. I've heard it. You told me so. Now, I have heard it. Now, my lord, please come to page 53. Sometime in February 2019, you, the addressee, approached the above client for the purpose of taking a loan, etc. Your lordship can turn the page, and your lordship will then come to at the bottom of the second page. Inasmuch as you had caused breach of repayment schedule and view of your failure to clear your dues of the said sum in spite of repeated reminders by a client as per the terms and conditions of the master facility agreement. Therefore, we, on behalf of our client, hereby recall the repayment schedule. As a result of such recalling, default clauses provided in the master facility becomes operative in respect of the repayment schedules. After giving credit of all sums paid to you as on date, a total sum of 450 crores, etc., is due and payable by you to our client in repayment schedule as per the particulars given below, and total due on termination, your lordship finds at the bottom of that table is 452 crores. Then, Lord, we call on you to pay this, etc. And Lord, we have other claims. Now, Lord, please go to the first page of this letter. Lord, it is given to Ilani Patnaik, who is the writ petitioner over here. Sorry, but Ranjan Patnaik, Ilani Patnaik is the she is the wife and she is the borrower. So one is the borrower, two is the principal, is the personal guarantor in respect of this loan. Now this personal guarantor has filed this writ petition. Now, also, Lord, please make a note, there is no reply to this notice by either the principal borrower or the guarantor. No reply. They never dispute this at all.
Yes.
Now, Lord, go back to this letter again, Lord, at 252, having explained this to your lordship. Now, what he is doing here, Lord, please note that this particular writ petition is relating to the loan where, Lord, Mr. Patnaik is the guarantor. So that loan was to Indrani Patnaik. Now, Lord, please see this letter. This letter relates to the dues of whom?
Both.
No, it relates to the dues of Tarini. Tarini only, which is a different company. D.R. Patnaik and Indrani Patnaik Group is one of our valuable and important customers for the last 15 years. There's an investment of 450 crores. But now this is in which context? I'll tell your lordship how your lordship will find it's not Tarini. Please come to the mail below this.
Yes.
Vishal, not, this letter is from Vishal Jain of Yes Bank, and if your lordship sees, not the second para. As discussed by you, total investment of DR Patnaik, including investment of Tarini metal, is a mineral, is more than 450 million, etc. in the group, and loans are adjusted. No payment to be made by the group as a special arrangement. Please request you to grant, get the same rectified in the civil reporting. And Mulad, your lordship will find, please, not the first para, I'm sorry. The civil records of the company is reflecting an overdue. So this is referring to not that Tarini. The company. It's not referring to the other person at all. So this letter relates to Tarini. It's in the context of Tarini meaning entirely. And Lord, as far as Tarini is concerned, Lord, Dipti Ranjan is not even a guarantor. The writ petitioner is not a guarantor in respect of Tarini's not loan. So please see, Lord, how an attempt has been made to muddle up, Lord, the claims of these two companies. I will give the proper documentation relating to it, but your lordship will get it that this relates to Tarini because of the loan amount, Lord.
Yes.
And to do with the company. He is saying correct the civil recording of the company. Now, as far as this company, not loan is concerned, Tarini, not writ petitioner is not a guarantor. He is not a guarantor. So, this is the But please also appreciate this, that these debentures which he is talking about, he made a claim before the NCLT, and that claim for the debentures was not rejected. But these were in the nature of, I understand, not from the letters, that these were not non-convertible perpetual debentures. So I don't know whether he is entitled to not claim repayment or is entitled to interest for lifetime, but it was an unsecured claim and it has been rejected by NCLT, which extinguishes that claim. So those are my submissions, Lord. And Lord, I think Sybil wanted to say something, Lord, Ms. Soni Jha.
May I just make a few submissions, my lord? Since under section 21 proviso of SECRA, my lord, civil suo motu cannot make any changes unless it is confirmed by the member institution or bank, my lord. So the civil has no authority to make any changes, no relief can be claimed against civil, my lord. Unless it is confirmed by the respondent number 3 and 4, I have no authority to make any correction in the records, my lord. That's all. This is all my submissions.
Now, my lord, this is the precise reason why I have come to court. Now, my lord, quick, let us see, my lord, who is misleading whom. My lord, my learned friend is factually incorrect when he says, my lord, the guarantee is invoked only in 2026. That is at page 734. Only in 2026. So 21 letter, assuming, my lord, that 21 letter which is shown is correct. What was shown is a 26 November 21 letter, but my lord, 5 years nothing is done, 2026, and we have come to court. My learned friend says don't pass interim order because 11 months have passed. 11 months, 11 times it has been mentioned. My learned friend's advocate also would know. Today we are getting the chance because at the last we were successful. Lordship was, my lord, I mentioned it and Lordship fixed the time. So, my lord, the fact that we had filed in time and this was the immediate trigger. Now, my lord, it's a question of simple mathematics. Kindly come back to page 252. That line is conveniently omitted. My lord, if in 2020 the admission is that I owe more money to you and your claim for your instruction for adjustment is pending consideration before us, no document is shown that your consideration is rejected. Kindly see that letter. Till today, no document. But now this story is spun up. See, my loan is carrying interest.
So if I wait for 5 years and make a claim, it will increase, it will go 800 crores. Well, at 5 more years, it will go 800. Well, not a whisper. What happens to my 450 crores? Have you repaid it? Answer is no. Kindly come to 252 once again. Well, at this line, what has happened to that? The second last line. At the same time, we have received an application from DR Patnaik to adjust the investment in the loan account which is under process. So if 2000 it has been processed, how can you say I am accruing interest for 5 years?
Under process and processed.
And what have you done till date? Not a single letter that your application has been rejected from the bar statement is being made.
Yes.
But CIRP order is on record.
I did not interrupt you.
CIRP order is there.
Why is Shrey fighting this application? This is again civil. Now, well, at CIRP order, I will tell your lordship. There is no application before NCLT. What my learned friend is saying is, before the NCLT, lordship knows, if a company goes into, my lord, CIRP, all creditors, if the credit is shown, my lord, as creditors, it will be applicable. But once a scheme is sanctioned, whatever if your claim amount is 450 crores, they say it's a clean slate. So what my learned friend doesn't say is, I have taken 450, I have repaid you nil, but because now I am in a new avatar, I am in a clean slate, so your 450 gets wiped off, but you owe me now 500 crore rupees because my interest meter is ticking. This is the injustice that and CIBIL is acting on their behalf. Will kindly see there is no state.
So this disputed, how this court can go into that?
Well, I am not asking your lordship to go into the dispute. All I am asking is, in teeth of the admission, my lord, in this letter, that my lord, as on 2020, money given by more, as on 2020, instruction was given, you adjust whatever money is there and refund the list that is pending. After that, my lord, there was no transaction. Assume for a moment whatever interest they are doing. If you have adjusted it here, no document is shown that your application, I have rejected it. Not a single document, not before any authority.
In that case, let they file the sort affidavit, disclose all the document. I will.
Very well, very well.
Let they file because they are telling
But so far as CIBIL is concerned, my lord, kindly restrain them because the submission is what? I don't have any power. My lord, court will grant them. They shouldn't publish the score.
Let they file the report.
But otherwise, my lord, kindly see how inequitable it is. I am out of pocket by 450 crores. My lord, Shrey smartly comes and says, well, your money has evaporated because over there in the creditor, what you had made a claim, because it has gone into CIRP by the clean slate principle, your money has evaporated, but you are a creditor in my book, so your CIBIL rating will go. And I have come at the earliest possible instance.
Okay.
Because
then let they give bring all the documents on record. Then we'll see to that. If it is there, then the court will.
The lordship will kindly record my submission that so far as my lord, this application being rejected, there is no document on record. If it would have been, my lord, the first thing they would have shown. And my lord, this letter which they are saying
without any letter of acceptance.
Without prejudice,
He is not
they say,
showing
I am
any letter.
suppressed. They don't tell you, they say you settle this separately, we will settle that separately. And it is clearly written over here, this is not to be relied in court because they were negotiating that separately.
Well, my learned friend has offered 80 crores when is due to him.
So you have paid a single penny.
He has offered, he's offering 80 crores after filing of the writ petition.
Yes. 450 crores can't evaporate, my lord. There has to be a payment.
The petitioner has prayed for an interim order. Prayed for an interim order.
Yes, he did.
Directing the respondent number 2 to update the civil score CIBIL capital score of the petitioner after removing and oblique or disregarding the false claims of the respondent number 3 and 4 in respect of the loan account of Mrs. Indrani Patnaik and Tarini or Tarini Minerals Private Limited are not Tarini Limited full stop. The petitioner has relied upon the mail dated 17th of August 2021 wherein the Siri has informed the bank that the D.R. Patnaik and Mrs. Indrani Patnaik group is one of our most valuable and important customer, as well as investor of for the last 15 years. Full stop. There is an investment of rupees 450 crore with us in various instruments. Full stop. At the same time, there is a loan which is lesser to the investment value. Full stop. Relating to the civil record as it is auto-generated, which may have reflected some due, but there is no due outstanding as on date. At the same time, we have received the application from Mr. P.R. Patnaik Group to adjust the investment in the loan account which is under process. The repayment behavior is satisfactory and the actions are standard since the last 15 years. Never default in any of the loan accounts with us. By referring the said letter, the petitioner submit that once the SERI is admitted that there is no due and there is an investment of 450 crore by the plaintiff and there is no due, but in spite of the same, the CB has recorded, civil has not correcting the recording. Full stop. Land Council, Mr. Gachawat, Land Council appearing for the SERI, submit that subsequent to the said email, there are dues pending against the petitioner which has not been brought in the present date application. He has relied upon the communication, he has relied upon the letter dated 26th of November 2021 and 26th November 2021 and 10th of March 2026 and submit that there are dues against the petitioner and as such the bank has the civil recording has recorded as and as such the civil recording has been recorded. The score and civil score is recorded as 673 as on 27th of September 2020. Full stop. This court find that before passing any interim or police land counsel for the respondent has also SERI has also raised the point of maintainability. Full stop. Land counsel for the bank civil submit that unless and until the civil will receive the information from the bank, the civil will not be in a position to correct the civil record. Full stop. This could find that the SERI has relied upon certain documents which is to be brought on record by an affidavit. Accordingly, the respondent number 1 is directed to file the report by way of an affidavit. How soon? 1 week?
Well,
Within
2 weeks, not
2 weeks, they are asking for the interim.
Make it 10 days.
Within 10 days, after serving the corporative and counsel for the liberty to take exception to the report within a week. Within a week, list the matter on on 27th of August 2026 at the top as urgent motion. Lordship has been fixed to fix a time. Yes. No, as at the top, urgent motion. At top, okay. The interim order will be considered after filing the report by the SERI. Deeply obliged.
Your Lordship, sorry. Your Lordship has kept the question of maintainability open.
I recorded.
Your Lordship, the item matter is appearing as item number 5, but it could not reach. Your Lordship may kindly retain the position.